is continuing the consideration of committee business. Today's just a few things in case we get rusty, since we haven't been at this for a while. Today's meeting is taking place by video conference, and the proceedings will be televised and made available via the House of Commons website. Just to mention a few rules. Interpretation will work much like a regular meeting. You have the choice of floor, English, or French. It's critical for the best sound for those doing the translation, the interpretation, for members to wear their headsets. If you plan to alternate from one language to the other, you do need to also switch the interpretation channel to the language you are speaking. And it may be best to pause briefly when you're switching over to give the translators time to catch up. I know all members knew these points in the spring, but as a refresher, all comments should be addressed through the chair. Should members need to request the floor outside of their designated time for questions or comments, they should activate their mic and state they have a point of order. If a member wishes to intervene on a point of order that has been raised by another member, they should use the raised hand function. That will signal to the chair and the clerk of your interest to speak. In order to do so, and Ms. Jansen just gave me a little education on this, you should click participants at the bottom of the screen. When the list pops up, you will see next to your name that you click raise hand. Please mute your mic when not speaking. If technical problems arise, like audio, translation, or other, just please advise me, and we will wait until that is solved. Now, if I could turn to the suspension of the meeting. You will, and I know there is some confusion over this. You will recall I stated on Mr. Poilievre's point of privilege that there was a procedural technicality with his point and the motion following his point. We suspended for a few minutes, and I did not get complete clarity on really what is an unusual development to a great extent related to the fact that this is a new session of Parliament, and I'll get to that in a moment. The meeting was not adjourned, as some implied, but it was suspended by the chair. And I just want to turn to House of Commons Procedure and Practice, 3rd edition, page 1098. Committees, quoting, committees frequently suspend their meeting for various reasons. With the intention to resume later in the day, suspensions may last a few seconds, several hours, or span even more than one day, end of quote. On the question of privilege, when there's some people have asked me, how can you interrupt a motion and go to another motion? So I'll read when a question, when you're discussing a motion, the question of privilege does take precedent, and the chair has an obligation to deal with that. The chair, under parliamentary procedure, must hear the point, and I'll turn again to House of Commons Procedure and Practice, 3rd edition, page 1060. If a member wishes to raise a question of privilege during a committee meeting, or an incident arises in connection with the committee's proceedings that may constitute a breach of privilege, the committee chair allows the member to explain the situation. The chair determines whether the question raised in fact relates to parliamentary privilege. If the chair determines that the question does relate to parliamentary privilege, the committee may then consider presenting a report on the question to the House. The report should clearly describe the situation, summarize the facts, provide the names of the people involved if applicable, state that there may be a breach of privilege and ask the House to take such measures as it deems appropriate. Ordinarily, a presentation of a report to the House is a prerequisite for any question of privilege arising from the proceedings of committee. Mr. Fraser did raise a point from parliamentary procedures during the discussion, but he didn't challenge the chair on that point. Not in the rules, but running through my mind at the time was the problem where a point of privilege could be used to jump the queue on motions. You'll recall at the beginning of the meeting, I had stated that the order of motions would be Ms. Zerowitz, motion on pre-budget consultations. And we operate under a standing order of Parliament there that we must do those in the fall and report by December. That's an obligation for the committee. I had spoken with Mr. Julian and I told him I would have his motion dealt with in second at the committee as the proposals came forward. And his motion was on privilege and documents as well. And Mr. Poilievre's staff emailed me to say that Mr. Poilievre would be putting a motion. They didn't say a point of privilege. Although that was that was the way the motions had came to me. My thinking was to get to the pre-budget consultations in process, so that our staff, the clerks, and others could start the process, line up witnesses and meetings while we continue to discuss these other issues. And finally, why the motion I said was there was a problem, a technical procedural problem, really relates to that we're in session 2 of the 43rd Parliament, and there was prorogation on session 1. On prorogation, the House of Commons Procedure and Practice, 3rd edition, page 975 and 6 reads, as soon as Parliament is prorogued, parliamentary committees, with certain exceptions, lose their orders of reference, mandates, powers, and members, and all studies undertaken by committees lapses, end of quote. Resuming also in House of Commons Procedure and Practice, 3rd edition, page 977, resuming under the topic, resuming proceedings in a new session. Standing and joint committees that wish to resume a study they intend it themselves can do so by adopting a motion to this effect. Quote, if occasion arises and they consider it appropriate, committees that have the power to do so may readopt orders for the appearance of witnesses or the production of papers. It is quite common for the House or committee to adopt an order stating that evidence heard and papers received in a preceding parliamentary session be taken into consideration in the new session, and end of quote. So that leaves us with the current motion from Mr. Poilievre on his point of privilege. It does technically not have the evidence to make his point because the evidence, there isn't a motion in it, and there hasn't been a motion to bring that evidence forward from the previous session. Therefore, the speaker could kick it back to us and say that the evidence isn't there. I see Mr. Julian shaking his head, but that's the facts of the matter. We all know, those of us that are on the committee, what it means. But technically, that's where we're at. So I'm going to go with a couple of options here. I'm going to rule the current motion as written out of order and ask Mr. Polyev to bring it in order by dealing by putting an amendment or bringing it back with the proposal to bring forward that evidence from the previous committee. So I would rule it out of order. I would rule it out of order as written, and so I think the options are these. Mr. Polyev can take the motion back, sit in position 3, and we'll go back to where we were at on Ms. Zirowitz's motion first, and then come through the line and deal with his motion as amended. He could challenge into the ruling of the chair, and we'll see where that goes, and we would have to deal with it in that respect then. So I'll give members a moment to think about that. As I said, as written, I have to rule it out of order. It can be fixed, and would suggest to Mr. Polyev bring it back later in the meeting.
Point of order, Mr. Chair?
Yeah, go ahead.
So I would simply, given that I continue to have the floor, as I had the floor when you suspended the meeting, you've now suggested an amendment. I have accepted that suggestion, and therefore the evidence that you have required is considered amended into the motion. And so we can continue taking a speaking list on that premise.
If we get there, the next one.
No, I do. Sorry, I do have
just
the
hold
chair.
on. No, you don't.
Motion to challenge the chair. Motion to challenge the chair.
Good.
Motion to challenge the chair.
That's fine. That's what I was going to suggest. You had to challenge the chair to go that way.
So
not challenge the chair. Challenge the ruling of the chair. And I'll ask the clerk to take a vote on the ruling of the chair. Madam Clerk.
Okay. Shall the chair's decision be sustained?
No.
Mr. Fraser.
Yes.
Ms. Jarowicz.
Yes.
Mr. Fragiskatos.
Yes.
Mr. Gerritsen.
Yes.
Ms. Koutrakis.
Yes.
Mr. Polyev.
No.
Mr. Falk.
No.
Ms. Jansen.
No.
Mr. Kelly.
No.
Monsieur Sainte-Marie.
No.
Mr. Julian.
And no.
Mr. Chair, we have 5 yeas, 6 nays.
No, I think it's the other way around. I think you have 5 nays and 5 and 6. Yeah, that's right. Okay, the ruling of the chair is overturned, and that makes me procedural happy that we're back in procedure. Mr. Polyev, the next speaker on the list was Miss Jansen. I think we were going to her, but I do believe you had the floor, and you should also move the appropriate amendment at the appropriate time when you get a chance. Floor is yours.
Thank you very much, Mr. Chair. If there is any confusion about what documents the committee is referring to, I am going to have my staff send a specific reference to the clerk electronically, and we will give that body of evidence an official name that is identifiable and recognized by the committee, so that there is no confusion about the documents in question. As you know, Mr. Chair, committees can receive evidence a variety of ways. Sometimes it's through documentary submission, sometimes it's through testimony, and sometimes it's just through acknowledgement of what's happening in the world. So, for example, a committee can publish a report and include in that report observations made from what's in the public realm. It doesn't actually have to be formally submitted in the process of the committee for the committee to be aware of its existence. So I will make sure that you have reference to the documents. As you correctly pointed out, we all know which documents we're referring to. We all know which documents we're referring to. So on that basis, we will clarify. And I now cede the floor to Ms. Jansen, who I believe is next on your list.
Could we before you start, Ms. Jansen? Could I have people? We'll establish a speaking order here, and so you can click on your speaking order as we roll along here, and the clerk can notify me who's next, maybe by email. So, Ms. Jansen, the floor is yours.
Yes, what I was trying to say, I was very concerned about the fact that this exact process happened at the Health Committee. We made the exact same type of request. We wanted to get documents that were unredacted and then would move to the law clerk for redaction. When we received those, what we actually got were, again, documents that had been redacted by staff that had so much missing. It's how do we as parliamentarians do our job if and the interesting part about that as well was the fact that the argument against originally getting any of the documents was that the staff in a pandemic were incredibly busy, too busy to collect up documents for the committee. So when we saw that the staff then had been tasked with not just collecting the documents, but also redacting them, we were very shocked. And to have seen the way that these documents were redacted for this committee was absolutely shocking. I mean, it's almost like you did it in health and then you doubled down in finance. So I would say, again, last week when I was speaking and I was interrupted, I was shocked again by the process. I think that I've been elected to come to this place and to serve the citizens in my riding. And again, shocking to see how we are cut off. The information is not given. We're basically told, sorry, you have to stop. You have to stop. We're done here. So at this point in time, I think I'm going to yield the floor for the time being because I'm trying to wrap my mind around how it is that we find ourselves in a place like this, and our inability to actually be able to see any of the information is very shocking. So I yield the floor to my colleague, Mr. Polyev.
I think Mr. Polyev is not next on the list. The next on the list is my list thus far is Mr. Julian first, followed by Mr. Fraser. And I do hope that people have Mr. Polyev's motion in front of them, or if you don't, notify the clerk, and she can certainly see that you get a copy of that motion. So, Mr. Julian, the floor is yours.
Thank you, Mr. Chair, and I appreciate the committee ruling the way they did. I simply disagree with the ruling that you gave, Mr. Chair. With respect, I find you largely fair in what is often a difficult environment, but the reality is there is no doubt this is a breach of privilege. And given that every single member of this committee voted for the NDP motion in July, asking for the documents, every single member should be supporting this motion of privilege. If the committee had ruled otherwise, if the committee had upheld your decision, Mr. Chair, as you know, I had a privilege motion as well that had been vetted by the table, and I would have brought that forward. So that would have, we simply can't sweep this under the carpet. We have to deal with this. We have to pass this for many reasons. The fact that it is outrageous that over 1,000 pages of documents that we asked for were wholly or substantially redacted. In other words, censored, so that a committee, in a democratic parliament, has actually been denied access to information that the committee has requested. It's pretty outrageous, and that's why the motion of privilege is so important. Secondly, the fact that every single member of this committee agreed to the motion means that we have a duty to uphold the responsibilities that come from making that decision as a committee. And thirdly, Mr. Chair, the Speaker has asked us to bring a report back. And this is something that we cited a few days ago, but bears repeating. The reality is when the Speaker ruled, he said that the Committee of Finance has the ability to rule and bring this back to the House of Commons. For the moment, he is not able to rule when this was raised in the House of Commons prior to the committee being reconstituted, because he said it's not possible at this point to know whether the committee is satisfied with these documents as provided to us. And so the Speaker says, I don't know whether or not the committee actually agrees with the substantial censorship that took place. We have a duty as a committee to report back and clarify for the Speaker that we are not satisfied with over 1,000 pages being substantially or wholly censored. And so we have that responsibility to pass this motion and to move on. I believe firmly, Mr. Chair, that the Speaker will see this as a clear violation of privilege, and we have a responsibility to move forward quickly on this. I hope to my Liberal colleagues who seem to want to delay a decision on this matter last week, that they will move promptly so we can have a vote and refer the proper report to the Speaker so that the Speaker can make the ruling and the House of Commons can make the decision about privilege. This is an important matter. We shouldn't be spending a lot of time on it. We should be moving forward. Thanks, Mr. Chair.
Sorry, Rusty, myself, I was muted. Following Mr. Julian, Mr. Fraser will be followed by Mr. Garrettson, then Mr. Kelly.
Point of order, just the hands have to be removed again as well once you're finished speaking. So normally the Speaker can do it themselves.
Okay, thank you. I don't think I can I? I'm not sure. So good. Yeah, Mr. Julian removed his. Mr. Fraser followed by Mr. Garrettson and then followed by Mr. Kelly.
Thank you, Mr. Chair. Your suggestion that we should have the clerk circulate the motion, I think it would be helpful. I don't have the written copy of Mr. Poilievre's motion in front of me. So, Madam Clerk, if you wouldn't mind circulating that, that would be helpful. One of the things that I wanted to raise is, and Mr. Chair, you got into this during the onset of your remarks, was the nature in which the various points were made and the order that we've been dealing with things in. Obviously, the first motion on the table was that for Ms. Arowitz to move forward with pre-budget consultations, which will be required to table a report on should we choose to do pre-budget consultations several sitting days before the House rises. So there is an urgency to it. In my view, and respectfully, I think there are committee members who take a different point of view. Mr. Poilievre's point of order, in my opinion, was an attempt to jump the line in order to have this matter dealt with in advance of Ms. Arowitz. So you correctly pointed out that a point of privilege would take precedence in the order of discussion. There's 2 points that I'll make, and the first quickly because we got into it during our last meeting, and the second I'll try to flesh out a little. The first really touches upon the.
Before I hate to interrupt, Mr. Fraser, but Mr. Falk, your mic is open in case somebody comes in the room yelling at you or something there. It's open on my end anyway. Okay. Just muted.
I think I have it muted on my device here.
Okay, good, great, thanks. Go ahead, Mr. Fraser.
Certainly, and look, if anybody walked into to Ted's office, I don't think they'd be yelling at him. It's quite all right. So look, the first point is just to reiterate the issue around whether there is in fact an issue of privilege to be dealt with. My view, and upon reading the section immediately following the portion you quoted of Boston Gagnon, is that because the committee has the ability to deal with this grievance or issue in another way, namely by reaching out to the government and saying, we're not satisfied, we can do this a different way. I think we have the ability to deal with it that way, which would not make it a point of privilege, but instead an ordinary motion of the committee or a point of debate or grievance, which would forego the possibility of this committee hearing a point of privilege. However, if I am incorrect on that particular issue, I don't view this to be a violation of the committee's privilege. There may be issues with the disclosure of documents we want to prod further into, but following the adoption of the motion at Finance Committee, this is the July motion that gained, to Mr. Julian's point, significant support from all parties. Public servants got together to work really hard to gather relevant documents. They provided the committee with literally thousands of pages. The motion adopted by the committee stipulated that, quote, matters of cabinet confidence and national security be excluded from the request, semicolon, and that any redactions necessary, including to protect the privacy of Canadian citizens and permanent residents whose names and personal information may be included in the documents, as well as public servants who have been providing assistance on this matter, be made by the Office of the Law Clerk and Parliamentary Counsel of the House of Commons. I'll get into later into who was responsible for dealing with which aspect. Exemptions were in this instance applied by our professional and nonpartisan public service. The deputies at ESDC stated in their transmittal letter that the approach adopted was to disclose as much information as possible within the scope of the committee's motion. No exclusions were made on the grounds of national security. A substantial amount of information that would normally fall under cabinet confidence was provided to the committee in keeping with public disclosures made by members of the Queen's Privy's Council of Canada. Information that would fall under cabinet confidence but was not related to the Canada Student Service Grant request and therefore not relevant to the committee study, what was in fact withheld. This was reiterated in the transmittal letter sent to the committee by relevant deputy ministers. The motion clearly states that cabinet confidence should be excluded from the request. That's as clear as day in the way it's written. When I read the motion as it is written, it doesn't say that those particular exemptions should be made by the Law Clerk and Parliamentary Counsel of the House of Commons. The cabinet confidences were never in fact requested by this committee, so there would have been no duty upon the government to disclose them, which is obvious. I think we all want to protect cabinet confidences. As outlined in the other transmittal letters to this committee, departments are obliged to protect personal information under the Privacy Act unless the individuals to whom that information relates consent to its disclosure, or disclosure is otherwise authorized in certain specified circumstances, or the public interest in disclosure clearly outweighs any resulting invasion of privacy. Information that would have constituted personal information was released in certain instances when these documents were disclosed, where it was determined, including by the Clerk of the Privy Council, that the public interest outweighed the invasion of privacy. The clerk also made the decision, as was communicated in his transmittal letter, that personal information in certain instances, such as the name of a public servant's family members and the phone numbers of employees at WE who were not Craig or Mark Kielberger, that the public interest did not in fact outweigh the invasion of privacy in those circumstances. The Deputy Minister of Finance, for his part, noted that the type of personal information that remains protected consists of the identity of unrelated third parties where their opinion or view related to an unrelated matter to the committee's inquiry, as well as personal email addresses and phone numbers. The Deputy Minister went on to note that with respect to pages 190 and 194 through 213, further to consultation with the originating stakeholder, authorization to disclose this information was not given, as it constitutes personal information as defined under the Privacy Act. Further, this information is considered proprietary to the third party. The contents of that particular information was not relevant to the funding agreement or the student grant program. Therefore, it has been severed in its entirety. And that's a quote. That's not my interpretation. Additionally, the transmittal letters from the Clerk of the Privy Council and Department of Employment and Social Development note a limited waiver of solicitor-client privilege was issued because they believed it was in the public interest to do so. The question of parliamentary privilege is not a black and white question. Committees, no doubt, can request what documents they wish, but they can't compel their disclosure. The public servants who have custody of these documents have a duty to hold in confidence some of the information that comes into their possession in the course of their duties. There's legislation that binds them. As outlined in the document Open and Accountable Government, there's a natural tension that exists between the obligation and the request of parliamentarians for disclosure of that same information that the public service feels the need to protect. They further note in that document that in practice, officials should endeavor to work with members of parliament to find ways to respond to legitimate requests for information within the limitations placed on them. This comes back to my earlier point that I think we can engage in a conversation with government rather than jumping to a question of privilege before the House. Members of the committee should also note that in 2010, the previous government reaffirmed the long-standing principle from 1973 governing the production of documents as part of their response to a report to the Public Accounts Committee at the time. Those principles include criteria under which documents should be exempt from production, which of course include cabinet confidence or cabinet documents, and those that include Privy Council confidence. Cabinet confidentiality, for what it's worth, is not some label you stick on something to prevent disclosure of documents. It's fundamental to our system of parliamentary democracy. It allows ministers to have candid conversations and when appropriate, to shift their minds and be persuaded by others. It's essential that these deliberations remain private, and that's recognized by the Privy Councillor's oath. The Supreme Court of Canada has affirmed the importance of cabinet confidentiality. In fact, the court noted that judicial independence, parliamentary privilege, and cabinet confidentiality all contribute to the ability of each branch of government to perform its respective role without undue influence. It's a natural tension. On personal information, while parliamentarians are not subject to the Privacy Act restrictions, it does apply to the government institutions from which the committee sought information. This also creates tension. Providing unredacted personal information, even to the law clerk, would consist of a disclosure under the relevant legislation. As such, it requires the care and attention afforded to it by public servants. This personal information might lawfully be disclosed under certain scenarios, including when the individual at issue authorizes the release of the information and when the public interest clearly outweighs the privacy implications, as was the case as referenced previously in this instance. Additionally, the information could be released for the purpose of complying with an order by a body with the jurisdiction to compel that information. But we've made pretty clear previously, and I think everyone would agree, that a House committee doesn't have such jurisdiction, so it doesn't fall into that scenario. With all of this in mind, I find it's important to note that the committee's motion asks the law clerk to make redactions in relation to information about public servants above and beyond what the government in fact made. These are redactions officials did not make and would not have made in accordance with the Access to Information Act. Despite what's being suggested, this isn't a breach of our privileges as committee members. The opposition seems to be claiming that the only option in front of this committee right now is to report the matter to the House. With great respect, I don't view that to be correct. The committee has not yet asked the government for information that public servants applied exemptions to and that are outlined above in the remarks I've just given under very narrow and specific grounds. For example, if the committee members of the committee want information pertaining to family members of public servants, they could ask, but we haven't done that as a committee. Parliamentary privilege in no way, shape, or form absolves the government of its obligations to protect personal information and cabinet confidences. And in fact, the motion that we've put forward specifically excluded a request for cabinet documents. Despite this, the public service made a serious effort, I'd say a sincere effort as well, to provide as much information as possible. In light of this information and the examples I've used, this doesn't appear to be a breach of privilege, let alone raise a matter of privilege at all, Mr. Chair. Thank you.
Mr. Chair,
sorry, yeah, I'm muted. Thank you, Mr. Fraser. Turning then to Mr. Garrettson. Next up will be Mr. Kelly.
Thank you very much, Mr. Chair, for the opportunity to speak. I have a lot to talk about when it comes to this motion specifically, and I have quite a bit to offer. I'm really interested in hearing what some of the other members have to say before commenting on that. So I guess defer to talking about that until a little bit later. What I really wanted to talk about right now, Mr. Chair, was what we just witnessed, and that was a challenge of the chair and a successful challenge of a ruling from the chair. And to start with, Mr. Chair, I believe that you handled that in an extremely fair way. Not only did you point out the problems with the ruling that no doubt came from discussions that you had offline with clerks and people who understand the rules even better than somebody like yourself who's been around for a long time. I mean that with all due respect. But the reality of the situation is that you didn't just make a ruling, you also provided an avenue for how the motion could be corrected. And I find it extremely troublesome that we are now on the second time in a committee where members of the opposition are not happy with the outcome and decide that that constitutes challenging the chair. It does a massive disgrace to the institution that we have, the procedures that we have, the parliamentary establishment from where we've come. I saw Mr. Julian shaking his head the entire time that you were making that ruling. But then when Mr. Julian went to speak, Mr. Chair, he didn't once address a procedural problem with your ruling. In fact, he just went on to say why the motion was important to pass. Fair enough. And Mr. Chair, you gave an avenue as to where we could get to in order to put the motion in order. Mr. Julian should have taken the lead of Ms. Blaney in the PROC committee the other time that a challenge has occurred, where she too had a difficult problem in terms of wanting to see the motion pass, but understood that the content of it was out of order. It's unfortunate, Mr. Chair, that Mr. Julian could not bring himself to see the same way as Ms. Blaney did. And, you know...
Point of order, Mr. Chair.
Point of order, Mr. Julian.
The personal attacks are absolutely inappropriate, and the members should know that I am well versed in parliamentary procedure, and I simply disagree both with his comments, but also with your ruling.
Mr. Chair? I think that's basically a debate. Who was it? Mr. Fragiskatis?
That's right, Mr. Chair. I failed to see how the point raised by Mr. Gerritsen constitutes an attack, a personal attack. If we can't engage freely in debate here,
I think both your point, Mr. Fragiskatis, and Mr. Julian's are not real points of order. I'll go back to Mr. Gerritsen.
Thank you, Mr. Chair.
Debate.
And I do want to take the opportunity, if I offended Mr. Julian, and I can understand how he would be offended on that, because there's probably a little bit of truth to what I'm saying that's getting to him, and he feels the need to lash out against that. I understand that. But Mr. Julian perhaps should have consulted a little bit more and thought about this a little bit. Or when it was his turn to speak to it, Mr. Chair, he could have actually taken the time to tell us why he thought it was procedurally incorrect. He didn't, Mr. Chair. All he did was tell us why the motion was so important to pass. And that's why I started this off, Mr. Chair, with my introductory comment by saying that you did an incredible job as a chair of not only ruling it out of order, you could have just left it there, but you provided a path and an avenue to make this motion in order. And rather than take you up on that offer, which would have been extremely easy to do, the opposition members of this committee chose to instead use it as an opportunity to overturn your ruling. And in my opinion, Mr. Chair, that shows a fundamental lack of understanding of the importance of a chair's position and what a chair is supposed to do, much like the speaker. They're getting their information, they're making a ruling based on where procedurally
things are deemed to be correct and incorrect. And Ms. Blaney was able to see that in the PROC committee. Now, she did take a lot of heat for that in the media. And I imagine that Mr. Julian was concerned about the same thing. He was worried even if it is procedurally correct, if I go down this road, I'll end up looking like I'm trying to support a cover-up or something like that. So I understand politically why he did it. It makes perfect sense, but it's extremely disappointing to see not just Mr. Julian. I know I'm picking on him a little bit now, and I don't want to hurt his feelings because I clearly did a few minutes ago, but all members of opposing parties here would use the opportunity to challenge the chair to advance a political objective. And that's exactly what they did. And it's extremely discouraging to see that. Most members know, I've only been a member of parliament for about 6 years now. But before that, I was involved with our city council here in Kingston. I was a city councilor and I was the mayor. I was on both at times in the position of having to vote on a challenge of the chair and on the receiving end of being challenged. And I can honestly say that I cannot remember a time when there was a challenge that was successful, because at the end of the day, most members understood that the chair's job is to use the information that they receive and the advice that they receive from their clerks in order to make the best decision on behalf of the committee. And what we see today is all members of the opposition, despite the fact that the chair laid out the reasons very clearly and the chair provided an avenue and a path to make it procedurally correct, everybody still voted to dismiss the chair's ruling because they're motivated purely from a political agenda. So, I mean, I don't know if we're going to see more of this. Quite frankly, I don't know if it is indicative of parliamentary process that this happens quite a bit. This is my first time being in a minority parliament situation where I'm actually getting to see this unfold. But I can say in all my years of being involved in politics and sitting around not-for-profit boards and committees and council tables, I've never seen people use a challenge of the chair in such a politically motivated way, especially when you have a chair that takes the opportunity to not only explain in detail, but also provide avenues and paths to get out of this later on. So, Mr. Chair, like I said at the outset, and I have a lot more to say on this. There's a great deal to be discussed in this, and I will definitely come back to it. But at this time, I just really wanted to address this point, and I really find it to be discouraging to see members do this, especially after being on the PROC committee. I witnessed the NDP standing up for the parliamentary procedure, the way that chairs are supposed to engage, and the way that procedure is supposed to be interpreted, not using procedure for political motives. Thank you, Mr. Chair.
Thank you, Mr. Garrison. Mr. Kelly, the floor is yours, followed by Mr. Fragaskatis. Mr. Kelly, and you're muted.
Well, thank you, Mr. Chair. I just wanted to, some interesting comments from both of the last two speakers, and the curious part here is I noted Mr. Fraser pointed out the urgency of getting on to the business of Ms. Zerowitz's motion, which nobody denied the fundamental role of this committee on pre-budget consultation, and so we do wish to get to that. And it's curious that in the last meeting we listened to lengthy filibuster speeches from the other side, which had the effect of delaying getting to this other business. So it really was a bit thick, I think, coming from the governing party members on the committee to suggest that it's the opposition that doesn't want to to move on to those pieces. It's important business that we need to get to. And I noted in Mr. Gerritson's speech that it was just I did note that he it was sort of his words that to support the motion of the chair might have made one look like they were participating in a cover-up. His words to describe what's at play here. But to the point, and your ruling, Mr. Chair, on this, I am prepared now to make I think fulfill the remedy that you had proposed to us, and so I will move an amendment to Mr. Poilievre's motion, and move that the motion be amended by adding, after the word "that," where it first appears, the following: the evidence heard and papers received by the committee during its study on government spending, and the Canada Student Service Grant during the first session of the 43rd Parliament be taken into consideration by the committee during the current session and accordingly. So if we make that change, we should bring us into order per your ruling. And so I move that amendment, and I understand that the clerks likely have that. The clerks likely have that from us.
Okay. Point of order. The amendment is in order. Mr. Kelly, point of order from Mr. Fragiskatis.
Could he clarify? Could Mr. Kelly clarify? He said, beginning from the word "that," which paragraph is he talking about? Could he be more specific about where he's looking?
I'm sorry, I might need a moment to put these together. I'm looking in different screens right now.
The paragraph and the line, please.
Okay. The motion be amended by adding, after the word "that." I'll need a moment to place that.
Okay, take the moment, Pat.
Where it first appears, it's the first "that."
Oh, I get it.
Can you repeat that one more time? Sorry.
Where it first appears. The motion be added after the word "that," the first "that" in the motion.
It's a long, with due respect, Mr. Kelly and Mr. Chair, it's a long motion, and therefore we would need...
First paragraph, where it first appears.
Thank you.
Point of order?
So, just who was the point of order? Mr. Gerritsen, go ahead.
Mr. Chair, I just want to know, so if we're on an amendment now, are you going to take the existing speakers list?
No, I'm going
and then start a new list? How does that work?
I will have to work from a new list on the amendments and then come back, and I might remind Mr. Gerritsen, is your hand up for a new time?
Thank you for the reminder. I'll take that down. Sorry about that.
Okay. And then if people can take them down and put them up, I will need a new list for the amendment. Mr. Kelly, is this in the first line, that the chair be instructed to present the following report to the House forthwith, provided that the amendment goes in there?
Yes.
Okay.
Mr. Chair, point of order?
Yeah. Just a question for, okay, I'll go to the point of order. Mr. Fragiskatis.
Looking for certainty here as to whether or not a French text has been provided.
I'll have to ask the clerk on that. Madam Clerk, have you, I think Mr. Poilievre's office is sending you the amendment, hoping both official languages. Do we have that as yet?
Yes, we received it in English. I'm just turning it into French. And
on the amendment?
On the amendment itself, yes.
Okay, if you could get that to members as soon as possible. That it for your point of order, Mr. Fragiskatis?
Excuse me, Mr. Chair, could you repeat that? You didn't come through clearly.
Is that it for your point of order?
That answers the question that I did have. Thank you.
Okay, and the amendment is on the first line, at least in the English text, provided that the amendment there would go in at that point.
Point of order, Mr. Chair.
Ms. Katrakis.
When will the committee receive the documents if this motion is passed in their digital binders? And will committee members be given time to review the documents to see if they do in fact meet the original production order?
I think I don't see that as a point of order at this time, but I think it's a sensible question to ask maybe the clerks and the parliamentary procedure people at some point. I know what Mr. Poilievre's motion states in various places in terms of times. We need to make sure that from the parliamentary procedure people that is in fact doable. So I think it's a legitimate question at some point in time to either to someone. I'm not even sure who. I guess the parliamentary procedure people. Okay, is there anybody who wants to speak on the amendment, Mr. Kelly?
If I may, I want to be clear. It's when you repeated the motion, I'm not sure you got it in the first place. It's where the first so you insert that, and then the amendment follows. The evidence heard and papers received by the committee during the study on spending and the Canada Student Service Grant during the first session of the 43rd Parliament be taken into consideration by the committee during the current session, and accordingly, the chair be instructed to present, and goes on from there.
Okay, I did say it in the wrong place.
Mr. Chair, point of order, can you just read the whole paragraph, please, with that amendment included, just so I could make sure that I've got it right? I'm so sorry, but I want to make sure that I have it right.
Pat, Mr. Kelly, if you could do that please. On the motion, if you could, perhaps Mr. Kelly, count the paragraphs down on the motion. What paragraph it is in?
You had it right, Mr. Chair. It's in the first paragraph.
Okay. So if you could read that whole paragraph with the amendment in, that might solve our problem.
Well, I'm having trouble myself juggling with this, Mr. Chair, but you've got it correctly, and I think the clerk has it, and perhaps the clerk can, if there's any questions about that, they can go through the clerk.
Okay, but you do have the wording.
Point of order, Mr. Chair.
Yeah, go ahead, Mr. Fragaskatis.
Mr. Kelly is a new member and one I have a sincere respect for, but I think he knows better than to ask the clerk for clarification on his proposed amendments. He was asked a very clear question to read the amendment that he's put forward, and it is Mr. Kelly's amendment, and therefore I think we need to hear from, we need certainty and clarity from Mr. Kelly. To put the clerk in what would be a political position would be grossly unfair and very inappropriate.
That's not what I'm.
Point of order.
Who's point of order? Okay, Mr. Julian.
I do think it's reasonable to have the entire paragraph read out. It is absolutely normal that we ask the clerk to do that. That's as long as I've been in Parliament, we ask the clerks to make sure that the table has the correct amendment in the correct place. So having the clerk read out that paragraph, I think, is absolutely legitimate. So we can all note it and write it down. But it is something that we normally ask of the clerk.
That is fine. Madam Clerk, are you in a position at this time to be able to read the whole paragraph with the amendment in?
Point of order, Mr. Chair.
Mr. Falk, go ahead.
I'd be prepared to read it into the record.
Okay. then we'll go to Mr. Falk, and then we'll come back to the clerk if she has anything to add. Mr. Falk, go ahead.
Okay. The first paragraph will now read that the evidence heard and papers received by the committee during its study on government spending, we and the Canada Student Service Grant during the first session of the 43rd Parliament be taken into consideration by the committee during the current session, and accordingly, the chair be instructed to present the following report to the House forthwith, provided that dissenting or supplementary options pursuant to Standing Order 108 subsection 1 subsection B shall be filed with the clerk of the committee within 24 hours of adoption of this motion. And that, sir, would be the first paragraph.
Okay. Then thank you. I think that's very clear.
Point of order, Mr. Chair.
Point of order there, Mr. Fragaskatis.
And I don't mean to continue to raise points of order. I do so simply because I've noticed, I do so whenever I notice something important that arises that needs rectification, let's put it that way. This is a bilingual country. The federal government operates in a bilingual fashion. This is an important issue, and I think that we need to hear, as a committee, the amendment read in French as well.
Okay, can somebody read the amendment in French, or do we have it? I don't see Mr. St. Marie. Maybe there he is. There he is. Okay, could we have the amendment read in French? Mr. St. Marie, do you want to read?
Point of order. Point of order.
Okay.
Point of
I'll have
order,
to go
Mr.
to Ms. Koutrakis first, and then I think it was Mr. Kelly. Ms. Koutrakis?
Yeah, with all due respect to my colleague, Mr. St. Marie, this is a conservative motion, and not the block. So I think it would be more appropriate that the French translated motion be read by one of the conservative members.
Okay, Mr.
Point of.
I'll go to Mr. Kelly first, and then Mr. St. Marie.
This motion was made at a committee, and a motion may be made in either official language. I did make the motion in English, and Mr. Fragaskatis is absolutely correct. We must ensure that all members.
There's a point of order on the floor.
Yeah.
Go ahead, Mr. Kelly.
Well, it's a point of order to what Mr. Kelly is saying.
Okay, then, but if I may continue.
He has to finish his point of order first, and then I have Mr. St. Marie.
I trust that there was interpretation when I made the motion, and if the question to either Mr. St. Marie or anybody else on this committee is whether or not they received interpretation when this motion was made, then fair enough. But if I understand that interpretation was working and that my amendment was interpreted, then it was read. And I guess, we had it reread by Mr. Falk. This is again where I would ask either, a clerk or an interpreter if there was an interpretation problem to ensure that all members understand the motion. But this motion was made at the table. It's in order. And the interpretation service is there to ensure all members understand the motion.
Point of order.
Okay, I have. I'm not sure whether Mr. St. Marie was on a point of order or not. I'm taking the point of orders in order.
Point of order. Mr. Chair, I have some terrific news. I do have the French version here, and I understand the clerk's office is sharing it to everyone. So I gather that will make all members extremely happy. I'm happy to read it.
I'm going Mr. Polyev to Mr. St. Marie first because he was up first, then Mr. Fragaskatis, and then Mr. Garrison, and then you.
But just so you know, we do have the translation.
We hear you, Mr.
Everyone does. Everyone has the translation.
Mr. St. Marie's got the floor.
Merci, Monsieur le Président.
Yes, thank you, Mr. Chair. Indeed, I'd like to thank the interpretation service that does an extraordinary job. And in relation to what Mr. Poilievre just said, I'd like to remind members that the clerk sent us the amendment in both official languages by email, so we all have it. So I don't think it's necessary to read it out loud in French, especially since we already have it in both official languages in written form.
Mr.
Point of order, says Mr. Julian. Point of order.
Just a bunch of points of orders here. Next was Mr. Fragiskatis. I think Mr. Poilievre has made his point, and then Mr. Julian. Mr. Fragiskatis first, and then Mr. Julian.
Thank you, Mr. Chair. I meant what I said about Mr. Kelly earlier. I do remember when he served on the committee as a member. I remember pre-budget deliberations that were carried out a couple of years ago, traveling with him. I do have respect for him. I will overlook the fact, Mr. Chair, that he mispronounced my last name, and I hope his Greek constituents would extend the same courtesy. It's Fragiskatos. I'll leave that aside. Much more important is the fact that this committee ought to embrace bilingualism.
Okay,
Mr. Kelly, by running around and making technical arguments about what the interpreters said, doesn't suffice. It's surprising to me that the Conservatives have not.
That point's been made, Mr. Fragiskatis.
With the amendment in English.
I'm going to Mr. Julian. Peter?
Merci beaucoup, Monsieur le Président.
Thank you very much, Mr. Chairman. We're talking about a precedent that would be set, which would be very worrisome. If the Liberals are saying, well, an English-speaking motion has to read the same motion in French, well, then you're forcing Francophone members to read the same motion in English. That's not the principle of bilingualism. The principle of bilingualism is that we have interpretation, we have texts that are distributed so that everyone understands and is on the same page. It's very concerning when we see Liberal members who insist that when members are speaking in a language other than their mother tongue, well, that's not in line with the principle of bilingualism. It flies in the face of it, in fact, and it's very worrisome.
Okay, now we are back to the amendment. The discussion is on the amendment, and we will eventually get to a vote on the amendment. So, is there anyone to speak on the amendment? The only list I have is on the original motion.
So
is there anyone to speak on the amendment?
Well, point of order, Mr. Chair.
Yes, yep. I'll speak on the amendment.
Point of order first, and then Mr. Poilievre on the amendment.
So I'm just confused. Are we supposed to be raising our hands right now? Like the hands that are raised in Zoom, is that on the amendment or is that back on the main motion? And how are you expecting us to raise our hands for the amendment part when there are already hands raised for the motion part?
Unless Ms. Jansen knows more about this hand raised than me, the ones that are up are on the original motion. I will just take the hands as I see them. If you raise like this on the amendment. Okay. And first up on the amendment, I have Mr. Poilievre, and if somebody could give me a show of hands who wants to go next, we'll go with that. So Mr. Poilievre first, and then Mr. Fraser.
I think we want to listen to what he has to say first, and then we'll decide if we want.
Mr. Poilievre, and then Mr. Fraser on my list so far, and keep your hands up when you're putting them up, because I get a very small screen. Mr. Poilievre, on the amendment.
Yes, just in the spirit of Parliament and cooperation, we have assuaged your concerns, Mr. Chair. You have claimed that the committee does not know to which documents we are referring because those documents were submitted to the chair in a prior sitting of Parliament. That prorogation has erased our collective memories. So this amendment simply refreshes the memories of the official memory of committee. And so now we all remember those documents that you ruled were forgotten. So now, just to show how willing we are to cooperate and collaborate with Liberal members who are suffering from procedural and documentary amnesia, we are refreshing your memory, their memory, and the corporate memory of this committee. And therefore, I am proud to support this amendment, which makes it a friendly amendment.
Okay, that's your point. I will have to, Mr. Polyev, you didn't quite catch my ruling entirely. My concern is not about us who are on the committee. I don't think any of us have forgot. But when the original motion, if it got to the speaker, I expect what the speaker would do without the documentation there would look at me if I ran into him in the corridor and he'd say, "What are you folks doing on Finance Committee? You didn't provide me the documentation of which to make the point of privilege." That was my concern, not forgetting. But this gets to the speaker and then he has to rule. Go ahead.
And now everybody's memories have been refreshed and it's all clear what documents we're talking about. So I think we'll get unanimous support now for this newly amended motion.
I think we're on a roll. Mr. Fraser next. And who wants to come after him? Mr. Gerritsen. Okay, Mr. Fraser.
Thank you, Mr. Chair. It's perhaps a good segue, and this really builds upon the point that my colleague Ms. Katrakis made a few minutes ago. One of the things that I'm trying to figure out from a technical point of view, you initially ruled that we don't have the documents, but made the suggestion that could be remedied. We're now dealing with so as it stands officially now, I mean, the committee doesn't have documents in its custody, and that's the shortcoming that the proposed amendment seeks to remedy. When I see what's taking place with the motion from a very technical point of view, we're now being asked to adopt a series of documents into the evidentiary record and simultaneously pass judgment that we're not satisfied with them, more or less, and to move forward with the argument as it stands on a point of privilege. I'm curious, Mr. Chair, your opinion, or if you've taken advice on the clerk, whether we actually have the technical ability to do that. We're still, even having passed a motion, would be passing ultimately a main motion that would precede the adoption of the evidence on which the motion is based. That's a very roundabout way of saying I don't think including the amendment in the main motion solves the original problem of the committee still passing judgment on a series of documents that we technically don't have. I'm wondering if you could explain the workability of the proposed amendment, given the fact that we're still going to be in the same position that we faced at the outset of this meeting.
My objective is to chair the meeting and try and stay out of the discussion, but I did raise that point myself, whether there was whether the time frames within the motion could be met, and somebody maybe within the clerk's office may be able to answer that question. I do know, and I think all of us who were on the previous finance committee know that not quite all the documentation I don't think got uploaded to the digital binders before prorogation took place. It happened fairly shortly before prorogation, and that may be a problem, but it's a question that I can't answer, and I just put a flag on it because in the motion, when we bring those documents forward, in the motion, there's certain time frames within 24 hours of the adoption of this motion. I just want to raise a flag that may or may not be possible by the parliamentary people who deal with this issue, and I just don't want us blaming them if it doesn't get done within the 24 hours, because it may not be technically possible. That was why I raised the point. Back to you, Mr. Fraser. Mr. Gerritsen, I guess you're up. Mr. Fraser, go ahead.
Yeah, I guess what I'm still not clear on, and frankly, I wasn't expecting before Parliament resumed to revisit considerations of the government's compliance with the document production order that I was supportive of back in July, I'm going to find myself in a bind where we agree that everything gets adopted. Practically speaking, if I'm going to go through the documents and determine whether there has in fact been compliance with what the committee's asked for, I'm more or less being asked to pass judgment on the sufficiency of the redactions made for documents that I do in fact need an opportunity to revisit if this committee is going to both pass this amendment and the main motion. There's a further issue on the specific subject of the amendment. You mentioned just a moment ago that some of the upload of documents may have been interrupted by prorogation. I'm curious, I think the proposed amendment reads that the evidence heard and papers received by the committee, et cetera, and I'm curious if we can gain clarity on specifically how the interruption of any upload would be impacted if we're dealing with evidence heard and papers received.
I can't answer that question, you know, until this motion is either passed or lost, and we talk to the both the clerk of the committee and others who would be involved in terms of the documents that were uploaded in the last session. And where there might have been a shortcoming in terms of those documents been uploaded. I can't answer that question. So it'll be a bridge, I guess we have to cross. I understand your concern. I understand your concern on not having the ability to compare them, but it is an issue that I certainly as chair can't answer. I have to deal with what's before us. Mr. Fraser, do you want to add anything further? And then we'll go to Mr. Gerritsen.
Not at this time. I'll have you go to Mr. Gerritsen. I think that's fine. Thank you.
And I don't know if the clerk or the analysts have anything they can add on this. I would welcome their intervention if they want to intervene to give people clarity on the document upload or not. So Mr. Gerritsen, is there anybody else in the queue put their hand up on this amendment? The last one I see then at the moment before we go to the question is Mr. Gerritsen, but there's ample time to come forward if you want to speak. Mr. Gerritsen.
Thank you very much, Mr. Chair. I just want to say that it's reassuring to hear Mr. Poilievre speak of the spirit of collaboration right after challenging the chair. I would add that where we effectively ended up with this amendment is the advice that you gave to the committee at the beginning in terms of how this motion could have been done in a way that was procedurally correct. So for those procedural nerds that are paying close attention to this right now, what we've just witnessed is we've witnessed a full 180 from the committee. First, they challenged the ruling of the chair and were successful in that, all opposition members. And then they came back and basically did exactly what the chair was recommending that they do. So that would leave anybody watching this to conclude that the motive for challenging the chair was none other than a political motive to in some way have some vindictive purpose served in showing that they could challenge a ruling from the chair, which the very position of a chair is supposed to be extremely and completely nonpartisan, in which case I think, even to what Mr. Julian said earlier, this chair does a very good job of being fair. We've now seen this committee basically move an amendment, which is what we're talking to right now, which does exactly what this chair recommended doing in the beginning. Rather than take the ruling from the chair and then bring forward another motion, which is exactly what ended up happening through an amendment, the committee chose to overturn the ruling of the chair. And I think that that speaks volumes in terms of the political motive of the opposition on this committee using procedural tools to advance those political objectives. So I have no problem with the motion because the amendment, because the amendment seeks to do what the chair was suggesting we do at the outset. And that is to make sure that the documents that are required for this motion are brought over from the previous session of Parliament. And that's what we're seeing right now. And I think it's extremely important to point that out, because at the end of the day, what this really comes down to is this whole issue of we, the whole issue of we. It's about inflicting as much political damage as possible with a complete disregard for any collateral damage that might happen in the process, as long as it creates absolute political carnage around the Prime Minister and other members of Parliament, and as much as possible. That's really what this comes down to. And this amendment that we're seeing right now, which, by the way, was introduced, I believe it was by Mr. Kelly, but then suddenly Mr. Poilievre had the French version, and there was some confusion as to whether or not Mr. Kelly knew what the amendment was really even all about, and he was kind of like all over the place with it. And then Mr. Poilievre jumps in and says, "I have the French version right here," is just underscoring the fact that this is politically motivated. This entire charade right here is politically motivated. I see Mr. Julian shaking his head. And by the way, Mr. Julian, thank you for keeping your camera on when you're not speaking, unlike Mr. Poilievre that does the equivalent of hiding under the table in a committee room by shutting off his video as soon as he's done talking. I appreciate you at least staying on. It's always nice.
Point of order.
It's always nice to have the audience.
Sorry, Peter, I was muted. Point of order, Mr. Julian.
Mr. Chair, I'd ask you to, Mr. Gerritsen has the right to his opinions, but he needs to be treating all members of Parliament with respect. I find his comments immensely disrespectful, and he can make his point without personal insults or attacks.
Okay, point of order, Mr. Chair.
Point made. I didn't notice who the point. Was it Mr. Fragiskatis?
It was. I here too, and I made this comment earlier when Mr. Julian raised a point about personal attacks, which I disagreed with. I disagree here too. I think Mr. Gerritsen puts his finger on a very important issue. I see that Mr. Poilievre is missing. I see Mr. Kelly is thankfully back right at the right moment. But either way, I do want to remind all colleagues, Mr. Chair, that it is expected that we be on screen during virtual meetings. Let me quote directly from the Speaker, Mr. Chair. His findings ought to guide how we carry out business at the committee level. On September 24th, Speaker Rota said as follows: "Before we continue, I want to take this opportunity to remind honorable members, as we get into something new, that the members in the House have to stand to be recognized, which has been done for years. I would ask those at home to please turn on their cameras, those at home being members of Parliament, of course, to turn on their cameras well in advance and not wait until the last second. That is their way of standing up remotely. It makes it easier to deal with any technological problems that we may incur as we go on. Point of order. This applies to committees as well, Mr. Chair. It must.
You're next, Mr. Kelly.
It's interesting that Mr. Kelly has now chosen to join the meeting and offer an opinion through a point of order. But Mr. Poilievre is still missing. He's still missing, and all Liberal members have been here throughout.
Mr.
And I'll
Kelly,
give that courtesy to Mr. Julian as well and Mr. Saint-Marie. They've been here throughout. They have not disappeared.
Mr. Chair,
okay, Mr. Kelly.
First of all, this is debate. Secondly, I note that his singling me out for maybe 90 seconds or so of being off camera. Third, Mr. Gerritsen is way off topic. I ask you to keep members on order. Let's finish the debate on this and get to a vote on it.
Okay.
Okay.
I still have the floor, Mr.
Point on relevance. You still have the floor, Mr. Gerritsen.
Thank you. So I am actually extremely to the point, Mr. Kelly. If you had been paying attention, you would know that. I'm explaining why this amendment that you've put forward is problematic in the sense that you ruled against the chair when he offered to you to use this opportunity, to use an opportunity to accept his ruling and bring forward another motion that covered this. You challenged him. You won the challenge. And now you're coming back and bringing forward the exact same amendment. That points to nothing more than political motive in challenging a chair. The chair is there to exercise the procedure and to make sure procedure is followed in a committee and to use their best judgment in an impartial way. This chair, to Mr. Julian's point earlier, when he said it in his comments earlier, said this chair does a really good job of doing that. You didn't like the ruling and you challenged it. You don't challenge the chair because you don't like the ruling. You challenge the chair because you think that they've done something procedurally incorrect. And it is something, Mr. Kelly, that you and the rest of the opposition are not grasping.
Are we ready to?
Excuse me, I still have the floor if I think so. I have a lot to say, okay?
Okay. I was just going to ask, are we ready for the question? But
no, we're not ready for the question yet. I want to address Mr. Julian's point. I'm sorry if I'm coming across in a way that you're interpreting to be disrespectful. I have a lot of respect for you. You have served many years in the House, and I respect that. I respect when you get up. You and I probably see eye to eye on more issues than you realize when it comes to things like basic income and a lot of other issues. I'm sure that we do. But I think, respectfully, you're interpreting me explaining the situation clearly in a way that maybe is getting under your skin, but tell me I'm procedurally wrong. Tell me what I'm saying in and the way that I have addressed this is wrong. Like what I have just laid out exactly what happened. And I know, Mr. Chair. I know, Mr. Chair, that Mr.
Julian, I believe. Sorry, Mr. Gerritsen, Mr. Julian, on a point of order. I have to allow that.
Mr. Chair, your volume is very low. I'm not sure what the problem is, but just wanted to make you aware of that.
Here's the trouble. I had the mic up to take a drink of water. Mr. Julian, you have the floor on a point of order.
Thank you, Mr. Chair. Your ruling, of course, was that the motion of privilege be disallowed. The only way to actually get it to the amendment
point of order, Mr.
to
Chair.
override
he should put up his hand, Mr. Chair. He should put up his hand, and he should debate me. He has an opportunity to debate me. He knows this better than anybody on this committee with his vast experience. Maybe with the exception of you, Mr. Speaker. He knows that he's debating right now.
Mr. Gerritsen, order. I will determine whether it's a real point of order or not in a moment. But Mr. Julian, let's hear you.
Thank you, Mr. Chair. So by overruling your decision, this allowed for the amendment, which now Mr. Gerritsen says he supports. So let's have the vote.
Back to Mr. Gerritsen.
Well, I mean, if we want people to take your word, Mr. Julian, then at least raise a legitimate point of order. That wasn't a point of order. You were trying to respond to what I had to say. And you're doing it in a way, Mr. Julian, that you're just trying to throw one-liners out there. You know who does that a lot? Donald Trump. You know, somebody says something and he just goes, wrong. You don't have to justify what you had to actually say there. You're just throwing out things, saying wrong, and you're not actually justifying it. Get on the speakers list and tell me why I'm wrong. That's what I'd ultimately like to hear. But nonetheless, I just want to say, and what I had been saying before, multiple point of orders had been raised on me because apparently people are offended by the way that I talk to them, but we shouldn't take offense by what this committee witnessed towards the end of its last meeting before it was suspended. I am just trying to get at the point that the chair quite clearly laid out a path to putting forward a procedurally correct motion, and everybody or the majority turned that down, and then basically through this amendment, Mr. Kelly, that's how I'm addressing this point, through this amendment are trying to come back and basically do exactly what the chair said, but you ruled him out of order in the first place. And I just think that it's a slap to the parliamentary institution and the democratic procedure that we have, the manner in which opposition members, and not just Mr. Julian, all opposition members conducted themselves on this.
Okay, I do have, and I'm not sure whether you're in the main list or this list, Mr. Julian and Mr. Fraser. Mr. Julian, you're in the main list, I believe, are you? Originally? Your hand is up here. I'm just wondering whether you're on the amendment.
I'm on. Yes, I am, Mr. Chair.
Okay.
Thank you.
So I have Mr. Julian,
Mr. Chair.
Yeah, I have
it's
Mr.
Peter
Julian
Fregascatos.
first, and Mr. Fraser. And just to indicate to committee members, the clerk sent me a note in case anyone wants to have a look at it. The documents and evidence from the previous session are still on the Finance Committee's public website. I'm not 100% sure, Madam Clerk, whether that's all the documents were uploaded or not. But anyway, the documents and evidence are still on FINA's public website. The floor is yours, Mr. Julian, and then Mr. Fraser on the amendment.
Thank you very much, Mr. Chair. And again, for folks who might have listened to Mr. Gerritson's very wildly inaccurate interpretation of what's happened at the committee, as you know, Mr. Chair, you made an interpretation that did not allow us to amend the motion. That's why members of Parliament decided to overrule your decision, because otherwise we wouldn't have been able to amend it. We've now heard from a number of members of Parliament from all parties that they support the amendment. They now support the motion. So I think the logical conclusion is, rather than continuing this filibuster, which I think has been very unfortunate, particularly with the personal attacks that I've heard, I don't agree that that's appropriate. I think in any committee and in Parliament, we should be treating all members of Parliament with respect, even if we disagree. So given all of that, I call question, because obviously all members now agree with the amendment and agree with the motion, and we should proceed to the vote.
Point of order, Mr. Chair. Mr. Julian is assuming a lot.
I still have others on the list to speak, and I'm going to Mr. Fraser.
Thank you, Mr. Chair. I keep I don't want to sound like a broken record. I keep getting hung up on what evidence is actually before the committee. Look, maybe I'm stuck in my previous career as a litigator, but the evidence that actually makes it formally on the record is what can be considered. This amendment tries to adopt the evidence that was before this committee in the previous Parliament, and there is I have great difficulty around the subject of what evidence is actually before the committee, or what's purported to be before the committee after, should this amendment pass. I actually question whether it's in order, given the nature of the evidence that was actually placed on the record previous to prorogation, and frankly, if I'm going to be put in a position to pass judgment as to whether my privilege has been violated, or if the government has complied with an order of or document request rather from this committee, I think that ask in and of itself would violate the privilege of members who have not received all the documents, but nevertheless have to make a finding that the government did not comply with the order. So I'd ask for your guidance as to whether an amendment that contains such uncertainties is both properly in order, or is in and of itself a violation of privilege on the basis that we're going to be asked to make a finding about information we've not received.
Okay. Does that exhaust our list now, and can we go to the question?
And no, Mr. Chair.
Okay, Mr. Fregascatos.
Thank you, Mr. Chair. And I still notice that Mr. Poilievre is absent in contravention of what Speaker Rota made very clear to all of us on September 24th. But I'll overlook that in a spirit of cordiality, if you want to put it that way, or any other way that Mr. Poilievre was talking about earlier, but he's still not here. Mr. Chair, I think
that's because he's like Pokeroo. He just pops up every once in a while.
Point of order, Mr. Julian.
Point of order. Mr. Fragaskatos has a lot of experience, and he knows in the House as in committee, you cannot point out the absence or the presence of members of Parliament. And when we look at the Speaker's ruling that Mr. Fragaskatos does quote, that is for electronic voting. And I don't want the public to be misled by him trying to extend an interpretation on electronic voting to committee hearings or House hearings.
Point of order.
Mr. Gerritsen on a point of order, and then we'll be back to Mr. Fragaskatos on a speaking.
On the topic of trying to extend things from one area to another, Mr. Julian's doing the exact same thing by suggesting that you cannot point out somebody's absence in a committee. That is absolutely incorrect. You can call them by first name, as he just did, or by last name, as he just did with Mr. Fragaskatos. It is not the case, Mr. Chair, that you cannot point out somebody's absence. So, I mean, I'm certainly in favor of Polkaroo showing up again because he's been absent for a little while, and it'd be great to see him back on the screen.
I am going to, Mr. Gerritsen, tune you up a little bit because I don't believe we should call people names other than
he was a lovable character from my youth, from the polka dot door.
That may be true. Mr. Fragaskatos, your remarks.
Thank you very much, Mr. Chair. Again, I go back to the point raised by Mr. Fraser. I think he puts raises something incredibly important. The committee can't. How are we as members, as committee members, going to look at this in a meaningful way, in a serious way? We haven't received all the documents, and therefore nothing's really reviewable here. In fact, if you want to extend the idea further, it's hard to see how there's not questions of privilege that are being raised here if we're being forced to vote on this. So for all these reasons, I have a real challenge with where the amendment wants to take us, Mr. Chair.
Okay, then we're ready to call the question on the amendment. I believe, Madam Speaker, or Madam Chair, Madam Clerk, I will go to you to take the vote. And keep in mind, this is a vote on the amendment to the original motion.
Point of order, could we have that read out again, yes. Mr. Chair?
And I'd ask the clerk if you could read out the amendment. Maybe, Madam Clerk, if you could read out the amendment as inserted in the paragraph and just quote the amendment when you get there. It reads better that way.
And Mr. Chair, just as a point of order, was this supposed to be available on the website at this point? Because there's nothing there right now. It's not?
No, it's only at committee. It hasn't passed, so it wouldn't be on the website. So, Madam Clerk, if you could read it, please.
Okay, so the amendment by Mr. Kelly reads that the evidence heard and papers received by the committee during its study on government spending, we, and the Canada Student Service Grant during the first session of the 43rd Parliament be taken into consideration by the committee during the current session and accordingly. And then we would go back to the first paragraph from the motion by Mr. Poliev that the chair be instructed to present
point of order, Mr. Chair.
Report.
Okay, are you complete in your reading there, Madam Clerk? You are?
Yes.
Okay, point of order.
Yes, Mr. Chair. Nothing has been received. There are no documents on the website. I know that was mentioned before that there's no documents on the website. I've looked at it just now. And so it's hard to see how we're proceeding here.
We may have to get clarity on this. I think the clerk has indicated that the documents and evidence are still on our public website. So we'll have to look into that.
Point of order.
And make sure they are. We're on the question at the moment. Point of order, Ms. Sirowitz.
Yes. Is it possible for the clerk to maybe take a moment to find the link and perhaps ensure that we have it?
Okay. We'll do that. following this vote, because it really amounts more to the original motion that the documents be available.
Another point of order, Mr. Chair. Is it possible maybe we suspend just for a few moments, just for the clerk to be able to do that?
That is possible if that is your wish.
No, that's not the committee's wish.
No, it is.
Point of order, Mr. Chair. That would make me comfortable. I think that would bring assurance to the issue.
Okay.
I note that Mr. Fredriscato's comfort is not part of the committee's mandate.
Listen, we will suspend
point of order,
for
Mr. Chair. It's great to see
for,
Mr. Polyev back, but proper procedure is part of the committee's mandate. We need assurances on whether or not the document.
Gentlemen, we're not going to get into it. We're not going to try. We're going to try and not get into an argument here over the virtual lines at the moment. We will suspend for 5. We will suspend for 5 minutes.
Point of order.
And if the clerk can check if the documents and evidence are still on our public website, and make the link available.
Point of order, Mr. Chair.
So we are suspending for 5 minutes, and we will be back at exactly 13 minutes to 1 your guys' time.
Point of order, Mr. Chair. Point of order. I'm a new member, and I have these.
is below that. Everybody's back on. I believe, Mr. Polly, you have your point of order. Then we're going to the question.
Thank you. And there is no implied consent at any point to move to adjournment. I just want to make sure that's clear and that a vote would have to be held before an adjournment were to happen. Thank you very much.
That's a point of information, and I recognize that. We read. Thank you. So on the question, Madam Clerk, point of order, Mr. Fraser.
Sorry, one of the things I'm still not clear on is I received the email and it looks like it's got links to the various meetings we've had. I haven't seen on a quick scan through the links in the half a minute or so I've had to look at it whether my concern has really been addressed around formal receipt of by this committee of the documents that the government had disclosed in response to the committee member. I'm curious if you or the clerk can confirm whether the total disclosure was formally made, because that's unclear to me. And I'm not trying to be tricky. I don't enjoy the idea of voting on documents that I don't know that we have. If you could clear that up for me, I'm still searching for that information.
You had the documents for 2 months now.
Madam Clerk, can you respond to that? Are the documents there on that link?
So the documents that are available on the House of Commons committee website for the Finance Committee are all the evidence heard from the 43rd Parliament First Session, and also the documents that were tabled with the committee.
So they do. So through that link, the documents asked for by the committee that the law clerk redacted, they're available on that site. Is that correct, Madam Clerk?
Well, the documents, the redacted documents are on the website, yes.
Okay. Okay, and I do know that just immediately prior to prorogation, they all, I don't think, had been, I guess the word's uploaded. They are all there now, I assume.
Point of order, Mr. Chair.
Just so I could get an answer for Madam Clerk.
Yes.
Okay, thank you. Point of order, Mr. Fragaskatis.
I still am struggling to see the documents. I don't know where they are. I also call the attention of colleagues to parliamentary procedure and practice. We're being asked to make a decision here through a vote. We're being asked to put forward a view when papers and records are not present and made available to us. Parliamentary procedure and practice specifically mentions questions of privilege arise on matters of papers or records that need to be made available in order for members of Parliament to come to a decision. We don't have access to those papers or records, and therefore I think there's issues of privilege that are present here. I think it's incumbent on us to look at this more closely.
Point of order, Mr. Chair.
Go ahead. I think we're into a debate here, but go ahead.
Just for the information of Canadians watching, these are documents that Mr. Fragaskatos, Mr. Fraser, and all members of the committee have had since the summertime. If they've lost those documents through a carelessness, the clerk might do them the favor of re-emailing them the same documents. But let's be clear, these are documents that they know about, that they have possessed, albeit blacked out by their own government, but they know exactly what documents we're referring to. And I would ask them to send an email to the clerk and say, hello, Madam Clerk, we've lost these documents that you gave us all these months ago. Would you please help us rectify our error and send them again? That way members of the Liberal side can be up to speed on the documents that they've possessed for the last couple of months.
I heard a point of order from someone else, Mr. Gerritsen.
I just For the record, I don't see how Mr. Julian finds what I said offensive, but not what he said offensive, especially when he's been doing all the heavy lifting for the Conservatives today. But in any event, I don't have the documents. I wasn't here in the summertime on this committee. I'm new to this committee. I'm new to, well, my homework. You just introduced this amendment. You just introduced. I'm supposed to do my homework.
Read your briefing. It's not my job to brief you.
This information is based, Mr. Chair. If I could. Mr. Chair, this information is based on an amendment that Mr. Polyev gave to Mr. Kelly to bring forward only 45 minutes ago.
Do your job.
He doesn't. It's not even making any sense. So I certainly was never given these, Mr. Chair. It would be great if you could make sure that all members of this committee. I know Mr. Sampson is here as well. I don't know if he has these documents. I mean,
no hand-holding.
He wants the documents. So,
you're an adult.
Mr. Chair, I think it would be incumbent upon you to ensure that those are delivered via the clerk. Thank you.
Point of order. I tried when you shut the meeting down. I tried to say I have the documents. I'm also new, so perhaps somebody should have done their homework.
Someone's on the ball.
I believe according to my information in the clerk, and I'll read it again. Please find below. This has went to all members. Please find below the link to the documents from the committee, government spending, and the Canada Student Service Grant that are available on the committee website from the 43rd Parliament first session, and there is the link. And I'd encourage members to look at that website and see if they're satisfied. I do hear some believing that they don't have access to the redacted documents by the law clerk. So just checking that to see if you're satisfied. I'm not sure, Mr. Julian, did you have your light come up there? A little yellow line under you, and I'm not sure whether you were trying to get in or not.
Thank you, Mr. Chair. I don't think I have anything further to add.
Okay, are we now ready for the question? Could we
point of order, Mr. Chair?
Fraser?
There's with respect to some of the interventions that have been made, there's a key point that I've referenced a few times that is still unclear to me, not having had time to review the links that were sent out and only becoming aware of the proposed amendment during this meeting. The hitch that I'm running into is I mentioned there was an abnormality in the disclosure process because of the timing of prorogation previously. What I'm unclear about is whether the documents that have been circulated by link, which I know I had trouble finding on the public website. I don't know if that's exclusively an internal link, in which case we wouldn't have seen them here. But what I'm unclear about is whether the documents at the link are identical to those that in fact were formally disclosed to the committee before prorogation. The amendment discusses papers and evidence received or something to that effect received by the committee. What I'm not clear on is whether the documents available at the link provided actually can be accurately compared to ensure that they're the same documents that are proposing to be adopted before this committee now. I don't know if, Mr. Chair, I doubt you have that information on hand. Madam Clerk, I'm wondering if you can actually confirm that the documents you circulated by link are in fact the same ones that were uploaded. I know David Gagnon, I believe, actually indicated the uploading of the documents couldn't formally be completed because of the timing of the prorogation. So I'm aware there are many documents. I've reviewed thousands. What I'm unclear is which set of documents we're voting on, which is really the source of my my difficulty with the proposed amendment.
Sorry, my phone rang in the meantime. Madam Clerk, just for the information of the new members that are on here, David Gagnon was the clerk at for the committee on the in the first session of the 43rd Parliament, and Evelyn is now our clerk. Can you respond to Mr. Fraser's concern, Madam Clerk? I don't want to put you on the spot. If you can't, we'll have to raise the question with somebody at the center of the Parliamentary Bureau there to answer for us at some point.
Well, that is the link I shared with the members is the link that Mr. Gagnon had shared with me when I took over the committee. Okay,
so go ahead, Mr. Fraser.
Yeah, continuing then, what I'm still unclear, and I appreciate that you weren't engaged before this session began, Madam Clerk. Did Mr. Gagnon provide any evidence or any information to you about whether the links prepared were the same documents that in fact were formally put on the record for this committee?
That was my impression, yes.
Do we, I really don't mean to be difficult or to try to put you on the spot. Do we actually know that, or is it just an assumption based on the conversation yet?
Madam Clerk, do you, I don't want to put you on the spot either, Evelyn, but go ahead.
So that is the link I received. Whether other documents would exist, I would not be aware.
Okay, one of the reasons I raise it, Mr. Chair, upon just I clicked one of the links. I'm trying to scan this in real time. I don't even see something as basic as the transmittal letters that were included in the correspondence that in some instances actually explain the nature of why certain redactions would have been made. And I feel like we're dealing with two separate evidentiary records potentially. One that's been submitted through a link very kindly by our clerk just minutes ago. And Madam Clerk, please accept my apologies. I do not mean to put you on the spot or ask for information that would be near impossible to have front of mind. But I still am struggling that when we're talking about the papers and documents received, that's going to mean something. A person is going to interpret that as something. The information that you just shared with us through those links, Madam Clerk, I don't have confidence upon a quick review that they actually match up with the evidentiary record that was before this committee in the first section of the present Parliament. In the absence of that certainty, I can't know specifically which documents are in or are out, so I can compare them with the motion to determine whether the redactions were made in an appropriate way to comply with the request of this committee. So I'm just wondering, is there a potential path forward that you see that would allow us to actually confirm that the documents we're about to vote on that are the subject of the present amendment to the main motion, can we actually confirm that those documents are what certain members of this committee are saying they are?
I'll go to you again, Madam Clerk, and I don't know whether we have to bring in the others from the parliamentary branch or not, because I don't really want to put you on the spot, but answer as best
point
you
of
can.
Order,
And
Mr.
I
Chair.
believe Mr. Polyev wants in as well, but just okay. Point of order.
Yeah, the documents in question are very clear. In the amendment that you have, it basically refers to the conversations around we and the Canada Student Service Grant that happened in the 43rd Parliament. It doesn't say anything about what's on a website somewhere and the members' website or web link. There's nothing in the motion that deals with a website or a web link. It deals with the record, which is permanently crystallized into parliamentary history from the 43rd Parliament. It is very clear what the documents are. They are published. They are contained in something called the Blues, which members should be familiar with. The documents were turned over to this committee. At that time, there was a record of receipt of those documents and transmission of those documents to all committee members. All of that is in existence. The fact whether or not the clerk has put them on a website somewhere, whether there is a web link where Liberals can go and find it, is absolutely irrelevant to this debate. The documents and the testimony is now a permanent matter of public record, and that is what the the amendment refers to. When this is reported to the House of Commons, this motion, then the Speaker and all MPs will be able to refer to those records. There's no confusion about that. I find it a little bit embarrassing. I feel badly for my Liberal friends who kind of embarrassed themselves by saying that they haven't done their homework on what happened only a few months ago right here in this committee prior to prorogation. To say that they are oblivious to those conversations, or that they have been unable in the 6 or 7 weeks since to pull up those documents and look at them, is kind of embarrassing. Use the basic rule that you come prepared. Ms. Jensen, who is a new member of this committee, seems to be more informed than Mr. Fragiskatis and Mr. Fraser, who are completely oblivious to what happened right before their eyes in committee meetings they attended. So I'd like to congratulate Ms. Jensen for—
Point of order, Mr. Chair. This is an example of the personal attack.
I'm in the middle of a point of order.
We're already into a point of order. We'll get to you next.
That is a personal attack.
Peter, Frank Fragiskatis, Mr. Polyev.
Yeah, no, I'm merely pointing out what Mr. Fragiskatis has admitted. He has admitted that he is unprepared and that he has no idea what happened in the meetings that he attended. And that is the very basis for his argument that he can't vote. So
point of order, Mr. Chair. Another personal attack.
And Mr. Gerritsen are
completely unacceptable.
Are confused. Then that is a matter of poor preparation and not a matter of parliamentary procedure. So we can't hold everybody's hand because they haven't been able to do their homework. We have to. Canadians expect a high level of competence from their committee members. That's why they send us here. That's why they get paid. Parliamentarians get paid. And if they can't do their homework, maybe they should call up their whip and ask to be replaced by someone who can. Ms. Jensen has demonstrated she can show up to work prepared. So I ask that all members of the government side follow her example. Thank you.
Mr. Fragiskatis, on a following point of order. And I believe we're straying some from the discussion here, but Mr. Fragiskatis.
I appreciate it, Mr. Chair. I will keep it focused, and it is longstanding practice, and not just in Canadian parliamentary tradition, but Westminster parliamentary tradition writ large, that as a basic way of engaging in debate, members have to be collegial. Mr. Polyev brings this point up about collegiality when it suits him, but all too often goes on the attack. Now, I'm not insulted personally, but I think it establishes a negative precedent. He went after me and said that I haven't been prepared. I've been prepared for each meeting. He went after Mr. Fraser as well. Mr. Fraser is modest and won't speak about himself. He's one of the first MPs that I met after being elected in 2015. I know he takes the job extremely seriously. When Mr. Polyev attacks my friend Sean Fraser, I have to stand up, and he's done it to other members at this committee as well. Not just on the Liberal side, but throughout his tenure as a Finance Committee member. He has gone after each member of the committee and heckled, hurled insults. It's not becoming of what an MP is all about. We have to keep in mind that, yes, we will agree and disagree, but when we disagree, we must do so reasonably. And it's very, very unfortunate that Mr. Polyev has decided to engage members in that particular way. And I'd call your attention to it, Mr. Chair.
Point of order,
Mr. Chair,
please
Chair?
Call the question.
Mr. Chair, I've had my hand up.
I do have Mr. Gerritsen first on this point, and then Mr. Fraser.
Mr. Chair, I just want to say that although Mr. Kelly would love Mr. Polyev to have the last word on that, I would like to weigh in on that as well, which is I am a new member to the committee. He says, and was trying to insult me by saying that I should have done my homework. I would have had no way of knowing that the Conservatives were going to bring forward this particular amendment to a motion. So therefore, there's no way that I could have been able to somehow in advance try to figure out what they were doing. Mr. Poilievre criticizes members of this committee for not being prepared and perhaps doing other things. Well, I'll be the first to say that I was doing something else, Mr. Chair. I'm not sure if Mr. Poilievre is aware, but there's a global pandemic going on right now. We are in the second wave of it. Canadians are looking for assistance. I've pulled staff from my Ottawa office back to my Kingston office to assist members of my community, constituents, in accessing a lot of the programs that they need right now, stuff that they rely on, they're looking to the federal government for. So I apologize to Mr. Poilievre if I wasn't paying attention when he was, grandstanding and waving papers around in the air, trying to get attention from the media. Some of us were actually back in our constituencies, actually helping Canadians who are looking for help right now, who are looking to access programs like CERB, and small businesses that are looking.
Point of order, Mr. Chair. I was doing this same thing and was able to prepare my homework.
We're already on a point of order, Ms. Jensen.
Call the question. Yeah, this is delay. This is a delay tactic to prevent the vote. Call the question, Mr. Chair.
No, I think it's
and then Mr. Fraser.
It's extremely germane to the discussion, Mr. Chair, because what Mr. Poilievre is accusing members of this committee of doing is basically not doing the work that he deems to be so important, which apparently is predicting what his next move will be so that we can properly prepare for it. On the contrary, I would argue that most members of this committee, and I would put my Conservative, NDP, and Bloc colleagues into that as well, we're working on behalf of their constituents. I have small businesses in my community that were looking for access to wage subsidy for their small businesses. Businesses that are literally about to close. And for some reason, Mr. Poilievre feels as though the most important thing for Canadians right now is to get in front of a podium and grandstand and wave around papers as though, that's the only thing that Canadians care about right now. So, Mr. Chair, I do sincerely apologize to him and the other colleagues on this committee that I did not somehow anticipate what their moves were going to be so that I could magically prepare for it because I was caught up doing other things on behalf of my constituents while we're in the second wave of a global pandemic.
Okay, last one. I'm not sure if last one or not. Mr. Fraser, and I'm not sure if you still want in Ms. Jensen. Mr. Fraser, and then I'll go to Ms. Jensen. And we'll go to the question, hopefully.
Thank you, Mr. Chair. And look, with respect, I don't. The accusations Mr. Poilievre is launching, they don't really bother me. But one of the things that I'd like to draw attention to is that no one, including him in his criticism of my request for clarity on this, has actually clarified the one piece that I keep repeating. The issue here is that there's different batches of documents that we are talking about. I understand some were disclosed on USB keys to critics of different parties. I understand some have been uploaded to the website, but I also understand that there was a very specific, unique thing that happened during the upload of the documents, which was prorogation. This is not a matter of having not done homework. I've been able to look at many of the documents that in fact I expect are the subject of the proposed amendment. What I find it impossible, and I don't even know how we can consider the amendment in order if it doesn't make clear which documents we're actually looking at. So the unique piece, perhaps because I was paying attention at the meetings and the various correspondence that has come through to committee members, is whether the documents that the motion's actually going to further adopt is effectively an incomplete version of the disclosure because of the timing of prorogation. if that is the case, obviously the right approach would be to say, government, can you please table the full disclosure of documents as you were asked to do? And then we would presumably have an opportunity to look at those documents, compare them to the request that we've made, and make a determination at that time as to what is appropriate. So perhaps Mr. Poilievre is choosing not to understand that particular point, but the issue at play from my perspective is the fact that the amendment does not make clear to me whether we're dealing with all of the documents that the government had intended to disclose because of the very particular nuance around the prorogation at the time they were being uploaded.
Ms. Jansen, and I believe that is the end of my list. Is there others? Ms. Jansen.
No, I'm good, thank you. Just wanted to remind him that I was doing all the same things, Mr. Gertsen, that I was out there, got my flu shot, I went to the Thanksgiving dinner, all of that, helped with the businesses, met with veterans at the Legion, and got ready for the meeting. So just that's our work, that's our job.
Okay, then I guess we're ready for the question, Madam Clerk. I wonder if you could call the vote on the amendment to the motion.
Point of order, Mr. Chair.
Point of order, Mr. Fragiscatis.
Vote was called. There are no points of order during a vote.
I said that I would not bring up points of order unless
the vote is already called. We're in the vote.
Issues were important, but the point of order was recognized.
That's not true.
The point of order
That's not
was
true.
recognized.
The clerk had not started the roll call yet, so and nor has the chair read out the motion. So technically, it hasn't begun. So, Mr. Chair, a point of order right now is completely in order.
Mr. Fragiscatis.
I'll continue. I do not believe as a member of this committee, and I think Liberal colleagues would echo my reservations, that the points that Mr. Fraser and other Liberal members have brought up here have been dealt with. So I understand that certain members in the opposition want to move towards a vote, or it sounds like they're unanimous in that on the opposition side, but I still think we have not dealt with the matter that has been raised before the committee, which, as I stated in my remarks, based on what we find in parliamentary procedure in practice by Bosch and Gagnon, these are questions that hinge on and relate to privilege as well.
Point of
this
order.
Is not debate. These matters do relate to privilege as well. So we have not dealt substantively and meaningfully, Mr. Chair, with all due respect, with the issue at hand.
What I can say on that is what both the clerk has indicated and I've indicated on the message that the documents and evidence are on our public website, and the link has been sent to members. You will have to determine whether that's adequate or not.
Point of order, Mr. Chair.
Point of order.
Point of order. First, Mr. Fragiscatis, then Ms. Zerowitz.
Perhaps it could offer some guidance, and I respect that, and I suggest that rather very humbly, Mr. Chair, that we look as to whether or not there's a precedent for this particular situation to sort of guide our decision making. I'll turn it to Mr.
Ms. Zerowitz.
Yes, my point of order is Mr. Fraser, I think, made some very good points in terms of there's some information on a memory stick and there's some information that was part of the link. And I wonder if it's possible to perhaps have the clerk address that specifically, Mr. Chair, if that's appropriate to be able to do so. I'd love to hear from her in terms of whether there is indeed different bits of information in different places. And I do think that what my colleague Mr. Fraser has raised is a very important point of privilege for all of us.
I have a note. I think I did say on the public website, the documents are on our Commons website through the link that the clerk has sent. Madam Clerk, do you want to rephrase your question to the clerk again, Ms. Zerowitz? I didn't quite get the context.
Absolutely. So I'll ask it maybe, and I'll probably just bring it to the point where we've raised a few things. One is I would like to know whether all of the information that was submitted, I believe the 5,600 sort of pages, as well as the transmittal letters, as well as anything that was on memory sticks, is that all provided to us as part of the information that was sent to us via link within the last hour?
Madam Clerk, I'm not sure. Again, we're putting you on the spot, which...
So only certain documents get posted on our website. Items such as correspondence usually would just stay in the clerk's office, but they are available for the public to consult. Any confidential documents would be circulated to MPs during one session and not posted on the website.
And specifically for the transmittal letters, because they are critical in terms of us understanding what was redacted, what was included, why it was included or not included. Would you be able to confirm if that was, if the transmittal letters are actually part of the documents that we have received?
I do not know. I do not know if they were included in that link.
Okay.
Point of order, Mr. Chair.
Point of order.
I see Mr. Fraser and Mr. Sampson, and I heard someone else.
Ms. Zarowitz perhaps articulated the point more accurately than I have. I'm scanning these sites as we go. I can't find I've been looking for the transmittal letters because they're the purpose of their inclusion was more or less a covering letter to explain whether and to what extent and reasons why certain portions of documents would have been redacted. If we know that those documents are not actually in the documents that we're about to adopt, then we will know that we need to engage with the government to encourage them to re-disclose the full package of information on the committee's record. It seems as though I don't think it would be a violation of privilege, which is not for this committee to find. But it strikes me, Mr. Chair, that if we actually know that the documents referred to in the amendment have not fully been disclosed on the record for this committee because they're not on the website that contains the evidentiary record. I'm curious if the proposed amendment could be construed as being in order if we know, in fact, that the documents referred to do not reflect the complete version of the documents that the government, in fact, disclosed to members, but is not before the record on this committee.
Okay, Mr. Sampson.
Thank you, Mr. Chair, and I appreciate the opportunity to make my point of order. You know, I must say that I've been listening now for about half an hour, and I'm very, very disappointed with the opposition trying to let Canadians think that we are not prepared. Let's be honest with what's happening here. This is an amendment that was just put up in this meeting. So how can you be prepared for an amendment about documents? And now the question mark is you're asking me to vote on an amendment about documents that may or may not all be there as they should. And I'm listening to the opposition say, oh, I did all my reading, I was prepared, I did all my other work. Listen, let's be honest with Canadians here. We are not expected to vote on something that I'm not. How can I vote on something that I don't know for sure those are actually the documents? And then I have to share this as well. You know, I've been listening in the House of Commons now for a number of weeks since we started again, and all they talk about, and in the media, about budget. Let's get to the budget. Where's our budget? And we have a standing order that clearly indicates that we have to be, as soon as Parliament took over in September, working on this budget, a pre-budget consultation.
Point of order. This is just debate, Mr. Chair. It's time to call the vote. This is not relevant to the motion. This is not relevant to the debate on the motion. Call the question, Mr. Chair. Restore order.
We cannot respond to those documents unless we move forward on them. And Mr. Julian, with all due respect, he has brought some very important points at the table in the House of Commons: taxation inequalities, tax evasion. I mean, I enjoy when he shares his perspective on tax evasion, but he's not talking about that, and we're never going to get to those points unless we move on to what is important for this committee, and that's a pre-budget consultation, as a standing order clearly indicates.
You are straying considerable from the amendment, Mr. Sampson, but I think
but nonetheless very true.
The question really is, and I don't know whether Madam Clerk, you have to contact somebody in the parliamentary branch there, but I believe what members are asking.
Point of order, Mr. Chair.
I believe what just a moment. Can somebody give the assurance that all the documents that the committee asked to be uploaded to the website prior to our digital binders, I guess is the proper word, prior to prorogation, including the transmittal letters, are there in that link? I think that's what members are asking. Your point of order, Mr. Fragaskatis.
I think, Mr. Chair, you suggested something there that that could provide guidance. And I have enormous respect for all public servants, including those who perform the role of clerk. The clerk is incredibly able, otherwise she would not be tasked with being the clerk of probably the busiest, and with due respect to many of my other colleagues serving on other committees, the most important committee on Parliament Hill, or if not the most important, then one of the most important, particularly now as we deal with the challenge of COVID-19. But when you suggested, as you did a moment ago, that perhaps the clerk could go back and confer with other parliamentary colleagues on the matter, I think that that could be a useful suggestion. I also think that, again, we have to be remarkably careful here. When we see a call in basically what counts as our guiding Bible, if you wish to put it that way, parliamentary procedure and practice, making very clear that matters of privilege do relate to papers and to records, and when those papers and records are not present and accessible, then issues of privilege do arise, in my view. I think Mr. Sampson also put a very good point forward when he just spoke, saying that
this is repetitious, Chair.
Repetition. No, it is not, Mr. Chair. And I said before, I have enormous respect for Mr. Kelly, but I wouldn't want to accuse him of violating my privilege by interrupting me on a very important point of order as an MP. So I'll continue, Mr. Chair.
Too late. He already did it.
He did already do it, but I'm going to ignore that in the spirit of collegiality that Mr. Poilievre so ably talked about before, which, and by the way, I still see his absence here at the committee. But we need assurances, we need certainty, absolute certainty, that we are seeing the documents that we ought to see as they've been put forward. We can't play guessing games, Mr. Chair. I think Mr. Fraser talked about that. Mr. Sampson talked about it as well. Mr. Darowitz raised this point earlier. And so I do not believe that we are ready to move forward to a vote here until all of these issues have been looked at thoroughly and analysis has been exhausted on the matter.
And I have another point of order to add to that, Mr. Chair, if I can.
Go ahead.
Oh, thank you. I always wonder whether I'm muted once I speak. Just in line with what Mr. Fragaskatos has said, I will get his name proper soon. I wonder, is voting on this motion in order when we don't know if we have the full documents? I think that's really where I'm left with.
And assumptions can can be a problem. I'm operating under the assumption that the information that went up to the digital binders and the documents and the transmittal letters are as the clerk maintains. And whether or not we've seen them, we certainly expect them. What I'm going to do is suspend for 5 minutes so I can talk to the clerk on the side because we do need assurance that information is available now or is readily available. So I'll suspend for 5 minutes, and I will give you a call, Evelyn, offline. papers come back on. Okay, there's nothing like saying life is complicated. In any event, the from the clerk's point of view and discussions, the committee will see exactly what they seen in session 43.1. They will restoring the e-binders, and they will be brought forward and made available to this session. Part of the problem here, if we want to see the evidence from session 43.1, we really don't know that evidence until we ask for it. And this is the and certainly some of us who were on the previous committee before have seen that evidence. And that is the link that was available prior to prorogation. So everything that was available to the committee in 43.1 is there. The difficulty, and I don't have an answer on it, because when prorogation happened, I don't think all the evidence was up into the digital binder on the documents at the time of prorogation. I know David went a few hours after prorogation to try and get it in the digital binders. So I can't answer in that question, but basically what I can say is that the committee will see exactly what they saw on session 43.1, and this amendment is asking for that evidence. And as I said in the beginning of the meeting on my order, is the speaker would definitely need that evidence in order to make a ruling. So that's where we're at on the amendment. I know there may be some objections
Point of order
to that, and I'll go to Mr. Poilievre's point of order. That's the best I can tell you at this time. And the transmittal letters and some 5,000 plus pages of documents should be in that e-binder that was in the last session. Mr. Poilievre.
Can you clarify where the e-binder was mentioned in my amendment?
Your e-binder, the e-binder wasn't mentioned.
Oh, good. Okay, so then that's irrelevant to the debate.
But I think in fairness, Mr. Poilievre, to make sure that
if he doesn't know where his what his
hold
motion
on,
says.
Hold on. The clerk could restore the e-binder and make available all evidence that was in the last session and bring it forward to this one as well. Okay.
Right. And so my point of order. And so what part of that evidence has not been made public yet?
I think it, and I might have to ask for clarification on this from the clerk, but I think all of that evidence has been made public in the last session. I believe that to be true, but we need that evidence. to go to the speaker as per this motion as well.
Yeah.
So are we now ready for the?
To conclude my point. That's great. All the documents are public, and the speaker therefore can acquire them. And if he needs someone in the clerk's office to point him in the right direction, that can happen too. Thank you very much. So let's go to the
point of order, Mr. Chair.
Are we ready for the question?
Point of order, Mr. Chair.
Mr. Fraser.
Point of order, Mr. Chair.
I'm still
Mr. Fraser and then Mr. Polyev.
Mr. Chair, one of the things that I apologize for coming back at this, that I understand that there are documents in an e-binder that should correspond to what the committee had on record. I understand from your explanation following the recent suspension of this meeting that there is the ability to provide whatever was provided at the time the first session of the current Parliament was prorogued. The question that I still don't understand is whether the complete disclosure package that the government did in fact provide to members of this committee is actually included in what this committee will have. This is not some nuanced technical point. One of the reasons I'm concerned about it is upon a review of the documents that the clerk directed us to during the suspension, I remain unable to locate the transmittal letters. I expect there are other things that were disclosed by the government that are in fact not going to be made available. Having incomplete disclosure, particularly, and I keep drawing attention to the transmittal letters, because those are the documents that explain why certain portions of documents were redacted. For example, they may have included information about the family members of public servants, or just a list of email names of public servants that had personal information, just for example. It seems foolhardy for us as a committee to demand production that we know or expect is incomplete, not because the government chose not to disclose information, but because it may not have been fully uploaded. Is it possible to have someone do a comparison of the documents that were in fact provided to committee members directly, say by the USB keys, and the information that would in fact, Ms. Jansen, I have the floor with respect.
Point of order,
Mr. Chair.
It's been established that the documents have been made public,
I do have the floor.
It's a point of order when there's one point of order on the floor. So I'll go to you next, Ms. Jansen. This is point of order day for sure at the Finance Committee. I can tell you that. Mr. Fraser.
Thank you. To finish my point, Mr. Chair, it would be very, very helpful if the clerk perhaps could do a comparison to ensure that we're not on a fool's errand here, demanding production that we know will be incomplete because it wasn't properly uploaded. Is it possible for the clerk perhaps to do a quick review of the two sets of documents to ensure the same number of pages are there, for example, so we can verify that we're actually looking at a complete body of information? What I'd love to avoid is having setting the stage for a false accusation that the government failed to meet the order of this committee or request of this committee, when in fact they did their best to, but due to a technical reason during the timing of the upload, the complete package wasn't put on the table.
Okay, I'm going to Ms. Jansen's point of order, but in your point of order, it's maybe something to think about. You can put an amendment to the amendment to assure the documents include transmittal letters, if that's a huge concern. Ms. Jansen.
Yes, just the fact that it has been established that everything was made public, and Mr. Fraser is talking about a fool's errand, and I think most Canadians watching this, if anybody is still watching this, would consider this committee meeting probably that fool's errand which he's talking about. It's really time to take a vote. Let's get on with it so we can get on with business.
Point of order, Mr. Chair.
And I can't take a vote until the committee allows me to take that vote, Ms. Jansen. That's the problem. Mr. Fraser, on your another point of order.
Sure, and it's related to a comment that you just made. My concern is not solely the presence or absence of transmittal letters. That's one of the concerns, and it's a serious one. The bigger picture concern that I am worried about when I'm looking at this motion is I know that certain documents were made public. What I want to ensure is that all of the documents that the government disclosed are part of that record, and no one's been able to clear up for me if, in fact, what documents are the subject of the proposed amendment to the motion that we're currently debating actually mirror the documents that the government provided. If we're not talking about the same set of documents, of course the government will have failed to meet the request of this committee, but it wouldn't be because they chose not to disclose information. So I'll ask again, and you suggested maybe it could be an amendment for an amendment, but is it possible to have someone, before we take a vote on the existing amendment, to actually confirm that the two packages of documents are identical?
The only person I could ask on that is the clerk, who may be in communication with the analysts.
Can you make that request, Mr. Chair?
Could you? And we're talking about 5,000 pages here plus. So could the clerk and the analysts take 5 minutes, look into this, and we'll come back to it.
Point of order, Mr. Chair.
Yes.
No, we're not going to suspend again to run on a fool's errand, as Mr. Fraser
has not a point of order.
Properly gave it the appellation.
It's not a point of order.
We are now ready to go to vote.
It's really
now time to go to the vote.
I think, Mr. Polyev, it's really not. I don't have to move to the vote.
Motion to challenge the chair.
I can't.
Challenging the chair. I'm challenging your ruling.
I can't move.
I don't
know that there was a ruling to challenge.
There wasn't a ruling to challenge.
Your ruling is that you can't move to a vote, and I'm challenging that.
I can't move to a vote on till there's satisfaction among committee members to move to a vote.
I challenge that ruling.
And
so that's not a ruling.
I'm not accepting that challenge.
I challenge that ruling.
So I am going to ask the clerk and the analysts to meet for 5 minutes, come back with as best an answer as they can give us, and then maybe we can get to the vote. So I got no other choice but to do that. So take 5 minutes, Evelyn and the analysts, and see what you can come back to us with. Meeting suspended for 5. We will we'll come back to order. Madam Clerk, have you got a response there to what we asked you to look into?
Yes, so the links to the documents that were shared with the committee members are the documents that were sent from the departments. Do not include the transfer letters, those were separate files, and do not include the letter from the law clerk, but all the other documents that were transferred as part of the request are in that link.
Okay.
So point of order then, Mr. Chair.
Okay, I see two hands up. I first have Mr. Gerritsen and then Mr. Fraser. And okay, go ahead.
So I think that, you know, I would like to move an amendment to the amendment then, Mr. Chair, in light of the fact that we heard this information. So I would, my amendment to the amendment would be, and further, that the clerk of the committee, so this would just be at the end, that the clerk of the committee do a complete analysis of the documents provided to the committee by the law clerk and compare them to that which was provided to members by the government.
Can you roll that
and I have it in French
again?
Yeah, and sure I can forward the French text as well. Maybe my staff could do that right now to the clerk. I will read it again more slowly so that everybody can take that in. So this would be an amendment to the amendment, Mr. Chair, at the to follow what is currently proposed, and further that the clerk of the committee do a complete analysis of the documents provided to the committee by the law clerk and compare them to that which was provided to members by the government.
Okay, got to find the original motion here. Okay, I believe the amendment to the amendment is in order. We're on that. It's moved. Mr. Fraser.
Thank you very much, Mr. Chair, and thank you to any staff involved with the comparison. I think it's I think it's one of the things that's really important is that the transmittal letters in particular are included in the package of documents that will find its way for consideration by the committee. You'll recall the original motion back in July, again, that gained support from both sides of the aisle, stated that pursuant to Standing Order 108, sub 1, sub A, the committee ordered that any contracts concluded with We Charity and Me to We, all briefing notes, memos, and emails from senior officials prepared for or sent to any minister regarding the design and creation of the Canada Student Service Grant, as well as any written correspondence and records of other correspondence with We Charity and Me to We for March 2020 be provided to the committee no later than August 8th, 2020. And this next part is key to sort of the importance of the transmittal letters, and forgive my taking a little bit of time to get there, but this piece is important. That matters of cabinet confidence and national security be excluded from the request. Before I read the rest of the motion, I think it's important for it to sink in that the government was not requested to give documents that touch on cabinet confidence or that compromise national security. And then that any redactions necessary, including to protect the privacy of Canadian citizens and permanent residents whose names and personal information may be included in the documents, as well as public servants who've been providing assistance on this matter, be made by the Office of the Law Clerk and Parliamentary Counsel for the House of Commons. I argued earlier in this meeting that that doesn't relieve the nonpartisan public service of their obligations to comply. In any event, I'll set that argument aside for now. The point here is that items that are not relevant to the committee or motion request for documents that were redacted by the professional public service, those redactions took place for good reasons. They may have involved items that were on the agenda of a cabinet meeting. The cabinet meetings, in fact, perhaps that the Prime Minister and his chief of staff testified to at the Finance Committee in the previous session. Matters of national security and sensitive procurement that could hurt the government's ability to act in the national interest. Matters that, if released, could be damaging to Canada is frankly what we're trying to avoid the disclosure of under ordinary circumstances. Look, I'm always in favor of protecting our national reputation, our national security before anything else, and allowing government to take decisions knowing that they can have, in certain circumstances, confidential conversations. In my view, the redactions that I've seen strike the right balance between releasing relevant information, as the committee's requested, and protecting cabinet confidence, which, again, this committee did expect would be respected. Now, in the Privy Council Office document release that the clerk circulated today, there is a synopsis of a cabinet meeting, and it's frankly an extraordinary document when you think of it, that would rarely be released. I don't think previous governments would have allowed that kind of document disclosure of things that should be subject to cabinet confidence. The synopsis here of an entire cabinet meeting has been made public, though there's obviously items that are protected by cabinet confidence. Items that related to the Canada Student Service Grant were still disclosed. I don't know what other topics were discussed. There could be national security issues. We'll never know. And cabinet confidences that are not related to any of this ought to be protected for good public policy. This was determined by the clerk of the Privy Council and referenced, to my point, in his transmittal letter specifically. These transmittal letters give context to the documents to explain precisely why certain things were redacted or not redacted. Frankly, Mr. Chair, there's reasons that documents like this are not normally public until long after a government's mandate has come to an end. Ensuring the confidence of cabinet deliberations is essential to peace, order, and good government, which our colleagues often reflect upon publicly in their comments. I think these confidences are essential to the operation of responsible government. Yet, in a rather extraordinary move, the clerk waived privilege on sections of this particular document as they related to cabinet discussion on the Canada Student Service Grant. These confidences are amongst our country's most protected information. Here it is for everybody to read. If opposition colleagues want to view documents that are subject to cabinet confidence, they should form government and be appointed to cabinet, and they will have their access to cabinet confidences there. And frankly, I would defend their right to have those confidences, even in opposition. Until then, Mr. Speaker, the release of these relevant cabinet information as it relates to the Canada Student Service Grant is going to have to suffice. Through the PCO release, and once again, what do we actually find redacted? It's a personal phone number of a staff member, an item that never would have been released in an access to information request. And I think that kind of protection is important and necessary. I think just to conclude the point in support of the sub-amendment, the transmittal letters we now know were not included amongst a few other documents that were just referred to, are not actually captured by the motion. It's difficult to imagine how we can determine the appropriateness of disclosures made by the government when we simply accept the documents but purposefully exclude the government's explanation as to why certain redactions may have been in place. As such, I'd be supporting my colleague's sub-amendment that he's placed before the committee.
Okay, Ms. Jansen next on my list, and just has the amendment to the amendment. That is the issue we're on now. We'll have to vote on it, then get to the amended motion or not, and then to the original. So we're on the amendment to the amendment. Ms. Jansen.
Yes, thank you. I find it just very, very interesting how we were talking about how very important it was. The Liberals wanted us to get moving. Let's get on to the next most important item of business. And Mr. Fraser is actually putting a motion forward that is going to ensure that it takes weeks for us to go forward, when we know that all of these documents are already public. And, regular Canadians are going to say, this doesn't feel like openness and transparency to me. Again, like I say, weeks. Can you imagine how long this is going to take? When the clerks have all been working hard and doing their job, we know that they're very competent. We're very thankful for the work that they do. So this amendment, as it stands, it just boggles the mind. This absolutely stands in the way of us getting anything done. So just so you know, regular Canadians that don't talk lawyer speak are going to be quite shocked at this amendment.
Thank you, Madam Jensen. Ms. Zerowitz, and then Mr. Gerritsen.
Thank you so much, Mr. Chair. I will be supporting my colleague's amendment to the original motion. And I just wanted to respond to Ms. Jensen's comments. Let Canadians be very, very clear. I put a motion on the table for us to begin pre-budget consultations during an unprecedented pandemic. I can assure you, if there's anybody who's wasting time, it is the original motion that was actually proposed by the opposition. It is not us. So if you can sort of wave a magic wand, Ms. Jansen, and sort of get us right back to the pre-budget consultation, I think that is where we're raring to go, because we know that Canadians want to talk to us. Canadians want to share their ideas. We know that economists want to provide some advice on how do we create a competitive environment in Canada? How do we best restart the economy so that we could support our businesses moving forward? How is it that we can make sure that we continue to support those industries that are most impacted? Tourism, arts and culture, hospitality. I can unequivocally tell you that it is not us that is wasting anybody's time. So it is the original motion that was put before us. And I will tell you, there is a motion that I read first. It's on the table. It's on pre-budget consultations, and we were ready to start it at our last meeting. Thank you.
Mr. Gerritsen, and then Mr. Polyev.
I think I was next.
No, the ones that come in from the clerk. The one that I seen from the clerk is Ms. Gerritsen first, and then you, Mr. Polyev.
Mr. Chair, I would very much enjoy hearing what Mr. Polyev has to say.
Okay,
I'd be willing to let him go first if I could follow.
Okay, we'll let Mr. Polyev go first, and then Mr. Gerritsen.
I thank my distinguished colleague for that concession. I was just going to say that I heard Ms. Zerowitz's comments, and I couldn't agree more. Let's get on with the rest of the committee's business. I totally agree. I want to move right to her motion. So if we can just vote on the motions before us, I think we could probably get through the votes on the two amendments plus the main motion in about 5 minutes. And I'm happy to actually stay and discuss her motion as well. So we could easily get through it all today.
What's your point of order?
Is Mr. Polyev saying he's withdrawing his original motion, and going right to the PBC, to the pre-budget consultation motion?
Mr. Polyev will have to answer that.
Well, that's what I was proposing.
Oh, I was just with a minor tweak, which is that we would just vote on these motions that are before us right now, and then we'd go right to your motion. So if you're really interested, Mr. Chair, we're in a pandemic. Canadians are suffering. They've lost livelihoods. Some have lost their lives. Let's get back to work on that. Let's vote on these motions so we can get them out of the way and get back to discussions on how we can rebuild Canada's economy. Let's do it now.
Mr. Gerritsen.
We'll see.
And then Mr. Julian.
Here's the problem with what Mr. Polyev just said, is that he's basically saying, Mr. Chair, I recognize that Ms. Zerowitz's motion was on the floor. I didn't like the fact that we had to deal with hers. So I tried to use some procedural moves in the last meeting to jump ahead of her. And hey, guys, let's just vote on my motion now and get it out of the way, and then I'm happy to go back to hers. And if he can't see the problem with that, Mr. Chair, then I think he really needs to reassess his participation in this committee, because it's not all just about him, Mr. Chair. You know, maybe it is just about him on the Conservative bench because he seems to be running the show there, which is very respectful, and your soldiers are doing a great job on your behalf. But the reality is that there was already a process in place with Ms. Dzerowitz's motion, and Mr. Poilievre tried to jump ahead of it. And now he's trying to use the rationale of, hey guys, just vote on it. Let's push this out of the way and then we can go to her motion, as long as what's important to me is dealt with first, which I find to be extremely unfortunate that he's choosing to go down that road. And so if he has issue with members of the Liberal caucus taking a position on that and being offended by that, well, I would assure him that that is a legitimate position, in my opinion, at least, for Liberal members to be taking. And that's how I end up supporting the fact that, yeah, maybe it is in the best interest to withdraw your motion, Mr. Poilievre, get in the queue where you belonged, and let your motion come forward properly, because I believe that Mr. Julian even had one in between the one that was on the floor and yours, but somehow you're the most important asset to this entire committee and the parliamentary process writ large, and therefore your issues should be dealt with great haste.
Okay.
But I'll just go back to the amendment that we are discussing, which is my amendment to the amendment, Mr. Chair. And I want to emphasize that I want to emphasize why these transmissional letters are essential. It's already a rare occurrence that cabinet confidences of a sitting government are released. And the clerk took the extraordinary step to release all information as it relates to the CSSG, while also maintaining that he would protect necessary and unrelated cabinet confidences. He detailed that process as did other deputy ministers in their transmittal letters. Everything present here has been done in the spirit of that promise and while respecting the committee's motion for information. Let me give some examples of that. In the PCO release, we have a summary of a full cabinet meeting. The discussion could have been related to vaccine or PPE procurement, national security, or other matters. A cabinet document such as this is rarely, if ever, made public. Cabinet confidences unrelated to the Canada Student Service Grant are redacted per the terms of the motion adopted by the committee. Keeping with the spirit of this committee's motion, those items, CSSG items in particular, were visible. And a second example of this is in the PCO release. We have a second cabinet note, Mr. Chair, where the document is redacted. It is the latter cabinet meeting in May of 2020. The CSSG implementation was discussed and is unredacted as ordered by this committee and agreed to by the clerk of the Privy Council. However, the rest of the information is still redacted as they fall under cabinet confidence. Again, we do not know what the topics of discussion were. There could have been talks related to national security matters, legal discussions that are solicitor-client privilege. There could have been key discussions related to further PPE, personal protective equipment, and vaccine procurement, that if the public would have put our competitiveness at risk otherwise if that was released. So, Mr. Speaker, in conclusion, or Mr. Chair, I think that we have demonstrated in an exhaustive manner that the redactions the opposition have been turning into political theater are in fact in line with the motion that they proposed at this very committee. Thank you, Mr. Chair.
Thank you, Mr. Gerritsen. It was really nice of you to get back to the amendment. That's where we all should be. Just before I turn to Mr. Julian and then Mr. Sampson, Mr. St. Marie, if you do want in, you're probably going to have to wave both arms because you're near in the dark there. So I don't want to miss you if you want in. Mr. Julian and then Mr. Sampson.
Thank you, Mr. Chair. I mean, from the very beginning of this meeting, we've seen Liberal members trying to find technicalities to try to delay what is very clearly a breach of privilege and to deny the instruction that we received from the Speaker. The Speaker asked to find out whether the committee is satisfied with the documents as provided to it. The documents have been provided to the committee, and for those who the slight exceptions to that, all of that information was available in August in the public domain. The media was very clear in reporting both the law clerk's letter and all of the other details relating to the massive censorship of these documents. So the search for a technicality I find very disturbing. This meeting now has gone on, according to the House of Commons website, for 180 hours, and I know we've been suspended for much of that time. And basically, government members of Parliament have been delaying for 180 hours what is a clear question of privilege that, as a committee, we have to decide upon and provide that information back to the Speaker. That is our role, to defend the committee's decision and the fact that the government clearly did not adhere to it. Censoring the law clerk has been very clear about this, censoring documents that they were not entitled to. And so we have that important response to give back to the Speaker. That's what this motion that Mr. Poilievre has suggested, with the amendment that I think we all accept. I think any other amendments are distinctly unhelpful. And I am very frustrated and dismayed by the attitude of the government. We've seen this in other areas. Within days of the pandemic striking, $750 billion in liquidity support was given to Canada's big banks. And yet people with disabilities have been waiting now for 7 months to get 1 cent of support from this government. The government delays when the people's interests are taken into consideration. When it's lobbyists, they just move right ahead. And I find this deplorable. If the government members were really interested in what has been raised as various points, the fact that we have put forward an amendment, the amendment is put forward in a way that should provide consensus from all members. We should be voting on the amendment, voting on the main motion. I will be voting against the latest amendment because I think that is basically a delaying tactic. And we should be proceeding to inform the Speaker about our opinion on the documents that were so heavily, wholly and substantially censored. And we should be able to move on to other important items. And I'm very dismayed that government members have now held up this committee hearing for 180 hours. We're in the midst of a pandemic. We should proceed to the vote, and we should move on to other business.
Okay, final one on my list is Mr. Sampson on the amendment to the amendment. That's the one we're on. Mr. Sampson.
Mr. Chair, I'm sorry to interrupt, Mr. Chair. Point of order. I'm also on that list. I thought I had raised my hand too.
Okay,
glad to speak whenever
okay,
it's appropriate.
Mr. Sampson and then Mr. Fragiskatis.
Merci, Monsieur le Président. Et puis, moi, je veux certainement appuyer.
Thank you, Mr. Speaker. I would like to, I'm in favor of the amendment to the amendment. And as my colleague Garrison explained, we should have the letters included in the documentation, but it doesn't allow us to make a decision and to confirm that this statement is correct. I explained it earlier in English, and I do it now in French because I cannot vote for a document that hasn't been confirmed by the clerk stating that it's exactly what it was before. And my second point is that Mr. Poilievre, who I think clearly demonstrated today that his strategy is, in fact, to not answer the question, the most important question, that is the motion by Ms. Derrick, which demonstrate clearly that the task of our committee right now is to make sure that we can move on to the very important consultation, the pre-budgetary consultation, in order to have the documentation. As I said earlier, I don't understand how come the Conservatives are losing time and not go to the pre-budget consultation when they, for month and month, are saying that we should have a budget and we should be able to demonstrate to Canadians that we have a budget. Well, this is a bit surprising to see how Conservatives are doing politics, to not take on the responsibilities that were demonstrated in the standing orders that were shared before. So, Mr. Speaker, thank you to let me say what I had to say on the subject.
I have two on my list, Mr. Fragiskatis and Mr. Gerritsen. Is there any others? Okay, Mr. Fragiskatis.
Thank you very much, Chair. I'll respond to the comments that were made by Mr. Julian a few moments ago. I think he raises some legitimate points. I will disagree on the substance of the points that he raised, but when he does make general arguments about the need for all of us to stay focused on Canadians, I think that is a perfectly reasonable point of view. It's one that I wish was adopted unanimously at this committee. We are facing, as a country right now, our most difficult moment, the most challenging time that the country has seen since the Second World War. That sentiment was reflected in a tweet Mr. Julian put out very recently, calling for support to Canadian food banks to be given. I see and applaud the government for standing with food banks, not just with one announcement for financial support, but with two, as we've seen in recent days. Those are the sorts of issues that we should be debating at this committee. Now, there are Canadians in need. I did notice that Mr. Julian failed to mention the importance of the CERB and how that has assisted folks. The CEBA, SECRA has been a program that has assisted, but there's been gaps there, admittedly. Let's talk about those things. Let's recognize Ms. Derowitz's motion to begin pre-budget consultations, which I remind this committee is absolutely mandatory. It is not a choice that we can make. Standing Order 83.1 specifically mentions the Standing Committee on Finance, our committee here, and calls on us to take pre-budget consultations that have to commence at a particular time and end at a particular time. It's not a choice. We are mandated to do that. So I very much hope that we can move towards that, and Liberal members have wanted to move towards that particular outcome. And actually, it's not just Liberal members. Let me commend our colleague Gabriel Samari from the Bloc, who has made clear that he wishes also to put forward a motion that would move this committee towards a pre-budget consultation. We need to commence that. There's no way around it. I know that the opposition wants to raise matters on the We Charity issue. And I've said this at the committee before. Those questions we're not trying to push those aside. They ought to be raised. Mistakes were made by the government. That is not being denied here. When you're flying the plane and building it at the same time, it is going to be the case that errors get made. The government has been forthcoming in a desire to release thousands of documents. I know the opposition still continues to raise its arms, wants to put forward motions that relate to those documents that, frankly, only the opposition understand. We have an amendment to an amendment here that I think is very, very reasonable, that provides greater certainty, greater clarification. It is one that calls on the opposition to compromise, to put some water in its wine, because the opposition will not get its way every single time at committee. What they were originally proposing was inappropriate, was coming very close, I think, if not entirely, to breaching the privilege of members on this committee, Mr. Chair. So what has happened? Mr. Gerritsen has very correctly put forward an amendment to that amendment that was suggested by Mr. Kelly, and I think it was suggested many hours ago. Here we are still debating. I fail to see I fail to accept the rationale for the amendment, as we heard from Mr. Fraser as well. There's deep challenges with that amendment for a number of technical but very important reasons. And so this amendment that's been put forward is one that can move us forward in a way that provides a lot of certainty and greater comfort for members of this committee who want to make decisions, but in a way that matches with recognized parliamentary procedures. If we were to accept Mr. Kelly's amendment as it stood on its own, then I worry that we would be going down a path that would set a very negative precedent for this committee. And that's not something I want to see happen. I know that's something that every member would be concerned about, quite rightly, Mr. Chair. So that's where I sit on this, sir, Mr. Easter. This is a matter that, yes, we need to decide upon. But when I hear, and as we've seen, close to 800 submissions from Canadian stakeholders from right across the country, and later I'm sure we'll be continuing this discussion, I do want to talk about some of those stakeholders. The Federation of Canadian Municipalities, Mr. Chair, has an interest in seeing support for municipalities continue. The federal government has stepped up in remarkable ways to support our cities and towns. But that needs to continue. That renewed federal municipal relationship that took shape beginning in 2015 needs to proceed with even more vigor, particularly now as cities and towns face great difficulties. The Chamber of Commerce, the Canadian Federation of Independent Business.
Mr. Chair, this rambling on has absolutely nothing to do with the amendment to the amendment.
Just going to say there, Mr. Falk, I believe, Mr. Fragiskatis, you're straying away from the discussion on the amendment to the amendment.
I'm bringing it back.
Point of order.
Yeah.
Mr. Chair, I would disagree with what Mr. Falk is saying. Mr. Julian raised specific points with respect to how the government was responding, and Mr. Fragiskatos has been addressing those points. So if you were going to allow Mr. Julian to make those points in the manner in which he did, just preceding Mr. Fragiskatos, I think you have to allow the opportunity to Mr. Fragiskatos to respond to that.
I believe we are straying into debate there, Mr. Gerritsen, so we'll ask Mr. Fragiskatos to pull it to make his argument why those points are on the amendment to the amendment, and then we'll move to the next speaker.
Thank you very much, Mr. Chair. I echo the rationale of Mr. Gerritsen. I was simply offering a rebuttal to what Mr. Julian put forward on the table, hence relevance. But I will bring it back specifically. When we continue to debate matters as we are debating the substance of Mr. Kelly's amendment. We are now, as Liberal members, we've heard Mr. Gerritsen put forward an amendment to that amendment. And I'm glad to continue to discuss that. I think there's important issues that are yet to be clarified and decided upon. But the more we focus on these technical issues, the more we are hindered from the need to focus on the lived realities of everyday Canadians. In my community in London, I know my constituents want us to focus on the COVID-19 response from an economic perspective. I know that constituents in every one of our communities feel exactly the same way. Why we have now descended into a political battle over this particular issue is beyond me. After, in the summer, we saw a number of meetings, meeting after meeting, and those meetings needed to take place. They should have taken place. It was good for this committee to focus on the We Charity issue. But now the Conservatives in particular, but the rest of the opposition too, have steered this committee, or are trying to rather, steer this committee towards an outcome that suits their political interests, and I fear not the interests of this country. This country right now needs its politicians at every level to focus on COVID-19 and the economic response. I urge my colleagues, Mr. Chair, to move in that direction. We can keep debating this amendment, but again, on relevance, it's standing in the way of us talking about the main thing. And the main thing right now is COVID-19.
Okay, I have Mr. Gerritsen and Ms. Zerowitz, if I haven't missed anyone. Mr. Gerritsen, on your amendment to the amendment.
Yeah, Mr. Chair, I mean, my comments were I raised my hand when I heard Mr. Julian speaking and some of the things that he was talking about, and in particular when Mr. Julian speaking to this amendment to the amendment started to go on about the lack of work that the government has been doing. The reality of the situation is, Mr. Speaker, 8.9 million Canadians have received CERB. 5.4 million Canadians received CERB between the World Health Organization declaring a global pandemic and a month and 4 days later. This government has been working around the clock, and more importantly, the officials for the government, the departments, the folks that have been coming in overtime, folks that have been working from home relentlessly to develop programs that would probably otherwise take 18 months to develop, Mr. Chair. You're seeing these programs come together like CERB in a matter of 5 or 6 days. And, for Mr. Julian to be making the point, which he just made a moment ago, that the government is not doing anything and is not doing meaningful things to support Canadians, I think is so incredibly disingenuous, especially when you look at the fact, and he brought up businesses, so to address his point specifically, 106,000 small businesses have received the commercial rent assistance in Canada. That's a lot of businesses, Mr. Chair, throughout our country that are receiving assistance from the federal government. We talk 994,000 employees have been helped as a result of that.
Point of order.
Mr.
Julian. As you know, Mr. Chair, you can occasionally stray, as I did for 20 seconds when you are intervening, but there is a question of relevance when people go on for minutes and minutes on something that is not related to the amendment at all.
So
you've taken far longer than 20.
If I understand correctly, Mr. Chair, Mr. Julian is setting the new rule of 20 seconds.
Mr. Chair, thank you. Thank you very much. So there is an issue of relevance here. Straying occasionally is quite different from devoting your entire speech to something that is not relevant to what is before the committee.
Well, if that's the case, Mr. Chair, and I accept that from Mr. Julian, I would love for him to tell me what the official amount of time is. He said 20 seconds. Is that written down somewhere, or is that his anecdotal perspective on it, or is that just how long it takes him to stray? So I guess as long as Mr. Julian can stray for 20 seconds. Sorry, your microphone is way up. I can't hear you trying to interrupt me.
Sorry, Mr. Gerritsen. I would say you've had quite.
But I do want to address that point of order.
You've had quite a bit of time to rebut the remarks of Mr. Julian, and I think that's fair ball. And now, if we could get back to the amendment and why you are proposing it and supporting it, that'd be great.
Well, I didn't get to finish it. I am not as skilled as Mr. Julian. I haven't had the years of experience that he does in order for him to be able to summarize his thoughts in 20 seconds or less. I apologize if it takes me longer to do that. I'm not as a skilled politician as he is. I apologize for that, okay? But I will say that I don't think that it's appropriate for Mr. Julian to arbitrarily be setting time limits in terms of how long one is able to stray off topic. You're either allowed to or you're not allowed to. Mr. Julian was allowed to, okay, but I guess it was only 20 seconds, so it was okay. And now I'm trying to address what he said, and I'm being called out of order from him for doing that. So I take exception to that, Mr. Chair. I'll leave it at that. I'll leave it at that.
Good,
and
Mr.
I'll turn the floor back to
Mr. Julian may not be able to set time limits, but I can as chair. So let's get back to relevance.
I'll cede the floor. I guess Ms. Zerowitz was after.
Okay, Ms. Zerowitz. Ms. Zerowitz, and then Mr. Fraser.
Okay, thank you so much, Mr. Chair.
And we're on the amendment to the amendment. Keep that in mind.
Yes, thank you. One can get lost in all these. Yes. Look, the reason I support the amendment, I think very basically, is that it will ensure that the package of documents that we have been provided a link to is complete, that the transmittal letters are included. And I think that is a fundamental reason why I am supporting the motion that my colleague, Mr. Gerritsen, has pointed out. I also want to point out that perhaps if there is some question as to whether the documents were redacted properly, I think perhaps the committee should get to hear from public servants who did the redactions and from the law clerk and the parliamentary counsel. Because right now, I think what's happening is we have to ensure that due process is provided to them. If after the committee has heard from these witnesses and it is still not satisfied, then it can take whatever action it deems necessary, but at least we afford due process to allow those who actually redacted these documents to actually speak to it. I would also point to some remarks that Minister Rodriguez, Parliamentary Assistant Kevin Lamoureux made in the House in September. He said the following: I want to make it clear that when the Finance Committee restarts on October 8 or 9, if it readopts the motion and it is not satisfied with the way that the government has provided documents to the committee, the government is prepared to work in good faith and with the committee to address any concerns that it may have. And I also want to point out again what the Harper Conservative government said in 2010 in response to the 22nd report of the Public Accounts Committee. It's a government that Mr. Poilievre and indeed a number of MPs currently at this meeting were served as an MP. The government believes that the departmental officials acted lawfully and diligently in these circumstances, and that the House and Canadians should be concerned with the committee's exercise of a claimed privilege in these particular circumstances. Necessity is the principle that underlies parliamentary privilege, which itself is a gift from the electorate to safeguard their rights. What, in the government's view, even if privilege were to extend so far, a very strong justification would be required for demanding the personal information of individual citizens, which in this case comprised 12 seconds of tape. In the same vein, the supplementary opinion of the 22nd report raises concerns that the committee did not consider the public interest when demanding the production of these audio cassettes. Regardless of the scope of the committee's powers, the government believes that parliamentary committee and all parliamentarians should, as a general principle and as a matter of convention, exercise restraint in the exercise of these privileges, particularly when the interest of individual citizens are affected. Those are my comments so far, Mr. Chair, and I'll cede over to Mr. Fraser, who was, I believe, after me.
I believe, Ms. Jansen, did you have your hand up, or were you just giving a wave?
Sure, you can add me on, but that's...
Okay, Mr. Fraser, and then Ms. Jansen.
Thanks, Mr. Chair. I'll do my best to speak to the sub amendment that's on the table, which deals really with the issue of to what extent the full disclosure that the government provided should be part of the evidentiary record going forward. I would suggest that if we're going to proceed with any of the motions on the floor, whether we're dealing with the main motion, the amendment, or the sub-amendment, the very least that we're owed as a matter, not we are owed, that the professional public services owed, is the opportunity to explain why they've made the redactions they've made before this committee embarks on a quest to find that their redaction of those documents constitutes a violation of the privileges held by members of this committee. If I, to make the, maybe lead with the point, effectively what's going on here right now with respect to the sub-amendment is those who've indicated their opposition to it have more or less said, we want to ensure the evidentiary record does not include the government's explanation as to its redactions, and instead want to find that those redactions constituted a privilege and make sure that we bury the evidence so we can't actually hear the government out as to why they may have done what they've done in terms of the document disclosure. I don't think that's the right approach. If we go back, I know Ms. Zarowitz actually quoted part of Kevin Lamoureux's, I believe it was Kevin Lamoureux, his remarks in the House when this made it to the floor previously. And with respect, Mr. Julian, I believe, made the point that there's obviously a breach of privilege with respect that the Speaker of the House of Commons found he could not find a prima facie case of privilege. So I would dispute the notion that it constituted one, notwithstanding his misplaced confidence. But in Mr. Lamoureux's remarks in the chamber, he said, the member argues that the government did not respect the Finance Committee's motion, while at the same time acknowledges that the government provided the requested documents to the clerk of the committee on August 8th, 2020. It was the opposition parties who wanted the law clerk to review these documents for the purposes of additional redactions. Liberal members on the committee agreed to the motion. I want to be clear, this is all still a quote. The government respected the Finance Committee's motion and provided the documents on time. The government also provided exactly the information that the committee requested in its motion. The only things that were excluded were matters of cabinet confidence and national security, which the committee spelled out in the motion. In preparing these documents in response to the committee motion, public servants respected their statutory obligations under law. The government provided the documents, which were 5,600 pages, on the date requested by the committee. Due to the time needed for the law clerk to do his work, Parliament was prorogued before they were properly given to the committee. As a result, not only did the Finance Committee cease to exist with prorogation, but the committee did not fully have these documents. It is therefore difficult for the opposition to argue that the government did not comply with the committee's motion when they were not in a position to take such a determination, since they did not have the formal law clerk approved documents. And then the portion which Ms. Zarowitz read out was, I want to make it clear, and this is important given the nature of the allegation of a violation of privilege, that when the Finance Committee restarts on October 8th or 9th, if it readopts the motion, it is not satisfied with the way the government has provided documents to the committee, the government is prepared to work in good faith, with the committee to address any concerns that it may have. So there has been an offer made to work with members of the committee. I would suggest that as a far cry from a violation of privilege. What I want to draw your attention to, though, and this is really the crux of the sub-amendment, is whether you're going to include all of the evidence, including specifically the government's explanation as to why certain redactions have been made. And I don't understand how someone could oppose the inclusion of the explanation by the government of the very thing that has been alleged to constitute a violation of privilege. If I actually take a look at some of the letters that the public servants prepared, or rather in response to the committee's motion, we can start with the letter from the clerk of the Privy Council, which is specifically the kind of document that I now understand the opposition does not want to form part of the evidentiary record going forward. In a letter on August 7th to David Gagnon, the clerk of the committee, Standing Committee on Finance at the time, the clerk wrote, "Dear Mr. Gagnon, I'm pleased to provide records from the Privy Council Office, PCO, that were requested under the motion adopted by the Standing Committee on Finance," which he referred to as the committee throughout the letter, "on July 7th, 2020, in relation to the committee's study on the We Charity and the Canada Student Service Grant. I'm also pleased to provide information related to the undertaking that I agreed at my appearance before the committee on July 21st, 2020, which were as follows: a detailed timeline of events, which was attached as Annex 2, is a timeline describing PCO's knowledge of and involvement with the file, a full list of organizations that were consulted on program development. On Friday, July 24th, 2020, the Department of Employment and Social Development, ESDC, provided the committee with a list of the National Coalition member organizations of the Canada Service Corps, who ESDC spoke with in March and April of 2020. I'm told that on April 9th, 2020, Department of Finance officials were provided with a report on stakeholder outreach regarding support for students during the COVID-19 context. PCO number 3, PCO media monitoring from the dates when Margaret and Alexandre Trudeau had speaking engagements for We Charity. I can confirm that PCO media monitoring does not have any media content of the public appearances of either Margaret Trudeau or Alexandre Trudeau. The PCO Media Centre monitors coverage of the Government of Canada priorities, programs, and services and does not monitor media coverage related to the relatives of the Prime Minister or their public appearances. The letter goes on. Number 4, all communications between PMO staff and PCO staff, the Finance Minister's Office and PCO, and the Finance Minister's Office and the Finance Department relating to the We Charity Contribution Agreement and the CSSG. These communications are included in Annex 1 and in the package from the Department of Finance. Names of number 5. Names
point of order. Are we now discussing the documents? I'm confused. I mean, if we could just vote on the amendment, we could dispense with this.
I think the point is Mr. Fraser is making the point through the letter of why that is important evidence as related to his sub-amendment or to Mr. Gerritson's sub-amendment. I believe so. It is relevant, Mr. Fraser.
Yeah, thank you, Mr. Chair, and that's precisely why I'm going through some of this evidence. I'm trying my best to highlight the context the government did provide that the opposition now seems intent to exclude from consideration as we move forward. I forget precisely where I was, but I believe I was just picking up on number 5. Names of participants, notes, and recording of mid-April meetings between Rachel Wernick, Michelle Kovacevic, and whether PCO personnel were aware of the meeting taking place and participated. And then he lists a series of bullets. I'm told that a teleconference between officials with the Department of Finance and ESDC was held on the evening of April 18th, 2020. It provides a list of the officials who took part. Perhaps I'll spare you from listing all of their names. He mentions near the end that no officials from PCO participated in the call or were aware of the meeting. There is no recording of the meeting. Meeting notes that were taken by Rachel Wernick and an email thread about setting up the call were attached at Annex 4. Number 6, due diligence analysis of any financial scrutiny undertaken with regard to the We Charity during this process. Attached at Annex 5, you'll find the detailed explanation prepared by ESDC of the controls embedded in the contribution agreement to ensure stewardship and appropriate use of funds, as well as a brief overview of the typical process used to evaluate projects and recipients. Further information relating to due diligence that was done by officials in relation to the Canada Student Service Grant is provided in Annex 1 and in the packages that other relevant departments are providing to this committee. Number 7, the full text of the contribution agreement. The document was provided to the committee by ESDC on Friday, July 24th, 2020. The letter goes on as the final page of this particular letter. As I noted when I appeared at committee on July 21st, 2020, my intent has been to be as expansive as possible in relation to the information that I provide. The committee's motion stipulates that cabinet confidences and national security information are to be excluded from the package. No information is being withheld on the grounds of national security, since the information does not so pertain. With respect to cabinet confidences, you will note that considerable information on the Canada Student Service Grant that were cabinet confidences is being provided to the committee. This is in keeping with the public disclosures of information on this matter made by members of the Queen's Privy Council for Canada. A principled approach was adopted to this information to ensure a non-selective application of the protection afforded by cabinet confidentiality. As a result, considerable information on the Canada Student Service Grant that would otherwise constitute cabinet confidences is being released. Information not related to the Canada Student Service Grant that constitute cabinet confidences is withheld and identified as not relevant to the request. In this package, I have also chosen to disclose certain personal information contained in the Privy Council records relating to individuals working in ministers' offices, as well as personal information of individuals who work for We. I have decided to disclose this information because, in my view, the public interest in disclosure clearly outweighs any invasion of privacy. I notified the Privacy Commissioner of my intention to disclose this personal information, as I am required to do under the Privacy Act. I have decided to protect the phone number and email addresses of We employees other than Craig and Mark Kielberger. In addition, there are few references to the family members of a public servant, and I have chosen to protect that information. In my opinion, the public interest in disclosing this type of personal information does not clearly outweigh the invasion of privacy. Similarly, because I believe that it is in the public interest to do so, I am prepared to issue a limited waiver of solicitor-client privilege as it relates to the information that is being provided by departments in response to this motion and my undertakings. Lastly, I wish to draw to the committee's attention to a note to file prepared by Christiane Fox, the Deputy Minister of Intergovernmental Affairs at the Privy Council Office. In that note to file, Ms. Fox provides a clarification regarding references in 2 email exchanges, Annex 6. I trust that the committee will find the above explanations helpful in its considerations of the enclosed material. Sincerely, Ian Shugart, Clerk of the Privy Council Office. The final portion of the letter that I've read, I trust the committee will find the above explanations helpful in its consideration of the enclosed materials. I'm sure Mr. Shugart will be interested to hear that the community it not only is seemingly not finding them helpful on the opposition side, but is actively trying to exclude that explanation from the evidentiary record going forward. Perhaps the transmittal letters that provide context for these documents that are now the subject of the motion. Perhaps those letters are in fact the most important documents amongst those that were disclosed. As you can see from the Clerk of the Privy Council's letter, more information was actually provided than was requested from the committee. Matters that constitute cabinet confidence were provided, as well as other information. In fact, Mr. Chair, I'd suggest the transmittal letters weren't necessarily requested by the committee, but certainly they've become relevant because they provide context to the rest of the documents that we're discussing, and we shouldn't be trying to hide the government's public explanation of the redactions that in fact took place. The government frankly went above and beyond what was required in responding to what the committee had asked for. It's not just Mr. Shugart who had a letter that provides a similar kind of context. In fact, the different departments have done something very similar. If we actually look at the letter from the Deputy Minister of Finance, which I don't have the date before me, I believe it was also on the same day. In any event, I will point out the importance of this particular letter. He says, "Dear Mr. Gagnon," again sent to the clerk.
Point of order, Mr. Chair.
Point of order, Mr. Fragiskatis.
I'm not one to interrupt, but I don't see Mr. Poliev on screen again. He hasn't been on screen in a while. Is he all right?
I don't believe that.
Okay?
I don't believe that's a point of order. Wrong? We'll go back to you, Mr. Fraser.
Sure. I'm back to the Deputy Minister of Finance's transmittal letter, which is being sought to be excluded from the evidentiary record going forward. The Deputy Minister wrote to Mr. Gagnon, then Clerk of the Standing Committee on Finance, where he said, "Dear Mr. Gagnon, on behalf of the Department of Finance, I'm transmitting the attached documents to you in response to the motion adopted by the House of Commons Standing Committee on Finance on July 7th, 2020. He copied the text of the motion before the committee in that letter, that pursuant to Standing Order 108 sub 1 sub A, the committee order that any contracts concluded with We Charity and Me to We, all briefing notes.
Mr. Fraser, I hate to interrupt you, but the translators are having a little difficulty with the speed you're going. So if you could just slow down
I think he needs to start over, Mr. Chair.
No, just slow down a smidgen and we'd be all right.
Well, if we wanted to give them a real challenge, I would do my best to do this in French and see if the translators can make me sound sensible. But I think a few more years of practice. Thank you, Mr. Chair, and to our translators. I'll do my best to speak at a pace that is perhaps easier to translate. So picking up from the motion, I'll carry off roughly where I thought I was. From senior officials prepared for or sent to any minister regarding the design and creation of the Canada Student Service Grant, as well as any written correspondence and records of other correspondence with We Charity and Me to We from March 2020 be provided to the committee no later than August 8th, 2020, that matters of cabinet confidence and national security be excluded from the request, and that any redactions necessary, including to protect the privacy of Canadian citizens and permanent residents whose names and personal information may be included in the documents, as well as public servants who have been providing assistance on this matter, be made by the Office of the Law Clerk and Parliamentary Counsel of the House of Commons. Documents, we're going back to the Deputy Minister's text in his letter rather than the quote of the motion now. Documents are also enclosed as part of this package related to the undertakings of the Clerk of the Privy Council and Secretary to Cabinet, Mr. Ian Shugart, following his testimony to the committee on July 21st, 2020. The committee's motion stipulates that cabinet confidences and national security information are to be excluded from the package. No information is being withheld on the grounds of national security. The same was true with Mr. Shugart's letter. Since the information does not so pertain, with respect to cabinet confidences, you will note that considerable information on the Canada Student Service Grant contained in cabinet confidences is being provided to the committee. This is in keeping with the public disclosures of information on this matter made by members of the Queen's Privy Council for Canada. A principled approach was taken with respect to this information to ensure a non-selective application of the protection afforded by cabinet confidentiality. As a result, considerable information on the Canada Student Service Grant that would otherwise be protected as cabinet confidence is being released. Information not related to the Canada Student Service Grant that is contained in cabinet confidences is withheld and identified as not relevant to the request. With respect to personal information, the department is obliged to protect such information under the Privacy Act unless the individuals to whom it relates consent to its disclosure or disclosure is otherwise authorized in certain specified circumstances or the public interest in disclosure clearly outweighs any resulting invasion of privacy. That comes back to the point I made at the outset of this meeting, Mr. Chair, that there is in fact a natural tension that does exist where you have the committee demanding one thing and the public service who's subjected to legislation, including the Privacy Act, where things are not as clear as we may like them to be. In any event, the letter continues, reasonable efforts were made by the department to obtain consent. Where consent was not given, the department found that the public interest in sharing the information with the committee outweighed any invasion of the individual's privacy. As such, disclosure is being made pursuant to subparagraph 8 sub 2 sub eb sub 1 of the Privacy Act. As required by that act, the Privacy Commissioner was informed of our decision. In very limited cases, personal information was redacted from these records as consent was not obtained from the individuals concerned, nor was the department able to conclude that the public interest in disclosure clearly outweighed the invasion of the individual's privacy. The type, of personal information that remains protected consists of the identity of unrelated third parties where their opinion or view relates to an unrelated matter to this inquiry, as well as personal email addresses and phone numbers. With respect to pages 190 and 194 through 213, I referred to this earlier in the meeting as well, Mr. Chair. Further to consultation with the originating stakeholder, authorization to disclose this information was not given as it constitutes personal information as defined under the Privacy Act. Furthermore, this information is considered proprietary to the third party. The contents of this information is not relevant to the funding agreement or the student grant program. Therefore, it has been severed in its entirety. That would explain certain redactions made at those page numbers. For clarity, note that there were a series of emails between finance officials and staff in the Minister of Finance's office regarding next steps. Of note, an email from the Minister's office to Michelle Kovacevic on April 18th lists a series of items for the department to follow up on, as well as some items, quote, we will address. In this instance, we is a typographical error and refers to the Minister's office, not We Charity. Also of note, the Annex 4, dated April 19th, contains an error that was corrected verbally in an April 21st briefing with the Minister of Finance. While page 6 of the note references a cost estimate of $0.8 billion for the proposal plus potential administration costs, page 7, 8, and 9 recommend setting up aside up to $1 billion, brackets $900 million for the initiative and an additional $100 million for implementation and associated costs. The correct recommendation, $900 million, is reflected in the April 21st version of the note, also enclosed in the package. Finally, following the April 21st briefing, a draft ministerial decision page encloses the first page of the April 21st, 2020 version of the note, was prepared and routed to the Finance Minister's office for review and approval by the Minister of Finance. This ministerial decision page was not formally approved by the Minister of Finance. A formal decision was later made by the Prime Minister and is reflected in the package. Yours sincerely, Paul Rochon, Deputy Minister of the Department of Finance. Again, we're seeing in these letters that members of the committee are seeking to have excluded from consideration important context that actually puts into context the very specific reasons redactions would have been made. We're seeing an example of openness and divulging more information, in fact, than the committee requested when you look specifically to those items that would ordinarily be subject to cabinet confidences. But Mr. Chair, this is not just one or two departments. Several of them have included these kinds of letters.
Point of order, Mr. Chair.
Yeah, go ahead, Ms. Jensen.
I'm just concerned the reading into record of the documents. I mean, although I love Mr. Fraser's dulcet tones, it's lovely to hear him read. If you look from procedure and practice, the chair can curtail prolonged debate by limiting members' speeches to points which have not already been made. The freedom of debate enjoyed by members does not extend to the repetition of arguments that have already been heard. In the context of the legislative process, this restriction applies to members' remarks only within the same stage of debate on a bill. Arguments, I'll slow down for the translators. Arguments
that'd be a good idea.
At one stage may also legitimately be represented at another. Finally, the rule against repetition has been used by speakers in various other ways to assist the House in making efficient use of its time. Speakers have ruled against the tedious reading of letters, even when they are used in support of an argument. So I wonder if, as I said before, at the rate that we're going, I'm afraid Mr. Fraser is going to end up reading all 5,000 pages into the from the documents into a record. I wonder if we could just go to a vote.
But Mr. Chair, just on that point of order,
yes,
what Mr. Fraser has been reading is not repetitious. He's reading in the important parts of those letters, and I think that it's important for that to be on the record. So, if Ms. Jensen's point is that it's repetitious, it isn't.
Well, I think my point is that we are now reading the documents into record, which we're just saying, let's vote, let's move on, let's get it over and done with. That's what we would love to get back to work.
I think that the point is that Mr. Fraser is putting it on the record so that we have it on the committee's the blues, so that it's on the record there.
Point of order, Mr. Chair.
On the same point of order.
I was going to say that it's perfectly fine for Ms. Jansen to interject, but I don't see the relevance here. I don't think that Mr. Fraser is repeating. He's making a point. Now he's using a number
I wonder,
of different
on this point of order, I wonder if the chair could just make a ruling.
I was in the middle of a point of order.
Yeah.
In the middle of a point
so
of order.
was I. Not sure who says the precedence.
So okay, we'll hear everybody on the point of order, Mr. Fragiscatis.
There was another. Yes, I finished that point. Related though, and it's about the committee meeting itself. So not entirely related, I'll concede. But I continue to see Conservative colleagues dropping out of this meeting. Mr. Kelly
that's
has
not
made a return.
That's not a point of order. That's not a point of order. Mr. Fragiscatis, I'll go to Ms. Jansen if she wants in her point of order, and then
yes,
back to Ms. Fraser. Go ahead, Ms.
I'm just wondering if you could rule on that point of order so that we could move on.
Mr.
Chair,
I can't. Yes, Mr. Fraser.
Before you offer a ruling on the point of order, my understanding is that there would be an opportunity to debate the appropriateness of the point of order before you do offer a ruling. And if I may offer an explanation, the point of me going through these letters and offering commentary on them is to demonstrate that the transmittal letters, which the members who are opposing the sub-amendment on the floor are trying to exclude from the evidentiary record before this committee. In order to determine whether those letters should be excluded from the record formally in our sub-amendment, I do think it's relevant for the committee to actually hear what those letters said. I can't imagine something that would be more relevant to a discussion about transmittal letters than transmittal letters.
Point of order.
My point of order, Pat, Mr. Kelly.
The substance of this is not transmittal letters, and the also in the procedure in practice, procedure in practice is not merely repetition that are grounds upon which the speaker, the chair, may rule against excessive reading into the record. If doing so is vexatious and designed, as this clearly is, to simply avoid a vote, the chair may rule it out of order. So I bring those points to your attention.
I have a point of order too, Mr. Chair, but
okay,
not on this point. If you could.
Okay, it's not on this point. I do the letters that Mr. Fraser has been reading are really relative to the sub-amendment, and I haven't heard, although they go to somewhat the same point, there's different information in each letter that goes to the relevance of the sub-amendment, so I'm going to allow it. Mr. Fraser, back to Mr. Garrettson.
I believe Mr. Garrettson actually had a point of order, Mr. Chair.
Yeah.
So I know that you've ruled on the necessity of a member's screen to be on, but I respect that. But I just want to know what you deem, Mr. Chair, to be a quorum. For example, if we were sitting in a committee room and people actually started leaving the room, you would know if we no longer had a quorum. When people are turning off their video cameras, we don't know if they're still there listening, or if Mr. Poilievre has gone to Starbucks, or what's going on. So how are you determining, if enough screens go off, whether or not you still have a quorum to continue the meeting, Mr. Chair?
I haven't seen, I would determine it based on the people that I can see, and we haven't seen below that numbers yet.
Given the, he has a Starbucks. He came back with a Starbucks. He could have brought one for everybody at least.
I have a point of order too. Is it going to be all right?
Just hold on, Ms. Jansen. Are you done with your point of order? Okay, Ms.
Is it to my point of order, Mr. Speaker? Because I would really like to hear your. Okay, great. I'd like to hear a ruling on that.
I would like to know. I would like to know whether or not bathroom breaks are all right if we turn off the video.
Yes, Ms. Jansen, for a very short time, and when I need a bathroom break, we're going to have to suspend for 3 minutes. In any event, on Mr. Garrettson's point, I certainly would prefer if people would leave their cameras on, so that we can see the members are present. When we're at an official committee meeting in person in Ottawa, the people are there, and if they leave the room, it's quite easy to see who's there and who's not. All I see in some cases, in this case, is the names up, and I really don't know if they're present or not.
So just to that point,
if the pictures on the screen drop below what is needed for quorum, then
the meeting would have to stop. So just for clarity on that point of order, Mr. Chair, if, for example, just hypothetically speaking, Mr. Poilievre was not on the screen, and hypothetically speaking, all the Liberal members dropped off, then you wouldn't have quorum and you'd have to end the meeting. Is that correct?
I would have to check the parliamentary rules on that and get clarification.
Okay, just wanted to check on that.
Then we go to a vote.
All right, now we're back to Mr. Fraser.
Thank you very much, Mr. Chair. Where I had just finished going through some of the information included in the letter from the Deputy Minister of Finance that the amendment to the main motion would exclude, and that is the subject of the sub-amendment. The next letter that was submitted in the government's disclosure package, but it would not be adopted before this committee under current circumstances, came from the Deputy Minister of Innovation, Science and Economic Development. Similarly, was sent to Mr. Gagnon, and similarly, and perhaps I'll spare some committee members the pain of hearing this part again, which is repetitious. It began with the copying and pasting the language from our July 7th, 2020 motion, which I've previously read into the record. So, Ms. Jansen, I'll spare you a few minutes of the voice you've indicated you enjoy so much. In any event, after the copy of the motion, the text of the letter reads, Innovation, Science and Economic Development Canada has retrieved all records from within the department that respond to the committee's motion. You will find the results of that search enclosed for the committee's consideration. It should be noted, however, that in the preparation of this package, care was taken to obtain consent to disclose personal information from exempt staff referenced in the material, and in collaboration with other government departments, the staff from We Charity, in accordance with the provisions of the Privacy Act. In addition, the committee's motion stipulates that cabinet confidences and national security information are to be excluded from the package. No information is being withheld on the grounds of national security, since the information does not so pertain. With respect to cabinet confidences, you will note that the information on the Canada Student Service Grant that was a cabinet confidence is being provided to the committee. This is in keeping with the public disclosures of information on this matter made by members of the Queen's Privy Council for Canada. A principled approach was adopted to this information to ensure a non-selective application of the protection afforded by cabinet confidentiality. Information not related to the Canada Student Service Grant that constitutes a cabinet confidence is withheld and identified as not relevant to the request. I said too, and this came from Simon Kennedy. I said too, made the point that they were providing disclosure in accordance with what the committee had asked, explained in instances where there was differentiation why that may not be the case, and in fact explained where cabinet confidences have nevertheless, documents that would have otherwise been subjected to cabinet confidences were nevertheless disclosed. If we look at the letter from the Secretary of the Treasury Board, also sent to Mr. Gagnon, it similarly started out that in response to the motion adopted by the House of Commons Standing Committee on July 7th, 2020, concerning any contracts concluded with the We Charity and Me to We, all briefing notes, memos, and emails, including the contribution agreement between the government and the organization, from senior officials prepared for or sent to any minister regarding the design and creation of the Canada Student Service Grant, as well as any written correspondence and records of other correspondence with We Charity and Me to We from March 2020, please and find enclosed bilingual copies of Treasury Board of Canada Secretariat records. It should be noted that in preparation of this package, care was taken to obtain consent to disclose certain personal information from relevant exempt staff referenced in the materials. Similarly to the other letters, this particular one at Treasury Board indicates that the committee's motion stipulates that cabinet confidences and national security information are to be excluded from the package. Again, no information is being withheld on the grounds of national security, since the information does not so pertain. With respect to cabinet confidences, you'll note there is considerable information on the Canada Student Service Grant that were cabinet confidences, is being provided to the committee. Excuse me. This is in keeping with the public disclosures of information on this matter made by members of the Queen's Privy Council for Canada. A principled approach was adopted to this information to ensure a non-selective application of the protection afforded by cabinet confidentiality. As a result, considerable information on the Canada Student Service Grant that would otherwise constitute cabinet confidences is being released. Information not related to the Canada Student Service Grant that constitute cabinet confidences is withheld and not relevant to this request. The same principled approach was also applied to the second enclosed package of TBS documents, Treasury Board Secretariat, which is provided in support of the commitment by the Clerk of the Privy Council to provide additional information on due diligence in the Canada Student Service Grant subsequent to his appearance on July 21st, 2020. Additionally, because I believe that it is in the public interest to do so, this package includes information being made available as a result of a limited waiver of solicitor-client privilege as it relates to the information that is being provided by Employment and Social Development Canada. While many TBS employees continue to work virtually, guided by public health measures and focused on curbing the spread of COVID-19, these two packages provide, to the best of my knowledge, as of August 7th, 2020, the TBS documents in response to the above noted request for production of papers and due diligence line of inquiry. We're seeing a pattern here. One, that these transmittal letters, again, which are the subject of the sub-amendment, they provide the context necessary. They refer to the committee's request for information from the different government departments. These transmittal letters, which would not be part of the evidentiary record going forward under the proposed motion or proposed amendment to the main motion, nevertheless continue to drive home the point that we have made redactions in accordance with what the committee has requested. And in fact, particularly when it comes to cabinet confidences, we have nevertheless disclosed material that would ordinarily be subject to Crown privilege or cabinet confidence. When we look at the, there's various other departments as well, Mr. Chair. The letter from, I just finished with ESDC, or I think it was TBS rather, but if we look at the letter from the Deputy Minister of ESDC and the Senior ADM of ESDC and Chief Operating Officer for Service Canada, as well as the Senior Associate Deputy Minister of Diversity, Inclusion of Youth, that letter makes similar points that they too, and this evidence shouldn't be excluded from the record because it provides important context. They too wrote on August 8th to then Clerk, Mr. Gagnon, of the Standing Committee on Finance. And they said, "Dear Mr. Gagnon, on behalf of Canadian Heritage and Employment and Social Development Canada, please find enclosed electronically all records in the original language of drafting requested under the motion for production of papers related to the Canada Student Service Grant and the We Charity and Me to We, adopted by the Standing Committee on Finance on July 7th, 2020. Due to the significant volume of documents requiring translation, a partial package containing the translated records is therefore, translated records is here enclosed. Over 400 translators have been working on the documents for some time, and we will provide the rest as soon as possible. As discussed during committee testimony, Canadian Heritage, with support from Employment and Social Development Canada and Service Canada, are working diligently to ensure that students negatively affected by COVID-19 receive much needed support as they seek to further their studies in a time of reduced employment opportunities. As you will see from the enclosed documents, the approach adopted by the departments is to disclose as much information as possible within the scope of the motion to further the committee's breadth and depth of understanding of the design and creation of the CSSG. The committee's motion stipulates that cabinet confidences and national security information, are to be excluded from the package. No information is being withheld on the grounds of national security, since the information does not so pertain. With respect to cabinet confidences, you will note the considerable information on the Canada Student Service Grant that were cabinet confidences is being provided to the committee. This is in keeping with the public disclosures, and I won't repeat that portion because it simply goes on to make the exact same point as the previous letters, that in fact, because the committee requested national security and cabinet confidences be respected, the government nevertheless took the step in its redactions to make public certain measures that in these transmittal letters, they've indicated their desire to keep public matters that would ordinarily be subjected to cabinet confidentiality. The letter continued after that same paragraph we've seen before. Recognizing the significant public interest, we have included relevant personal information in the collection, but not personal opinions, in accordance with Section 37 of the Department of Employment and Social Development Act and Section 8 sub 2 sub M of the Privacy Act. We have communicated this decision of the Office of the Privacy Commissioner. Similarly, because we believe that it is in the public interest to do so, we are prepared to issue a limited waiver of solicitor-client privilege as it relates to the information that is being provided by Employment and Social Development Canada. The information enclosed consists of 4 parts. 1, the contribution agreement signed between the Government of Canada and the We Charity Foundation. 2, a list containing the names of Government of Canada representatives who received a proposal from We Charity for funding to deliver a 3-month youth summer service program and a 12-month youth entrepreneurship program for youth 16 to 29. 3, a set of documents that illustrate key moments in the design of the CSSG, and 4, a larger collection of communications, documents, and meeting notes connected with the development and decision-making processes for the CSSG. In addition to the request from the committee, Canadian Heritage and Employment and Social Development Canada have also received a significant number of access to information requests related to the CSSG. Some of these requests go beyond the scope of the committee's motion. We will make the committee aware of ATIP releases related to the CSSG as they occur. We trust that the committee finds the enclosed material useful for its work. And that was signed by the Deputy Minister for ESDC, Graham Flack, and the Senior Associate Deputy Minister of ESDC and Chief Operating Officer for Service Canada, Laurie McDonald, and Gina Wilson, Senior Associate Deputy Minister of Diversity, Inclusion and Youth at Canadian Heritage. As it's been made clear, Mr. Chair, by these transmittal letters, following the adoption of the motion of Finance Committee, our public service worked really hard to gather the relevant documents and provided the committee with literally more than 5,000 pages. As has been noted, the motion adopted by the committee stipulated that matters of cabinet confidence and national security be excluded from the request, and that any redactions necessary, including to protect the privacy of Canadian citizens and permanent residences whose names and personal information may be included in the documents, as well as public servants who've been providing assistance on this matter, be made by the Office of the Law Clerk and Parliamentary Counsel of the House of Commons. The exemptions were applied by our nonpartisan public service. Deputies at ESDC stated in their transmittal letter, which is the subject again of the sub-amendment, that the approach that was adopted was to disclose as much information as possible within the scope of the committee's motion. No exclusions were made on the ground of national security. The other subject that the committee said, government, we don't want documents from you, was on cabinet confidences. The government decided, nevertheless, where it was appropriate, to waive cabinet confidences and disclose those documents, even though the committee never asked for them. A substantial amount of information that would normally be under cabinet confidence was, in fact, provided to the committee. Information that would fall under cabinet confidence, but was not related to the Canada Student Service Grant, and therefore wasn't relevant.
Is this not now debate? I don't know. He seems to be debating that this is all important.
On your point of order, no, I don't believe it is debate. I believe he is making the argument why this is why these letters are relevant to the sub amendment, and why he, I guess, I expect he's speaking in favor of the sub amendment, and why other members should agree with them and see these documents as important to be tabled. Mr. Sampson, while I'm on this point of order of Ms. Jansen's, I would say to the benefit on the question that was raised by Mr. Gerritsen, that, I mean, we all know that quorum is a majority, but what would happen if I do not see a majority of members in person on my screen, I would suspend until such. I would have to suspend until such time as the members come back. It wouldn't be an adjournment. It would be a suspension until we again had quorum. So that point is cleared up. Mr. Sampson.
Thank you, Chair. I find it quite interesting.
Is this in a point of order?
Yes, on this point of order, which is really important because I want to thank Mr. Fraser for the important information that he's providing the committee and Canadians. It's essential. That's why we want to make sure that all the information, which is those letters that he's making reference to, is providing us key information into this debate. But what I find quite amazing is that here the opposition is willing to limit the information that is provided on this sub-amendment, but their initial motion, they were complaining that they didn't have all the information. So it's kind of, I don't know where they're going. Either they want all the information so that we can take a decision, or they don't want all the information. But this sub-amendment,
I believe you're straying into considerable debate there, Mr. Sampson. I will go back to Mr. Fraser, who had the floor.
Thank you, Mr. Chair. And as much as I admire my fellow Nova Scotian and colleague, that may be debate, but perhaps he'll want to jump into the debate when I wrap up. And to Ms. Jansen's
point of order.
Point of order. Sorry, Peter, my mic's down. Point of order, Mr. Julian.
Thank you very much, Mr. Chair. And I will compliment Mr. Fraser and the person who prepared his presentation. I don't agree with it, but it is carefully prepared, and I did want to compliment him on that.
I don't believe that's a point of order, but I bet you he takes the compliment. Mr. Gerritsen.
I was just going to point out that's not a point of order.
Okay, well, you're correct. Mr. Fraser.
So I've now got compliments from the NDP, from Ms. Jansen on the tone of my voice, and Mr. Fragiscato's jumped to my defense. So if only we had a Green Party member here, and of course our representative from the Bloc, who I don't see because he's darkened. I'll wait. Perhaps I'll receive one in French before the meeting is done. Mr. Chair, look, I will wrap up here. And to Ms. Jansen's point, this is very much debate, but this is debate on the sub-amendment, which I think is appropriate. The crux of my point is this. The transmittal letters are the subject of this sub-amendment. As it stands, under the main motion or the proposed amendment, the transmittal letters and other documents that specifically explain why the government made the redactions it did are being sought to be excluded by members of the opposition. I think that if this motion goes anywhere, it should include the government's explanation before this committee holds the government or declares the government to have violated its privilege for as a result of the redactions that it's made. Specifically, the motion before the committee, as I've repeated a number of times, as was pointed out, and to address Mr. Julian's point, that to the people who prepared my presentation are the nonpartisan public servants who've written those letters that are sought to be excluded from the committee's record right now. But the points that each of those letters made are largely this. The committee never asked for anything that was subject to cabinet confidence or that would compromise national security. So to the extent that any redactions touched on cabinet confidence or national security, those are really not an issue for this committee. In fact, there were no redactions made on the basis of national security. We know that because the transmittal letters say so. The committee may not formally know that if they don't include the transmittal letters in the record. The second category of documents that was not subject to a request by this committee is cabinet confidences. Similarly, if the argument is that a failure to divulge cabinet confidence constitutes a violation of this committee's privilege, there would be no basis. And in fact, I don't think that would be disputed. Nevertheless, the government actually did disclose material that would ordinarily be subject to cabinet confidence. If I then
point of order, are we not again entering into debate? I mean, the idea was that you would receive at the committee unredacted documents that would go to the law clerk to get redacted. That didn't happen, and now you're debating.
Point of order, Mr. Chair.
Yeah, I have a point of order as well, and I would like to address that point of order.
Address the point of order. Was it Mr. Fraser that came in on the point of order, and then I'll go to Mr. Gerritsen, and then I'll tell you my thoughts.
In fact, Mr. Chair, this is debate. I'm not speaking on a point of order. I'm speaking in the debate on the sub-amendment.
Right.
So I think my debate would be appropriate. But I can't disagree with Ms. Jansen. It's very much debate.
Mr. Gerritsen.
I was just going to point out the same thing. Mr. Fraser is not speaking to a point of order right now, Mr. Chair. He's speaking to the actual amendment to the amendment. So I don't know where the confusion is, but
I fully understand that he is speaking to the sub amendment and summing up his points.
I really am. I promise. I really am. The final point is the other category of documents that would have been made subject to redactions by the law clerk. So anything that was redacted based on national security or cabinet confidence would properly be redacted because the committee actually never requested those documents. The second category or grouping of categories is things like privacy, personal information. The committee has asked that the law clerk make those redactions. The independent civil service points out in their transmittal letters that the certain committee members are trying to exclude from the record that in fact they have certain obligations that they are required to adhere to, including those under the Privacy Act. They explained the process by which they made decisions as to when and whether they should redact those pieces of information. And so far as I can tell, the redactions that would have been made under that heading relate to things like personal information on family members of people who may have been involved in some of the decision making, personal phone numbers, email addresses, but not the contents of correspondence for people who really had no say in this. So at the end of the day, my point on the sub-amendment is that if we're going to have this go anywhere, the transmittal letters give explicit direction as to what process the government implemented and what factors they considered when they were making those redactions. And I think that's relevant to the work of this committee. Thank you.
Okay, thank you. And I have next on my list, Ms. Jansen. I might say, though, I am looking at Mr. Poilievre's screen, and I see a bright light there, Pierre. I'm wondering, is that a light in the ceiling or is that you? Go ahead,
I'm going to go with the ceiling.
Go ahead, Ms. Jansen.
Sorry, I have no idea where we're at now. Are we debating?
We are debating the sub amendment, which is the amendment to the amendment. That's where we're at the moment on the transmittal letters.
Okay, so I'm just hoping that that's all I'll say now, because it's just going on and on and on, is let's get to a vote. I think that'd be awesome. Thank you.
Okay, do I see any others on the list, or can we go to a vote? I see Mr. Pragaskatis. Mr. Pragaskatis.
Thank you very much, Mr. Chair. I know Ms. Jansen is anxious to go to a vote, but there's still matters that need to be put on the record in relation to the amendment to Mr. Kelly's initial amendment. It's been a long day for all of us. Forgive me if I do read at a pace that is not a normal pace. I'm going to try and get through something that, as I said, needs to be put on the record here. I'm not intending to read slow, Mr. Chair, but it's just when you're staring at a screen for hours on end, your eyes are likely to play some tricks on you. If not tricks, then it's a painful experience to look at a screen for hours on end. Let's put it that way. In any case, Mr. Chair, colleagues, I want to offer all of you a bit of a deep dive on the documents that were provided to opposition parties, and to detail how the redactions completely adhere to the motion that was tabled before this committee. I also want to point out that this work was undertaken by the world-class professional public service, nonpartisan public service that we have, that has helped us in such incredible ways through the COVID-19 crisis, but well beyond that, in accordance with their various obligations. Let me start by reflecting on the motion that was tabled before this committee that reads as follows. That pursuant to Standing Order 1081A, the committee order that any contracts concluded with We Charity and Me to We, all briefing notes, memos, and emails from senior officials prepared for or sent to any minister regarding the design and creation of the Canada Student Service Grant, as well as any written correspondence and records of other correspondence with We Charity and Me to We from March 20th, be provided to the committee no later than August 8th. That matters of cabinet confidence, and these points are particularly relevant here, that matters of cabinet confidence and national security be excluded from the request, and that any redactions necessary, including to protect the privacy of Canadian citizens and permanent residents, whose names and personal information may be included in the documents, as well as public servants who have been providing assistance on this matter, be made to the office of the Law Clerk and Parliamentary Counsel of the House of Commons. So that was the motion. Let me return to the substance of my remarks. This deep dive begins with the documents provided by the Privy Council Office. As an example, Mr. Chair, let's start with page 49. And I'm going to list pages, Mr. Chair, that might not align with what's been received most recently, but in any case, it doesn't take away anything from the substance of my my remarks here.
And this is relevant to the sub amendment, is it?
Yes, it is, Mr. Chair.
Okay.
And I'll be making that that argument throughout. Let's, as I said, start with page 49 of the PCO document release. There are a number of programs listed unrelated to the Canada Student Service Grant that have nothing to do with the motion at hand. Committee explicitly did not ask for this. However, in keeping with the motion, items related to the CSSG were released. Next, there's an email from Mr. Kielberger on pages 78 to 79 of the PCO document. Excuse me, of the PCO document released. It's from Mr. Kielberger to Ms. Catherine Fox at PCO. Yet the only redaction present is a private citizen's email address. This is Mr. Kielberger's assistant. This is private information and has no relevance whatsoever to this process per the terms of the motion at the committee. This is, again, all about giving context, all about relating to the issues that we are discussing, and I think a fulsome understanding, Mr. Chair, of the wider context.
Point of order. I'm a wee bit confused again. Sorry. I thought you didn't have the documents, but now you suddenly are reading from the documents. Is that correct?
The member is a new member to the committee, yes. Mr. Chair. Yes, that much.
You are reading from the documents that you said you didn't have before. Is that correct?
No, I'm sorry, Madam Ms. Jansen. You're misunderstanding. I'm not reading from the documents that you're raising here. I'm giving context to the entire discussion. So let me continue. Let me turn attention to pages 105 to 110 of the PCO release. A number of programs listed are unrelated to the CSSG and have nothing to do with the motion at hand. The committee explicitly did not ask for this. Still, where relevant, if there was mention of the CSSG, it was disclosed, for example, on page 107. Documents like this are a prime example of the documents that Mr. Poilievre was waving around, as we remember, many weeks ago in what some have termed quite correctly a stunt of a press conference. Items requested by the committee related to the Canada Student Service Grant. This cabinet confidence document, might I add, was released with all information related to the CSSG contained therein. The nonpartisan professional public service redacted matters that were not related to the committee motion. What was not only to be expected, but both appropriate and prudent. Sorry, which was not only to be expected, but appropriate and prudent. Another example, Mr. Chair, pages 189 to 190 of the PCO release. We are looking at an email between Ms. Wernick, Rachel Wernick at ESDC, and Ms. Tara Shannon from PCO. As the motion expressly stated, unrelated cabinet confidences were removed. As well, Ms. Wernick's cell phone number was removed. I think we can all agree it wouldn't be appropriate for that number to be public. I hope that is absolutely vital. And the more we push this, I worry that certain members of the committee might not take that into account, but I'll leave that aside. And in fact, the motion passed at this committee requesting these documents asks for this type of redaction to be made. Again, here on page 191 of the PCO release, we have another email between Ms. Wernick and Ms. Shannon. Again, only a cell phone number has been removed. Yet another example on pages 192, 193 of the PCO release. Another redaction to protect a cell phone number. I think we can all agree that the removal of such information is reasonable. Again, this is all adding context to the discussion here at hand, Mr. Chair. I find it interesting that while the public is battling a second wave of COVID-19, my opposition colleagues are chasing down private cell phone numbers. Let's look at pages 219 to 221 of the PCO document release. And frankly, this is a truly extraordinary document. A document that would rarely be released, a document that we would never have seen released under the Harper government. The synopsis of an entire cabinet meeting has been made public. Obviously, there are items protected by cabinet confidence. However, items related to the CSSG were still disclosed. Who knows what other topics were discussed? There could be national security issues. We don't know. And cabinet confidences that are unrelated to any of this should be protected. This is as determined by the clerk of the Privy Council and referenced in his transmittal letter. Frankly, Chair, there are reasons that documents like this are not normally public until long after a government's mandate has ended. Ensuring that the confidence of cabinet deliberations is essential to the peace, order, and good government of the country that my colleagues across the aisle always talk about, and I think sincerely. Cabinet confidences are essential to responsible government, and in an extraordinary move, the clerk waived privilege of the sections of this document as they related to cabinet discussion on the CSSG. Cabinet confidences are amongst our country's most protected information, and here it is for everyone to read. My opposition colleagues are not satisfied with only seeing the relevant and requested information that they asked for in their motion.
To interrupt you for a minute, Mr. Fragascatis, are these documents that you're reading from? I can't quite tell. That you're reading from, are they related to the sub amendment which we're debating now, or more so related to the main motion or the amendment to the main motion? I could clearly tell what Mr. Fraser was putting into the record was related to documents in the sub-amendment, but I'm not sure on the one. So if you try and keep it relevant to the sub-amendment, you're on. If not, try and move back to documents that are relevant to the sub-amendment.
Point of order, Mr. Chair.
Mr. Gerritsen.
I would suggest, Mr. Chair, that they are relevant because they're related to the sub-amendment as they highlight the issues that are required to be reconciled by the discrepancies. So what he's reading into the record directly speaks to the amendment to the amendment or the sub-amendment.
We'll monitor it and keep a watch.
Yeah, no, I understand, Mr.
Just hold on, Mr. Fragascatis. I believe I have a point of order from Mr. Fraser. Don't know where your mic is. You're doing the same trick as me, Pat. Go ahead.
Sorry, I caution too, or just maybe bring this to the chair's attention. The remarks that we heard sounded suspiciously like an argument already made, almost word for word. We can check transcript, but from Mr. Fraser's earlier remarks. So I hope that we're not actually repeating arguments that have already been made.
Okay, Mr. Fragascatis can take that into consideration as well. You're on, Mr. Fragascatis.
Mr. Chair, I'm simply adding greater detail, and as we heard from Mr. Gerritsen on his point of order, it is all related to the sub-amendment because what's articulated are issues that are required to be reconciled by the discrepancies that exist, and it's important also to have that perspective brought forward for all of the committee and for the clerk as well. So everything is putting in place, everything is intended here to put in place context. I don't believe that there's been any breach here or anything along those lines, but I'll continue in this vein, and if colleagues wish to point anything out, I was trying very hard to follow Mr. Fraser and believe I did, but it's not my intent here to repeat anything that my colleague has already put on the record. I've lost my place here, Mr. Chair. I'm not complaining about the point of order that was raised, but let me
start from the beginning.
While you're looking for your place, I'm going to give a heads up to Ms. Zerowitz that she is next on the list. Mr. Fragaskatis.
Thank you, Mr. Chair. So yet another example on pages 192 to 193 of the PCO release, another redaction to protect a cell phone number. We can all agree that the removal of such information is reasonable. It's interesting that while battling a second wave of COVID-19, my opposition colleagues are choosing to chase down private cell phone numbers. I do remember reading that already into the record, Mr. Chair. Let me just skip down here. Page 268 of the PCO release, an exchange between Ms. Wernick and Mr. Philip Jennings from PCO. In it, they are discussing an attachment that Ms. Wernick has forwarded to PCO. I know the opposition has a lot of interest in Ms. Wernick, but the only item redacted here is her cell phone number. I don't think they need that, Mr. Chair. Another example, pages 348 to 352 of the PCO release. We have another one of Mr. Poilievre's fully blacked out documents, if you can remember that famous press conference. If Mr. Poilievre were a sitting minister of the Crown, the overall result he is maybe looking for from all of this, he would have access to this entire document. But seeing as he is not, and in following the motion passed this committee, we have below the relevant portions of the document as they relate to the CSSG. In an extraordinary move, the relevant parties of this document were unredacted by the Clerk of the Privy Council. Items that are not relevant to the committee motion request for documents were redacted by the nonpartisan professional public service. The redactions were for good reason. Items were likely on the agenda of the cabinet meeting. Matters of national security and sensitive procurement that would hurt the government's ability to act in the national interest. Matters that, if released, could be damaging to Canada. I don't know about my opposition colleagues, but I'm always in favor of protecting Canada's reputation and national security before anything else, Mr. Chair. These redactions clearly strike the right balance between releasing relevant information and ensuring necessary cabinet confidences are protected. Mr. Chair, now turning to a very important document, the actual funding agreement between we and the Government of Canada, which is on pages 364 to 380 of the PCO release. Again, the professional public service redacted personal contact information. That is it. Nothing more. This entire funding agreement is public, not redacted, and available for public and parliamentary scrutiny. I think it begs repeating that while we sit here discussing the redactions of private cell phone numbers, the second wave of COVID-19 continues to rage through parts of Canada. While our focus should be on assisting Canadians to get through the second wave and conducting pre-budget consultations to see how we can help to build back better, we are focusing on missing phone numbers. And again, I remind my colleagues that there is a standing order pushing us, forcing us to commence a pre-budget consultation. Below is a Finance of Canada proposal, not below, excuse me. Let me talk about a Finance of Canada proposal on pages 394 to 401 in the PCO release. It discusses the implementation of the CSSG in full unredacted detail. The only removal information, again, the private cell phone number of a public servant. Next, a very interesting document, Mr. Chair. I think my colleagues will find this quite interesting. We are looking here at page 404 of the PCO release, which is a meeting invite to discuss the WE contract. The redaction, again, a conference call login ID. All simple things that need to be redacted for privacy purposes. PCO release on pages 417 to 419, a cabinet confidence document, stamped limited distribution, a document called a memorandum to the Prime Minister seeking his decision regarding the CSSG and other matters. As is noted in the motion from this committee, matters related to the CSSG were requested, and here we have them released. However, redacted items, being unrelated cabinet confidences, were redacted. As we have expressly permitted by the motion, agreed to by members of this committee. A very interesting email next from the PCO release on pages 426 to 427, an email from Miss Roseanne McKay at PCO to one of her colleagues, Alain Bondoin. The topic, a cabinet meeting note from the Prime Minister. Not unusual whatsoever. The redaction, again, a public servant's cell phone number. There's a pattern here, Mr. Chair. Let's take a look at other pages, 428 to 432 from PCO. And again, we have a document with a conference call ID redacted and items that are clearly not related to the CSSG. These items were redacted by the professional and nonpartisan public service. Below, we have another release. We have another release that I'd like to talk about further to my comments on pages 433 to 434. Again, my opposition colleague's complaint, a public servant's cell phone number. What exactly is the opposition, I would ask, Mr. Chair, hoping to find with the cell phone number of public servants? There's another page in the PCO release. On page 456, Mr. Poilievre seems to take issue with a redaction on this page. I see that he's present in the meeting, at least his screen's on, but he's not there to hear this. In any case, I'll continue by saying that we're looking at an email among public servants who are involved in the CSSG file. I'm sure colleagues on the other side would really decipher this email if they wanted to. I'll give them a hint. The email is of a private citizen. And there's more examples, Mr. Chair. The cell phone number of a public servant, just for the information of Canadians watching, we are focused on getting you through this pandemic. That is that is our obligation now. That will come to, I think, define what we do as parliamentarians in the weeks and months ahead. I hope that this committee is allowed to engage in that work. Unfortunately, we continue to see opposition colleagues focused on cell phone numbers of a professional public servant. More in the PCO release on pages 491 to 495. We have an email from Mr. Kielburger to Ms. Fox at PCO. The entire content and attached information from Mr. Kielburger is included. There is no redactions on content other than the names of private citizens and personal contact information, which is not at all relevant. Let's turn our attention to the documents provided, Mr. Chair, by the Department of Finance now, which I'll add, they've done an amazing job. They've come to committee time and again in the previous session to answer committee members' questions about the pandemic, and I'm sure that will continue if this committee is allowed to do its work. Pages 1 to 3 of the release. Once again, all content related to the CSSG is present. The only redactions relate to third parties not associated with the program. Let's take a look at pages 51 to 54 of the finance release. We're looking at an email between Ms. Kovacevic from the Department of Finance and minister's staff. The content is all here, Mr. Chair, all visible for public and parliamentary scrutiny. The only present redactions are for cell phone numbers, information that is not relevant and should not be in the public realm. Keeping with my opposition colleagues' predisposition to light their hair on fire, if I can put it that way, Mr. Chair, over what they call unreasonable redactions, let's turn our attention to page 189 of the finance release. We have a meeting invite with all information visible, the redactions, a conference call ID. I'd love to hear my opposition colleagues explain why this redaction is at all inappropriate. The redaction was completed by the nonpartisan and professional public service who I've mentioned throughout my remarks here. We were following all relevant guidelines, who were following all relevant guidelines to ensure the documents conform with the committee's motion, which states that redaction of private information is permitted. Now, Let's look at finance release page 190. This same email from Craig Kielburger to Minister Morneau, or then Minister Morneau, was also a part of the document submission that was received by this committee. In that email, Mr. Chair, we see the same email with all information present. As we see there, the information had nothing at all to do with the CSSG and thus had no relevance to the motion of this committee. Chair, page 216 of the finance release. An email from Ms. Marquez at WE to officials in the public service responsible for the CSSG. The only redactions present are personal information of Ms. Marquez. Again, pages 222 to 223 of the finance release. We have all content of the email between Ms. Marquez and relevant department officials fully visible. The redactions that my opposition colleagues are up in arms about, Mr. Chair, what could that be? An email address and contact information for Ms. Marquez. It's not exactly anything shocking, Mr. Chair. I'm looking now at page 224 of the finance document release. We have here a meeting invite for Ms. Kovacevic to a minister's office staff member. All content is present. The redactions that Mr. Poliev and the Conservatives are taking issue with, a conference ID and Ms. Kovacevic's cell phone number. On and on we can go, Mr. Chair. There's a similar story on page 226. Again, the only redaction present is a conference ID. All content, names, and emails of relevant officials are present for Canadians and the opposition to see. I will be accused, certainly by some members of the committee and some who are smiling at me right now, of sounding like a broken record. But it bears emphasis, Mr. Chair. We're looking at the finance release. We continue to see patterns here. All content of this agenda and notes from a meeting between members of PCO, PMO, ESDC, and meetings are included. This is a cabinet confidence document, Mr. Chair, and it's been released for review.
Interrupt you again, Mr. Fragaskatis, on relevance. The information that at this point that you seem to be providing a committee is on the issue of redactions, which in my view is more aligned with what the main motion states. And the sub-amendment that we're discussing now is really about the issue of providing more information, not less. So I again remind you on relevance to I do believe your comments are very, very relevant to the main motion, but I am considerably questioning whether they are relevant to the amendment.
On that point of order, or as a point of order, Mr. Chair,
yep.
Isn't it relevant for the need for the clerk to be able to compare the documents? So what he's providing now gives that opportunity for that work to actually happen.
Just let me have a look at the my rough notes on the sub amendment, which mainly relates to transmittal letters. But yes, you are saying compare documents. Okay, go ahead.
Thank you.
Thank you very much.
You're on the floor there, Mr. Fragaskatis.
No, thank you. I was just taking a water break there, Mr. Chair. But I will continue here. All content of this agenda, and I was speaking specifically about the finance release, as I said before. All content of this agenda and notes from a meeting between members of PCO, PMO, ESDC, and finance. All this content in terms of meetings are included. This is a cabinet confidence document, Mr. Chair. It's been released for review with all information as it relates to the CSSG visible. The redactions that we find here, a conference call ID number, again, another pattern here, Mr. Chair. We could be conducting pre-budget consultations. Instead, we're sitting here debating the redaction of a conference call ID, Mr. Chair, trying to add to the context, trying to, as Mr. Garrettson said, put some more meat on the bones so that we can have full understanding of what's at stake with the amendment to the amendment that we are debating, but I'd be much rather debating getting help out the door for Canadians in need, Canadians looking to pay rent in terms of small business owners, Canadians looking to secure themselves, their families. Just yesterday met Mr. Chair with meetings and events, business having an enormously tough time. Would love to hear them at committee. Unfortunately, we cannot do that. Let's take a look at an email exchange. And the comments, there's not that much more, Mr. Chair. I'm almost through. Let's take a look at an email exchange between Ms. Kovacevic and the Minister's Office staff and department officials. In this chain, we can be, we find all the information in the body of the email present. Again, though, we have redactions of private cell phone numbers, information that does not need to be in the public domain, and therefore our nonpartisan public service removed it, quite understandably, per the terms of the motion voted on by the members of this committee, even, Mr. Chair. Let's take a look now.
Just interrupt for a sec, Mr. Fraga. You're not on a point of order, Mr. Julian. You're one on the speaking list. Is that correct? Okay, great.
You'll be able to speak soon, Mr. Chair. As I said, I'm going to be wrapping up shortly. Let's take a look at an email from Ms. Wernick to officials across the public service, including PCO and the Department of Finance on pages 326 to 330 of the finance release. The redactions that the opposition is taking issue with, again, Ms. Kovacevic's cell phone number, it really is absurd here, Mr. Chair. Pages 411 to 426 of the Department of Finance release, we seem to be looking at a decision document of some kind. Pages 411 to 426, again, Mr. Chair, what you'll notice here, all the information as is relevant to the CSSG is unredacted and present for everyone to see. The redactions are unrelated cabinet confidences as determined by the nonpartisan and professional public service. As was expressly permitted for in the motion from this committee, all cabinet confidences that are related to CSSG would be released, but unrelated information was to be redacted, and it was. Nothing too complex here, Mr. Chair, not rocket science. It's already a rare occurrence that cabinet confidences of a city government are released, and the clerk took the extraordinary step to release all information as it related to the CSSG, while also maintaining that he would protect necessary and unrelated cabinet confidences. Everything present here has been done in the spirit of that promise and while respecting the committee's motion for information. I'm going to conclude in a moment. Let me look at two more examples of broad redactions. These are the famous blacked out pages that Mr. Poliev wanted to bring to the attention of the country. Again, at a time when the country is focused on COVID-19 and not the musings of, with all due respect, Mr. Poliev. Beginning on page 219 of the PCO release, we have a summary of a full cabinet meeting. The discussion could have been related to vaccines or PPE procurement, national security, or other matters. A cabinet document such as this is rarely, if ever, made public. Cabinet confidences unrelated to the Canada Student Service Grant are redacted per the terms of the motion adopted at the committee. Keeping with the spirit of the FINA motion, CSSG items are, however, visible, entirely visible. A second example on page 348 of the PCO release, we have a second cabinet note where the document is redacted. This is the later cabinet meeting in May 2020. CSSG implementation was discussed and is unredacted as ordered by the finance motion and by finance committee motion and agreed to by the clerk of the Privy Council. However, the rest of the information is still redacted as they fall under cabinet confidence, Mr. Chair. We do not know what the topics of discussion were here. There could have been talks related to national security issues, legal discussions that are solicitor-client privilege and protected as such. There could have been discussions related to further PPE and vaccine procurement that, if public, would have put our competitiveness at risk. So to sum up, Mr. Chair, I think I've demonstrated here, and I'll admit I was exhaustive, but again, we have to put everything in proper context, that the redactions the opposition have been turning into political theater are in fact in line with the motion they proposed at this very committee. I'll welcome, or I turn rather, Mr. Chair, to you. I know there's other speakers on the list, but glad to put this on the record where it needs to be.
Okay, thank you. I have two speakers in this order, Ms. Zerowitz first, and then Mr. Julian, and that's all I have on my list when till we vote on the amendment to amendment. I am going to, though, look, we've been at it for 5 hours and 15 minutes, and I'm going to suspend for 10 minutes. Because I have to make my own coffee here. I'm in isolation and take a washroom break. And so for 10 minutes, people stretch their legs if they could. So we'll come back on at 26 minutes after the hour. Okay, meeting suspended.
Yay!
We're back. We're just Ms. Sirowitz and Mr. Julian. There's Ms. Sirowitz. I believe we 1, 2, 3. St. Marie's back on. All right. We have quorum. We're ready to go, and keep in mind we're on the sub amendment. Thanks for the 10-minute break. I needed that anyway. So we'll turn to you, Ms. Sirowitz. You're on sub amendment.
I also want to say a huge thanks to you, Mr. Chair, and to everyone for the 10-minute break. I managed to sort of whip in some scrambled eggs. It was the fastest lunch I could actually do in a short minute of time. So thank you for that. I too am going to go through some a fairly detailed speech. It's not quite as long as my colleagues, Mr. Fredriskakos, but I can assure you, Mr. Chair, it is related to the sub-amendment as they highlight the issues that we have to look at in terms of the reconciliation of any discrepancies, and why it's important for us to have analysis from the clerk in terms of comparing sort of what the two versions that we've been talking about. So, and I'm actually going to continue with where my colleague Mr. Fraser left off by providing a detailed examination of the package of the documents provided by ESDC. The transmittal letters read into the record by Mr. Fraser provide us with some good context, and I'm going to be providing a few more examples of why it was very good context. And I'm going to use the page numbers that were stamped into the documents, as they are the only indicators that I have while the packages were provided to the committee today. So I'm going to start off with, and again, so this is all related to the ESDC documents. I'm going to start off with pages 159 and 161. And basically, at the very top right of the page, there is a designation which says secret, and then there's another designation which says confidence of the Queen's Privy Council. These are key designations that one would find on a document that are cabinet confidences. And confidences of the Queen's Privy Council are defined as cabinet ministers are collectively responsible for all actions taken by the cabinet and must publicly support all cabinet decisions. In order to reach final decisions, ministers must be able to express their views freely during the discussions held in cabinet. To allow the exchange of views to be disclosed publicly would result in the erosion of the collective responsibility of ministers, and as a result, the collective decision-making process has traditionally been protected by the rules of confidentiality, which upholds the principle of collective responsibility and enables ministers to engage in full and frank discussions necessary for the effective functioning of a cabinet system. The Supreme Court of Canada has recognized that cabinet confidentiality is essential to good government. In the decision of Babcock versus Canada, 2002 SCC 57 at paragraph 18, the court explained the reasons for this. The process of democratic governance works best when cabinet members charged with government policy and decision-making are free to express themselves around the cabinet table unreservedly. To preserve this rule of confidentiality, subsection 70, in brackets 1 of the Privacy Act, and from here on in, I'm going to be referring to the Privacy Act as the Act, provides that the Act does not apply to confidences of the Queen's Privacy Council for Canada. For convenience, in the following material, confidences will be used to refer to confidences of the Queen's Privy Council for Canada. Matters classified secret are considered secret because their release would cause serious injury to the national interest. Yet here we see that one of those essential confidences are redacted with only a conference call ID redacted. So clearly, Mr. Chair, the government and public service have been proactive to release as much information as possible, even information that is typically closely held and privileged, to allow for the proper and effective management of government. if we look to, and I just maybe we'll pause for 1 second, just because I think that sometimes when we talk about the lingo of who's actually doing the redacting, I know that it's mentioned a few times, but they always say you have to repeat things 6 or 7 times for it actually to sort of stick in someone's minds. The redactions were actually done by our independent civil servants and under very strict rules. And these are rules that have been followed for years and years and years and years. There were not new rules that were actually created for these documents. And I just want to remind all Canadians who might be listening that this was done by independent civil servants to decide what should be redacted, what should not be included. And I'll provide some more information about what it is that we continue to, I want to highlight a few more redactions. So if we look to pages 414 to 429, here, Chair, we have an email between relevant public servants responsible for the CSSG program. So for those who have forgotten, CSSG is the Canada Student Service Grant program, which we had originally been rewarded to deliver by ESDC. It's pages 414 to 429, and the only redactions we see here are for the personal information and unrelated cabinet confidences, which were permitted under the FINA motion. However, our government was forthright, and all information as it relates to the SSG is there in plain sight. So the entirely blacked out pages that Mr. Polyev has referenced several times are nowhere to be found. And so I want to make sure that I point that out. On pages 544 to 545, here, if we actually look at those pages of the ESDC release, we once again look at redacted phone numbers. The only redactions we have found on this particular page is in reference to a conference call ID. On page 621, again, we show redactions of conference call access information, which, Mr. Chair, is very reasonable. These are active conference call lines likely used by whether it's Ms. Warnick or minister staff, and so there's no reason why the public, for any reason, should have access to it. It is a security issue. Chair, if we look at pages 622 to 628 of the ESDC release, and if you had it in front of you, you would see on the top right corner that this document is marked secret. So for those Canadians that are following from home, Treasury Board Secretariat and our security services count any information that could cause serious injury to the national interest as secret information. And I'm sure as Canadians can understand, cabinet confidences are information critical to the national interest, and government decision-making are rightly never disclosed lightly. Yet here in this document, we have a prime example of the level of transparency our government went to ensure that documents related to CSSG were released to parliamentarians. Where we do see redactions in the secret cabinet confidence documents, they are for information unrelated to our motion and which are clearly in the critical national interest and therefore should remain protected. And our nonpartisan public service went about ensuring that the national interest was respected. If we turn to pages 631 to 638, as mentioned earlier on, Mr. Chair, there are reasons related as to why we are marking many of our documents secret or at a higher classification and why they're so closely guarded. So I want to provide an example where the nonpartisan public service did make some redactions. Here we are looking at pages 631 to 638 of the ESDC release, and colleagues will note that it's only one page. This is due to the fact that the public service redacted the section due to relevance and to protect cabinet confidences, which is our national interest. Now, I know, Mr. Chair, that my opposition colleagues sometimes will think that we have a negative intent when those redactions are actually done by our independent civil servants. But I do think that they've been very responsible, and I think they've done their best to try to disclose as much information while honoring secret information or non-disclosable information as per how I've defined it earlier on when I started the presentation. So if we turn to pages 888 and 889, the only thing that's actually redacted here is a private cell phone number of a public servant. And again, if we turn to page pages 958 to 966, it looks to be a cabinet document to discuss the implementation of the CSSG. And again, these are not the types of documents that on average are made public, but in respect of the motion, we have, it is almost entirely unredacted with unrelated personal information, and cabinet confidence is removed. If we turn to pages 975 to 979 from the ESDC release, we see minimal reductions. Only personal information was removed, and 95% of all of these pages are visible for anyone to read. On pages 1056 to 1057, here we have an email from Ms. Warnick to several other officials. Clearly, all items are related to CSSG. They are unredacted and they're visible. And now at the time our government was busy delivering a number of programs to help Canadians through this pandemic, these redactions are likely discussions around those programs. If you turn to, you can't really turn to it, but if you were able to turn to it and look at pages 1092 to 1098, this is an example of what a complete page redaction looks like. As you could see from some of my previous examples, complete page removals of this are rare and are directly related to cabinet confidences, which, as the original FINA motion stated, were expressly excluded. Again, these pages were removed by the professional, nonpartisan public service who were carrying out their duty to protect cabinet confidences. And here's also an interesting redaction, Mr. Chair, on page 12. Somewhere between pages 1262 and 1275 of the SDC release, we see that nonpartisan public service has redacted a document password. And so that, of course, we do that for security reasons and for very valid reasons. Pages 1784 to 1788, you'll see that there is communication between Ms. Warnick and several department officials, with minimal sections removed due to cabinet confidence, which is again expressly permitted under the FINA motion. When we look to pages 959 to 1959 to 1960, we're looking at an email from Ms. Warnick to Ms. Shannon at PCO. And we see that over 95% of the emails visible with one minor redaction due to the cabinet confidence, which, as we've mentioned, that is completely allowable. Let me see if I can just give you a few more examples, and then I want to wrap up with a couple of comments. On pages 2176 to 2181, we're looking at an email from the Deputy Minister at ESDC, and we see a majority of the information included as it relates to CSSG. But again, any cabinet confidential cabinet confidence or private information was removed. If we look at page 2191, we see it's an email from Minister Qualtrough to her Deputy Minister. We see there's no redaction other than the Minister's private email address. Typically, these types of correspondence are kept in confidence, but it was waived as it relates to CSSG and are here for all of us to see. So I think we could see that from these examples, you could tell that our public service did its very best to try to put out as much information as possible, as long as we were honoring anything that might be deemed cabinet confidence or part of cabinet discussions, as long as we were honoring any secret information like telephone numbers or any personal details that might be completely irrelevant to the CSSG contract, to the CSSG program, and to we actually being awarded or being selected to deliver the CSSG contract. I'm trying to think if there is anything else in terms of relevant that other than like telephone numbers being redacted and other bits of information, because I think largely I have about another 10 pages where I'm kind of saying, well, for the most part, we haven't redacted the information. We've done our very best to try to provide information to, or the civil servants try to make sure that as much information was going out as per the instructions of the July 7th motion. I think I'm going to probably end with just one more comment, Mr. Chair. I think that, one of the things that I think we might have forgotten is when our Prime Minister made the announcement that there was going to be a prorogation of government, I think he
point of order, is that relevant right now to the sub amendment that we're discussing?
Absolutely it is. And so if you'll just wait for me to complete my sentence, you'll hear it. Thank you.
Okay.
So so when he made the announcements in terms of prorogation, he made sure that he made the announcement after there was a release of all the documents and not before. And I don't think that that would be an action of a government that in any way was trying to hide anything. And I think with that, Mr. Easter, while I didn't go through another 10 or 12 examples of the exact, the ways that we didn't redact things, or we only redacted things that were absolutely necessary, I think I've made my point in terms of going through the ESDC arguments, and I think I'll leave it at that. Thank you. You're muted. You're muted, Mr. Chair.
Thank you. Thank you very much. We will now turn to Mr. Julian, and then hopefully we can have a vote on the sub-amendment. Mr. Julian, floor is yours. Sub-amendment, we're on.
Thank you very much, Mr. Chair. I meant no disrespect. You saw me a few minutes earlier eating popcorn as I watched the brilliant filibuster, and I will compliment Mr. Fraser, Mr. Frascatos, Ms. Jarowitz for their filibuster. As you know, Mr. Chair, I hold the record for filibusters in the House of Commons at around the Harper Softwood Lumber sellout, 16 hours by myself. And I always love a good filibuster. However, a filibuster actually has to reinforce your point. And so if I'd spent 16 hours before the Natural Resources Committee actually arguing for the softwood lumber sellout that Mr. Harper imposed on us, I wouldn't have had much credibility. And here's the problem.
Point of order.
Have had point of order, Mr. Gerritsen.
Mr. Julian is speaking to filibustering. He's not speaking to the amendment to the amendment. He really needs to speak to the amendment to the amendment, Mr. Chair.
Yes, I will give him a little leeway, as others have had leeway on his
20 seconds worth, right? 20 seconds worth of leeway.
Rolling on his points relevant.
Mr. Julian, I apologize if I interrupted your video clip. Maybe you want to start from the beginning again so you can capture the whole thing.
That's not a point of order. Mr. Julian, go ahead. You were winding up on your filibuster on the Harper government.
My point is simply this, Mr. Chair. What we have had from the last 3 Liberal members is a reinforcement of why we should be voting against the sub-amendment and voting through this motion. The initial argument has been all along that the documents weren't provided, and how could committee members actually make a decision because the information wasn't available. And as by her own admission, Ms. Zerwitz has another dozen pages of carefully prepared text that took days to prepare. Same with Mr. Frascatos, same with Mr. Fraser. This is meticulous. We have many Liberal Party operatives working overtime to actually produce all of this material to reinforce the sub-amendment. The reality is the argument that Liberal members of this committee have been using.
Hold it, Mr. Julian. Point of order from Ms. Zerowitz.
Well, okay. Well, it was more that Mr. Julian had alluded to the fact that we already had the documents. The documents I was referring to was actually documents that were released by the Government House Leader's Office, and it was given to all members. So it is not the documents that he was referring to. Thank you.
All right, Mr. Julian.
Thank you, Mr. Chair. My point is very simple. They have meticulously prepared presentations on the sub-amendment that reinforce the point that we've been making all along. Committee members have had access to the documents. We need the ability now to move forward. It's been more than 180 hours with breaks and with suspensions, as you know, Mr. Chair. But really, the reality is the people who are watching us know full well the Liberals have had access, have provided very, very well-researched and fulsome arguments that have been prepared days in advance, which means their fundamental argument that the committee isn't aware of the documents that have been distributed now for months falls through. And so those filibuster points have undermined the principal Liberal position. Let's get on with it, and let's vote on the sub-amendment, on the amendment, and on the motion.
I agree. We should vote on the sub-amendment.
Okay, we're ready for the vote. I gather on the sub-amendment. I will turn to you, Madam Clerk, and we will have a voice vote on the sub-amendment is the best way to go. Madam Clerk, floor is yours.
Thank you. First of all, I just want to verify the presence of members. So the list that I have here for members of the committee present and allowed to vote are as follows: Mr. Fraser, Ms. Jerowicz, Mr. Fragiskatos, Mr. Gerston, Madame Koutrakis, Mr. Poliev, Mr. Falk, Ms. Jensen, Ms. Vecchio, Monsieur Sainte-Marie, Peter Julian. Is that correct?
Did you miss Mr. Steinley?
I believe I'm here on behalf of Mr. Poliev. I believe Mr. Poliev is not here.
The documentation point of order should have been submitted to the clerk if there's a sub going on here.
Thanks.
Yeah.
Well, the clerk doesn't seem to know that because she's not under the impression that you're supposed to be here.
I have actually been on all of those emails. So just to let you know, it was indicated by the clerk about Mr. Steinley supposed to go in for Mr. Poliev and for myself for Pat Kelly. So thank you, Mr. Garrett.
The clerk doesn't know that.
Mr.
The clerk doesn't know that.
Just hold on. Just hold on.
Ms. Vecchio, you did interrupt me when I was speaking.
We'll ask the clerk. I assume, Madam Clerk, you have the documentation for Ms. Vecchio and Ms. Steinley.
Yes, sorry, I just wanted to verify because I see Mr. Poliev has logged in, so I just wanted to double check for the status, but I did receive the email.
That's good. Thank you.
Thank you. So the question is on the amendment of Mr. Gerritsen.
Mr. Gerritsen.
Gerritsen, sorry. All those in favor? Mr. Fraser.
In favor.
Ms. Jerowicz.
Yes.
Mr. Fragiskatos.
Yes.
Mr. Gerritsen.
Yes.
Ms. Koutrakis.
Yes.
Mr. Steinley.
No.
Mr. Falk.
No.
Ms. Jensen.
No.
Ms. Vecchio.
No.
Monsieur Sainte-Marie.
No.
Mr. Julian.
No. Against.
Mr. Chair, that's 5 yeas, 6 nays.
Okay, the sub-amendment is lost. Then we will turn to the amendment. Mr. Gerritsen. Go ahead.
Thank you, Mr. Chair. So in listening to the debate over the previous amendment that I had put forward, the rationale that, like the really only the rationale that I heard in terms of not wanting to proceed with it or that it wasn't a good idea came from Ms. Jensen when she talked about the amount of work that would be created as a result of this. This was really the only argument that I had heard from opposition MPs as to why we should not proceed.
Point of order, are we now debating what we just finished voting? How does that work? I don't understand that.
We're on the amendment as not amended.
We're on the amendment. The amendment to the amendment or the sub-amendment was lost. And we're on the amendment. And just for, I'm not sure if our list still remains the same, but my list is, according to my hands up, Mr. Gerritsen, Mr. Julian, Ms. Zerowitz, and Mr. Fragiskatis. And if that list has changed, then just let me know and we'll go from there. So Mr. Gerritsen, the floor is yours.
So thank you. And Mr. Chair, if you allow me the opportunity, I'm just laying the groundwork for the next part of what I'm going to say, which is why I was, and I'll repeat that. So I had started off by saying that Ms. Jensen had raised the point that there was going to be a considerable amount of work done with this. And that was really from the opposition, the only point that had been brought forward that explained why the opposition would be against a motion that would have brought forward that additional work in analyzing the documents that I had put forward in my previous one. So, in that vein, so I would like to try this again, and perhaps this time, rather than looking for the full detailed analysis, I would like something a little simpler. So, Mr. Chair, I would move that as an amendment to the amendment, I would move that the clerk and the analyst prepare a page annotation, not an entire new analysis, as I was previously suggesting. I move that the clerk and the analyst prepare a page annotation that enables members and the Canadian public to easily find pages in various versions of the document disclosure requested by the Standing Committee on Finance. And so what I'm basically looking for in this, Mr. Chair, is I'm looking for the ability to be able to, in a more expeditious fashion, look at the documents and understand what the committee has been provided and what it hasn't or what's missing, and an easy way to navigate through the documents, which we currently don't have. So I'm hoping with this new amendment to the amendment that I'm putting forward, Mr. Chair, that the opposition will look at this as something that does, I already see some shaking of heads, and I find that to be disappointing, but that the opposition would look at this as another way of getting the information to the public and to members of this committee, and indeed all parliamentarians, but not putting in the vast amount of work that Ms. Jensen had pointed out in her comments about why she didn't support the motion. So I'll put that out on the floor, Mr. Chair, and hopefully we can all agree that this doesn't require a whole lot of debate, and we can all vote in favor of it. I'm really hoping that we can make sure that we have this added to it.
So if you could read the proposed sub-amendment fairly slowly, so I can make note of it, see if it's in order, and then we'll go from there.
Okay. So I would, after the existing amendment, say, and further, that the clerk and analysts prepare a page annotation that enables members and the Canadian public to easily find pages in various versions of the document disclosure requested by the Standing Committee on Finance. I have that in French as well, if the clerk would like that sent over.
You'd best send that to the clerk. It is in order. It is relating to the documents in the original motion. So the sub amendment is in order, and we will start a new list. Or if Ms. Jansen, you're first on the list.
Just really quick, so we now have a sub-amendment which further delays this meeting on all the documents which you just read into the records. I'm just kind of shocked. Let's just move on, shall we? Thank you.
Is there anyone else who wants to speak on this sub-amendment proposed by Mr. Gerritsen? Ms. Sarowitz.
I just want to state very clearly that I think Mr. Gerritsen made an excellent sub-amendment. I think it's very logical. I think it is good for us to compare and make it easier for us to sort of understand what might be the discrepancies, and this provides a nice legend. To Ms. Jansen's point, this could all be eliminated if the Conservatives actually pull back their withdraw their motion. We could go right to the pre-budget consultation motion that I did sort of propose, and we can get right into pre-budget consultations. Thank you.
Ms. Jansen's back in.
Okay, so I just want to find out, is this, I want to clarify with the clerk if this would delay the tabling of the point of privilege report. Can they prepare an annotation that doesn't stop you from going on after anything else after the report of privilege is returned to the House?
Is the clerk in a position to answer that, or for that matter, any of the analysts? Madam Clerk or Brett or anyone who wants to try and answer that question?
I'm not sure how the committee would like us to. We don't have a time defined. in there. So I'm not sure how the committee would like us to proceed exactly.
I think basically, if I've got this right, Ms. Jansen, you're wondering basically how long it would take to prepare a page annotation that enables members in the public to easily find the pages and the various versions to kind of compare.
Yes, exactly. We're trying to move on. Exactly. Thank you.
Trying to see how much time that would take. I mentioned earlier in the beginning on Mr. Poilievre's motion, some of the timing in it within 24 hours of adoption of this motion. I don't even know if that is quite possible, and I don't want us to blame analysts or clerks or anyone else if it is just not doable. But basically, if you have any idea of rough time that might take from the analysts or the clerk, it would be helpful for us to know. It's basically a comparison document, a one-pager.
I think it would be difficult to give an estimate of the time it would take to go through all of the documents provided and prepare the annotated list. I think it would be up to the committee as to whether they would want to wait for the annotations to proceed with their review of the subject matter.
Okay, thank you, Brett. That's the best we can do. That's the best we can do. Ms. Jansen, anything further you want to add? Okay. Anybody else on the speaking list, or we shall move on to a vote? Karen, was your hand up, or you're just Ms. Vecchio? Don't think so.
Point of order, Chair.
Yeah, point of order, Mr. Fragiskatis.
Would it be something that the clerk maybe could look at doing, Mr. Chair, taking it under advisement and getting back to the committee?
Getting back to the committee when is the question, because the motion stipulates shall be filed with the clerk of the committee within 24 hours. She could do. We could ask her to do that. But I think I think what Ms. Jansen's question was relating to is can this be done in a pretty expedited fashion so that the information is available and doesn't slow down the process at least too much in terms of getting the motion to the speaker, to the House, to the report to the House.
Yeah. So, no, I raised the point, Mr. Chair, because it would be difficult to move forward towards a vote with that information.
Okay. So I'm not hearing a lot of discussion on this sub amendment. Are you ready for the vote?
Okay. So we're voting on my sub amendment, Mr.
We're
Chair.
voting on your sub amendment, Mr. Gerritsen, and I don't believe members have changed. Well, maybe they have. You better check your list, Madam Clerk, because Mr. Kellaway may have replaced Mr. Fraser. I'm not sure. Mike, have you replaced Mr. Fraser?
That is correct, Mr. Chair.
Okay. Madam Clerk.
Just point of information, does Mr. Fraser have to be logged off to be able to have Mr. Kellaway on the vote? Or can he stay on like that?
No,
okay.
members are certainly allowed to attend. It's their right as a member to attend. The important factor is who's signed in to vote.
Thank you.
Madam Clerk. Madam Clerk, do you want to go through the vote?
Yeah, so I'll just read the names again, just to make sure that I have the right ones. So Mr. Kellaway, Ms. Jerowich, Mr. Fragiskatos, Mr. Gerritsen, Ms. Koutrakis, Mr. Stanley, Mr. Falk, Ms. Jensen, Ms. Vecchio, Monsieur Sainte-Marie, and Peter Julian. We will now proceed to the taking of the recorded division on Mr. Gerritsen's amendment. Mr. Kellaway.
I vote in favor of the sub-amendment.
Ms. Jerowitz.
Oui.
Mr. Fragiskatos.
Yes.
Mr. Gerritsen.
Yes.
Ms. Koutrakis.
Sorry, I was on mute. Yes.
Mr. Stanley.
No.
Mr. Falk.
No.
Ms. Jensen.
No.
Ms. Vecchio.
No.
Monsieur Sainte-Marie.
No.
No.
Julian.
No, against.
Mr. Chair, 5 yeas, 6 nays.
Okay, the motion is lost. I see that Mr. Kellaway is into a virtual voting on committee, the same as we do in the House. Way to go, Mike. Okay, we're on the initial amendment. Back to the amendment to the original motion, do we need that read, or do we know where we're at? Does anybody want it read? Ms. Zerowitz, can you read the amendment, Madam Clerk? It comes in right after the first of that. And it's about pulling up the documents from the session 1 of the 43rd Parliament. So if you could read that amendment into the record so that people know what we're discussing, and then we'll get on with it.
Okay, the amendment was that the evidence heard and papers received by the committee during its study on government spending, and the Canada Student Service Grant during the first session of the 43rd Parliament be taken into consideration by the committee during the current session and accordingly.
And accordingly, the chair be instructed. Okay, so we all know what the amendment is now. I had on my original list Mr. Gerritsen, Mr. Zerowitz, and Mr. Fragiskatis are the only 3 I have. Do we have anybody else wants on the list? And is that list right? Are you ready to go, Mr. Gerritsen? You're the one I have on the, oops, now you're off, and I have Ms. Zerowitz as first. You ready to roll, Julie?
I think Mr. Fragiskatis was first, Mr. Easter.
Okay, Mr. Fragiskatis, the list is this. Now, Mr. Fragiskatis, Ms. Koutrakis, and Ms. Zerowitz and Mr. Gerritsen. Go ahead.
Point of order. Have we voted on the amendment yet, which is the amendment that was originally put forward by Mr. Kelly?
This is the amendment that we're
on the amendment. My hand was raised for the original motion.
Okay. So we are now debating the amendment to the original motion that the clerk just read. So we'll start with you, Mr. Fragiskatis, and then we'll go to the list that I see before me. People put their hands up so I can see them. Mr. Fragiskatis.
Thank you very much, Mr. Chair. It's unfortunate we had what I thought was a very elegant solution on the table because of Mr. Gerritsen's initiative to put forward an amendment to the amendment. And I know that we are seemingly running around in circles, but either way, sometimes that's what you have to do to get to a good outcome. And Mr. Gerritsen had put forward something that I thought was quite reasonable. I wonder why opposition colleagues have not supported it. And here we are again, debating an amendment that we were all, not all, but a number of us were rightly concerned about. An amendment that comes close, if not entirely, to breaching privilege. So with that said, Mr. Chair, I still have great hesitation here. I think we have to think very carefully about the way to proceed. And I'll also add that let's not forget that all of this debate is obstructing what must be the fundamental focus of this committee, especially right now, and that is COVID-19, pre-budget deliberations, inviting the nearly 800 stakeholders who want to come to this committee and make the case as they see it. But we are continuing to dither on that. I would also ask you formally, Mr. Chair, as I've said here before today, and I'll put on the record once again, Standing Order 83-1 calls on the committee to put forward, or to commence, a pre-budget deliberation, one that should take place over a number of weeks with a defined timeline. It has to end by a particular date. What happens, Mr. Chair, and perhaps you could confer with the clerk on this, what happens if that standing order is violated? Because I think that the more we continue to see the opposition play politics in this way, the more likely it is that that standing order is violated. What happens if the committee is in violation of 83-1? What are the consequences for the committee? I think that needs to be understood by all members. And again, this is not an effort to sidestep issues around We Charity and some of the mistakes that happened on that particular issue. I've been a member of this committee for some time, including during the summer when we had a number of hearings on the matter. These are important questions, no doubt, but I can tell you, and I think every single member of this committee would echo the sentiment, that there's people in our communities that want this committee to be serious about the work that it's doing. There's any number of questions that we would look at. I would think that we examine very closely issues related to COVID-19 without any hesitation. The more the opposition wants to put forward amendments or motions to begin with, and then amendments to motions that really have nothing to do with the issue of our time. When I get up, I'm thinking about constituents. I know that MPs around the table are thinking about constituents too. What are those constituents thinking about, Mr. Chair? They're thinking about the challenges that they're facing because of COVID-19. They're thinking about paying the rent. They're thinking about paying the mortgage. They are thinking about putting groceries on the table. We have seen government programs really provide a lifeline. They have helped to, in so many ways, serve as a safety net for Canadians across the country, whether as individuals or whether we look at Canadians who own businesses. When the CFIB, the Canadian Federation of Independent Business, says that they want to see this committee be serious about moving forward with thoughts on and advice that would be offered to the government based on expert testimony, which they would be included within. I'd love to hear from the CFIB, even though they've been critical of the government on a number of points. I think they've made some cogent points throughout this entire experience of COVID-19. That is also true of the Canadian Chamber of Commerce, another organization with an important voice that I know my Conservative colleagues certainly respect. Where are they on this? They want to see this committee carry out very, very important work. Restaurants, Mr. Chair, are ailing right now. The more we debate amendments to motions and motions to do this and that and the other around the We Charity issue, the more that we are obstructed from helping those folks on the ground. And I mentioned restaurants here in particular. My family has great experience in restaurants. My parents recently retired from the sector, but I know that family members that are still in it and friends that are still in it are facing real problems. Take a look at what Todd Barclay, Mr. Chair, recently said, and he is, as you know, the president and CEO of Restaurants Canada. He said that, quote, "We appreciate the federal government acting on this critical recommendation of stepping up to support Canadians during COVID-19. Among other new support measures that have been announced."
Point of order, Mr. Julian.
I'm relating it back, Mr. Chair.
It's actually.
I think you're anticipating the point of order. Mr. Julian, what is your point of order?
I have no objections to Mr. Fragriscado's carefully prepared arguments. Not enough. I just wanted to verify through you, Mr. Chair, with the clerk, that Alistair McGregor, the MP for Cowichan and Malahat Langford, very dedicated guy who will be taking my place, has that the papers have been submitted and that he can take over for me for the next few hours, and I'll be back this evening to enjoy this filibuster in the second or third round.
Madam Clerk, yes, she has. Peter, you're okay.
Okay, with that point, I will leave you all and see you later on.
Okay, Mr. Fragriscados, back to you.
Thank you very much, Mr. Chair. I take a bit of issue with Mr. Julian characterizing what's happening here as a filibuster. I think it's a spirited debate, Mr. Chair. Filibuster carries certain connotations. I think, and I don't doubt the sincerity of Mr. Julian. He's a sincere person who I disagree with a lot of the time, but he is someone that has added a great deal to committee deliberations. But it's a spirited discussion that's happening here, and it's nice to see Mr. McGregor at the committee. Someone who, yes, here too I disagree with on a number of issues, but he adds a great deal to Parliament. I know he's been justice critic on the part of the NDP in the past. I've sat in on Justice Committee in the past, not as a formal member, Mr. Chair, but sitting in and hearing his thoughts on a number of issues relating to justice and human rights. He always adds something to discussion, and I know that he'll do that here tonight. To the point that I was discussing earlier before the intervention of Mr. Julian, talking about restaurants. Again, Todd Barclay, President and CEO of Restaurants Canada, has welcomed the various, and there are many programs, Mr. Chair, as you well know, that have been introduced at the federal level that are benefiting restaurants, but they need ongoing support, as he has said, and I'm quoting here, to help restaurants pull through the ongoing pandemic. And isn't that true, Mr. Chair? I mean, you talk to restaurant owners, rather, their workers. You talk to hotel owners and their workers, the tourism sector in particular. These are ailing industries. One of the points that, or one of the sectors that we all too often ignore, however, is the meeting and events sector. Yesterday, and I mentioned this in earlier in today's meeting, Mr. Chair, I had the chance to sit down. It was a tour, actually, a socially distant one, but sat down with a local business owner who operates a meeting and events business. They build basically different stations that you would see at trade shows. Obviously, trade shows are not happening right now. He employs well over 30 people, close to 40 actually. Right now, his numbers are down to 10. He was very thankful for the wage subsidy. It's the only thing that is keeping his business going. But those are the folks that we need to hear from. We don't need to continue to go in circles in the way that we have, debating issues that we've already talked about in the summer. And it's not as if the government and Liberal members here at this committee are trying to ignore what the opposition is saying. Again, we had a very good, reasonable solution, if not a compromise. But that's politics, isn't it? Where Mr. Gerritsen put forward something that I thought really would have worked. And now here we are back to Mr. Kelly's motion, which, as we have put on the record ad nauseum, I'll admit, but perhaps it needs to be put on again. So I'll do that here. Is a problematic motion. So that's all. That all has to be kept in mind, Mr. Chair. I continue to look at things that key stakeholders have raised, and I wonder what those stakeholders are thinking when they see us debating amendments to motions as we are here today and continue to do. The YMCA, Mr. Chair, obviously a well-respected and well-recognized organization, wants to see pre-budget deliberations carried out. Nature Canada wants to see pre-budget deliberations carried out. And I think on this specific point of Nature Canada, let's not forget that issues of the environment have to remain front and center. How we address the issue of the environment, making sure that it's not put on the back burner as it so often has in modern Canadian history, making sure that it is front and center, that we do build back better, that a COVID-19 economic response plan takes into account the importance of the environment. Take a look at what has been said at this committee previously by, if not my Conservative friends, then certainly the NDP and the Bloc Québécois, talking about the need to not ignore the environment. That's something that we embrace as a committee. Liberal members feel the same way. We will disagree perhaps on the nuances, on the details, but I share the sentiment of Mr. Saint-Marie, who's an extraordinary member of this committee, regularly contributes. I know he has a background in economics, has taught economics. When I hear him talk passionately about the environment, I take that very seriously. Mr. Julian, very, very insightful thoughts on the environment. Yes, we will disagree on particular matters relating to pipelines, and I won't get into the specifics of that. But I know Mr. McGregor, I've heard him speak in a very passionate way in Parliament as well on issues relating to the environment. When we continue to debate motions, amendments, we're on the amendment to the motion. But the point holds, Mr. Chair. It means that we are not discussing the environment. It means that we are not discussing the issue of how to build back better, which is an interesting idea. This whole body of thought that has emerged that says that we have a new opportunity to embrace an agenda that allows for the environment to be front and center.
Point of order, Mr. Chair, is talking about Build Back Better relevant to the motion? I'm confused because I thought we were going to try and get to a vote.
Point of order on that.
I was muted, Ms. Jansen. I hear your point of order. I'll hear what Mr. Gerritson's view is also on the point of order. Well, I ask that certainly members be as close to relevant on the amendment as possible. This amendment is pretty broad, therefore it's fairly wide-ranging. Mr. Gerritson.
Oh, well, you took the words out of my mouth, Mr. Chair, in the sense that you said that it's a broad motion, in that it's asking for a whole whack of documents to come back. That's what this amendment is doing. And what Mr. Fragaskatos is doing by talking about these other important things is he's highlighting the fact that we're asking officials from Parliament to be working on this stuff when there are other more important things that he believes that they should be working on. So I would suggest that his what he's discussing and the route that he's going down is extremely germane to the discussion that we're having on this particular amendment. I mean, the opposition might not like to hear that, but it's the reality of the situation.
I will allow Mr. Fragaskatos to continue to go down this road, but don't go too far down it, or we'll have to pull it back.
Thank you, Mr. Chair. I appreciate the interventions of colleagues. It's not my intent here to obstruct the discussion, to stand in the way of what has been proposed by Mr. Kelly in the form of an amendment to a motion. Of course, we need to deal with that as a committee. But I've said at length here that when we continue to debate matters that have been dealt with in so many ways, maybe not to the satisfaction, the pure satisfaction of opposition colleagues, it obstructs us from dealing with the substantive matters at hand. And those relate, of course, to the environment. Those relate, of course, to COVID-19. Provinces are dealing with the issue from a health perspective. Of course, very happy to see the federal government step up to support provincial governments with the Safe Recovery announcement that we saw a number of weeks ago. $19 billion, Mr. Chair, for provinces. How those provinces put to use that very large amount of money, admittedly, but necessary amount, is up to them. But let's continue to hear from the Federation of Canadian Municipalities, not only mentioning provinces here, but hearing from the FCM on what cities and towns require during this time. Notice, Mr. Chair, I'm putting on record what I'm hearing from constituents. And what I'm hearing from constituents is not relating to anything that the motion and the amendment to the motion has brought up. I'm hearing from constituents on their everyday challenges, and those challenges have only been accentuated because of COVID-19. So this is where the country is. Let's not also ignore the very important issue of Indigenous affairs and how the Canadian government seeks to continue to build forward, or to put forward rather, an agenda that is in line with the general ethic of reconciliation in this country. We could be raising all of those matters right now at committee in a pre-budget deliberation. I don't know when we'll be able to do that, when we have the opposition continuing to raise issues in this committee, on other committees, that are not really in line with the desire to advance the interests of Canadians, that are completely in line with a desire to promote political interests, to exert as much, and if I can quote from my learned colleague, Mr. Gerritsen here, as much political carnage against the Prime Minister and the government of the day as is possible. At no point have I heard Conservative members in the motion and the amendment to the motion bring up how either seeks to advance the interests of Canadians. There's been no argument put forward to that effect. And Mr. Chair, that's very disappointing, because my constituents, all our constituents, Canadians across the country, deserve better. They deserve a finance committee that recognizes its fundamental role. We need to be very serious about gathering ideas that will, if not binding, certainly serve as important advice for the Minister of Finance, for the Prime Minister, and the wider cabinet. And will we have our way on every single point of advice? No, we will not. That's not the expectation at all. But certainly we've seen this government listen to this finance committee in important ways. There's been a number of things. In fact, I would, and perhaps I'm overdoing it here, Mr. Chair. I could be accused of that, but I don't think so. If you look at the programs that have been introduced and the changes to the programs that have been introduced as we've dealt with COVID-19, I'm thinking about CEBA. I'm thinking about the need to support Canadians with rent through SECRA. I'm thinking certainly about the payroll subsidy that the government has put forward and very thankfully renewed, as we saw in the throne speech. That will continue until the summer of 2021. That's another point I continue to hear from business owners, how thankful they are on that, Mr. Chair. This committee had a central role in suggesting a lot of those ideas. Based on what? Not on our own musings, Mr. Chair, but on the thoughts, ideas, analysis of expert witnesses, whether in the form of organizations like the Canadian Centre for Policy Alternatives, which I know Mr. McGregor will sympathize with, like the Chamber of Commerce and the Canadian Federation of Independent Business, not to mention a number of business owners, small business owners, but also large business owners that I think my Conservative colleagues sympathize with. At least I certainly hope so. They're not behaving in that way right now, though, at this committee. And certainly us on the Liberal side have paid attention to. Those programs have kept the country going. There's no exaggeration there. They have kept the economy going. They have kept individuals going. And what are the results? We see Canadians, yes, struggling, but at the same time, the country, when we compare ourselves to other G7 partners, we're doing rather well. We still have a very sustainable debt to GDP ratio at in and around 48%. I know the Conservatives, and they're free to do it when they want to get back to the issues that genuinely matter at this committee, will bring issues of debt and deficit up. What they fail to ignore is that at 48%, we're still at a very reasonable debt to GDP ratio. That's something that can't be ignored, Mr. Chair. In the mid-1990s, when the IMF called us an honorary, and I'm quoting here from the Wall Street Journal of the day, in 1994, I believe, it was the Wall Street Journal that said that Canada was an honorary member of the third world because we had a debt to GDP ratio of 67% at that time. We're not even close to that. But let's debate these matters in a meaningful way at committee. I know witnesses want to come and tell us that, but here we have opposition colleagues continuing to go round and round and round on all of these particular issues. So that's the challenge I have, Mr. Chair. And let me also say that there's so many sectors that want to make the case. I've talked about the importance of the environment. I've talked about Indigenous issues. I've talked about everyday people working in restaurants and hotels, in meetings and events, in the tourism sector, but the building sector too. There's such an important economic driver. I remember seeing very recently the view of the Canada Building Trade Union, that they are ready to listen to the government, to work with government on infrastructure programs, shovel-ready projects that would stimulate the economy. I'd love to hear from them, but I can't do that right now. None of us can do that right now. So we are where we are in this on this issue, Mr. Chair, and that's the sad reality. I'll leave it there for now. I thank the committee for indulging me. Again, Mr. Chair, we've got to have a pre-budget deliberation. And in the time that I've taken to speak, which I know has been some time, I wonder if you or the clerk have an answer on what happens if the committee is found to be in violation of Standing Order 83-1, what the consequences would be. That's something that I've looked at, Mr. Chair, in parliamentary procedure and practice. There is confusion on that point. I think I know the answer. The book and what a book it is for new members at the committee. I'm looking at Ms. Jansen, who's smiling at me now. I can see on the screen in a very collegial way, I'm sure agreeing with my points. I would advise Ms. Jansen, if she hasn't already done so, and other new committee members to take a look at parliamentary procedure and practice by Bosch and Gagnon to see to familiarize themselves with the standing orders. Under 83-1, as I've said, we have an obligation as a committee, but what happens when standing orders are broken? I know that mention is made in that book about parliamentary agents, which I take to be MPs, and if MPs are found to be in violation of the standing orders, the consequences are quite serious, Mr. Chair. But I was a bit confused on if parliamentary agents refers to some other specific category or whether it is referring specifically to MPs. So clarity on that point would be appreciated. But it goes to that's a related point. The key question I started with was what happens when we have a violation of 83-1. All these issues that I've raised relate to that need to begin a pre-budget set of hearings. Those deliberations are, well, I've made the point. You know how I feel, okay. Mr. Chair.
Thank you, Mr. Fragiskatis, and I will take a stab at that question. The only other person I have on my list coming up next then would be Mr. Gerritsen, but for the benefit of the committee as a whole, 83-1 in the standing orders states Standing Committee on Finance to consider budgetary policy. Commencing on the first day of September of each year, the Standing Committee on Finance shall be authorized to consider and make reports upon proposals regarding the budgetary policy of the government. Any report or reports thereon may be made no later than the third sitting day before the last scheduled sitting day in December, as set forth in Standing Order 28-2. So that is the direction from the House to the to the Standing Committee on Finance. What would be the consequences? I don't think the penalties or consequences are really spelled out. I think it would be up to the House to decide. But it is something that we could refer Madam Clerk to the Law Clerk to see if we could get an answer on at some point. I don't think we need the answer tonight, but I think it'd be up to the House to decide if the committee and its membership didn't meet the standing standing order 83-1. I will say that the Standing Committee on Finance is always in a problem on election year. Last year, the hearings get rushed. We did do the hearings last year and made them in. The analysts did a great job of putting it together and getting our work done in a fairly straightforward way. Okay, then with that, we'll go to Mr. Gerritsen. You're on, and we are on the amendment to the original motion, I believe.
I believe that Annie was trying to get your attention. That's what I was trying to signal to you, Mr. Chair.
Okay, Ms. Koutrakis, you're on?
No, I'm fine, Mr. Chair. Sorry if I confused the committee.
Okay, so Mr. Gerritsen.
Sure, I will take it then. Mr. Chair, that I find it, very discouraging that we have been around this a few times, and we're trying to bring through a sub-amendment. If it hasn't become overtly obvious by this point, what we're trying to do is we're trying to bring some points back to this so that the credibility of, or not the credibility, but that the reliability of, and the clarity, I should say, of the information that is coming back is done so in a way that people can properly understand it. And what we're hearing through this discussion, we're hearing quite a bit from the other side is, well, what about timing? What about 24 hours? We need this 24 hours. And, it leaves me to the conclusion that all that's really wanted is some kind of smoking gun that the Conservatives think exists out there. And I think that they're going to be very disappointed when, we do finally come to some kind of conclusion as to how the information will come back and in what way to make it as clean and clear as possible. Some of my colleagues pointed out in their speeches earlier, Mr. Fraser, Mr. Fragascatos, about, exactly why so much of the information was redacted. I know that Mr. Poilievre had the opportunity to do a little grandstanding, as I said earlier, and stand at the podium and wave around his blacked out pages. But if you actually take the time to look, to just go in and see the notes next to that blacked out stuff, which I look forward to sharing with the committee when we get back to the main motion, because I realize we're on the amendment right now. But when you actually take the time to actually go and look at that, you end up seeing that the vast majority of it is extremely, disconnected to this actual issue. And that's the only reason why it's being blacked out. And I look forward to the opportunity to really dive into that in a little bit and to share in great detail what is in those pages, because I think that the Canadian public, quite frankly, Mr. Chair, has the right to understand that. Monsieur Poilievre wants to paint the picture that some political operative sat in a room on the top floor of West Block and with a big black thick Sharpie marker and went through all of these documents line by line, blacking everything out. But in reality, it was done through a very methodical way that's done through independent individuals that are concealing information that is just not germane to the motion that was put forward by this committee. And that ultimately is what's there. So I realize that the members of the opposition are getting a little bit frustrated, rightfully so, that this is taking a long time. But what the Liberal members are trying to do here, if I have to make it extremely clear, is to put some parameters around how the information comes back, making sure that the information matches up perfectly as I tried through one sub-amendment and then through the other sub-amendment. You know, understanding that that could take a lot of time. The other sub-amendment was, okay, well, why don't we at least annotate and cross-correlate where the pages are so that it becomes easier for people to see that. And you're routinely seeing members of the opposition completely shoot that down because there's no interest in that because, Mr. Chair, that's not their end game here. Their end game is to wave around more blacked out pages. And I think it's extremely unfortunate because it's disingenuous to the intellect of the public. It's suggesting that the public can be easily lost in the idea.
Point of personal privilege, if I could, Mr. Chair. I think it's unfounded for the member opposite to be giving opinions on what the opposition's mental state is, intent, or general attitude when we have not in any way, shape, or form made any comments to that effect. And I think that while this debate around the amendment may be important, I think we should stick to the facts at hand and discuss the topic rather than taking personal shots at the members of the committee.
Okay.
Thank you, Mr. Chair.
So I'm going to just reply to that point of order before you rule on that. I think it is extremely rich, with all due respect to this member, Mr. Poilievre, and another of other members, to be criticizing, taking shots and personal attacks at other members of Parliament. Have you seen a question period, Mr. Chair, in which this member or Mr. Poilievre gets up? They don't have anything to contribute other than personal attacks. My attacks are not personal. I'm suggesting, I'm just providing input into this point of order, Mr. Chair. I am suggesting as to what I see the motive is behind this, and I'm entirely within my right to do that. I'm sure that this member, and by the way, her mother is a great constituent of mine, lives actually just down the street from me on Highway 2. My in-laws actually live right across the street. I have a lot of respect for this member, is what I'm saying about that.
If everyone would come to order. Everyone would come to order.
And I guess all I'm saying is...
Come to order. Come on, Garrett, come to order.
Just to finish up my point of order there. I guess all I'm saying, Mr. Chair, on my point of order is that I am attributing what I believe to be the political objective here, not an individual person's motive. And that is entirely fair because it happens all the time in our parliamentary process and democracy, generally speaking. And, so if you want to rule on that, but then I'd like to continue.
I don't think there's anything to rule on. I'm seeing both as a matter of the debate in the context of the discussion here. So go ahead, the floor is yours.
Thank you. So just getting back to that, I'm concerned by the fact that
point of order, just quickly, sorry, you're saying that he can talk about our motivation as part of his debate. Sorry, that's what we're saying. And that's relevant to the amendment?
It is relevant to the amendment because it's relevant to the conclusion of the motion.
But it's his own conjecture what our motivation is. I mean, we've been trying to get this sped up, and he's giving us a different motivation.
I'm seeing it. I'm seeing. No need to be sorry. You're entitled to make your point. I'm seeing it as part of the debate in the reason for the motion, the analysis around the motion, the different opinions on the motion. And we're seeing these kind of points raised by all sides in the debate thus far. Mr. Gerritsen.
So thank you, Mr. Chair. Just jumping back to that. So what I'm basically getting at here is what I perceive to be, what's going on, and the only objective is to try to bring forward something in such a quick fashion as to be able to grandstand with the information. So what we've been trying to do, and this is what I've been getting at, Mr. Chair, is we've been trying to put forward some amendments to the motion to set out the parameters in which the information is delivered so that it can be done in a way that is very easy for people to digest, for members to digest, for the Canadian public to digest. And that's the premise of the two motions that I had brought forward previously. And so I bring forward another motion to you, Mr. Chair, and hopefully that the members would agree that this sub-amendment would be more, hopefully they will find this one to be more in line with what they think is appropriate, because I think this one is equally as important. So it reads that, and further, that the committee requests the complete package of documents provided to the Office of the Law Clerk and Parliamentary Counsel of the House of Commons by relevant deputy ministers or signatories of the transmittal letters, as well as final packages of documents that the Law Clerk and Parliamentary Counsel of the House of Commons approved for release. That both the document packages be provided to the committee no later than October 19th, 2020, and that after the committee reviews the two different versions of documents, the committee invite each of the relevant deputy ministers or signatories of the transmittal letters, as well as the Law Clerk and Parliamentary Counsel of the House of Commons, to give testimony regarding the redactions applied to the documents that were requested and granted in the motion adopted on July 7th, 2020, and that until such time as the testimony is complete, debate on the motion and the amendment from Mr. Poilievre be suspended, and that the chair be authorized to schedule these witnesses and convene a meeting to resume the debate on Mr. Poilievre's motion once these meetings have taken place.
Okay, is the
I'm just wondering,
motion,
is this admissible? Because this is not Mr. Kelly's amendment anymore. I'm not sure what's happening all of a sudden here.
No, this is where we are. Is we have the original motion by Mr. Poilievre. We have the amendment by Mr. Kelly. We now have another sub-amendment from Mr. Gerritsen, and what I heard on it, it does relate to the motion and the amendment that's on the table, and it is substantially different from the previous sub-amendments that were debated and lost. So the sub-amendment is in order, but I was going to say, does the clerk have a copy of that, and can it be sent out to members for their discussion, or how soon? We'll let you.
I already have it in. I already have it in English and French, Mr. Chair. I'm happy to send that to the clerk right now.
If you could send it to the clerk, and
we will send that over.
We'll let you speak on it for a further moment if you like, and then we'll go to we'll establish a new list. I'm still looking at the old list, so I have Miss Zerowitz first. Is there any others want to raise their hand? That I can. Did I see you, Mr. Fragiskatis? Mr. Fragiskatis? Anyone else? Okay. If you'd send it over to the clerk, she can send it out to people. They can have a good look at it, and you can speak on it.
Thank you. And I just confirming that my staff are sending that out, so everybody should have that shortly, and it'll go via the clerk. And I guess, you know, I'll get back to what I was saying previously, is that I'm trying to find a solution here as to how the information can be transmitted you know, back to committee in a way that is going to be able to take, you know, have the proper—
Point of order.
Point of order, Ms. Vecchio.
I'm just wondering, just looking at procedural stuff, since the sub-amendment is not in order, it includes suspending debate on the main motion. Can we check on that? Because, I mean, we have an amendment, a sub-amendment, but this is actually another amendment. He's saying it's a sub-amendment, but how many amendments should we be going into?
This is, it is in order, I believe, unless somebody can give me a reason. It's not. It's just to back up a little bit, Karen or Ms. Vecchio.
Karen's good.
The original motion came in from Mr. Polyev, and I know you come in a little late, which you're filling in for somebody else. Then there was an amendment by Mr. Kelly to basically to pull the documents from the first session of the 43rd Parliament. Then there was a sub-amendment that was debated for quite a while, that lost. There was a second sub-amendment and that lost. And this is a third sub-amendment. The sub-amendment is allowed. It wouldn't be allowed if it was attempting to do the same thing as any of the sub-amendments that lost. This one is substantially different than the other sub-amendments that were debated. So I do see it as an order, unless the clerk sees something different here. So the floor is yours, Mr. Gerritsen.
Thank you, Mr. Chair. So just getting back
point of order, Mr. Chair.
Yeah.
I beg to differ on your ruling there. A sub-amendment cannot significantly alter the intent of the original amendment or the original motion, and this certainly does that. It's a significant departure from what the motion and the amendment are.
No.
And I think you need to rule it out of order, and I'd like to have the clerks weigh in on that.
Well, on that point of order,
I'll give my comments on that, Mr. Falk. The intention of the sub-amendment is to raise the point of privilege with the speaker. It asks for certain documents when you go through it one by one. I don't want to read it. To go to the speaker, and the reasoning there, and the reasoning why Mr. Polyev believed there was a point of privilege there. This does not change the intent of doing that, other than it basically asks for further review to make sure the documents are all in order going forward. That's all it's doing. Mr. Gerritsen.
Thank you. And I just want to say, I've seen this now on both the PROC committee and in this committee, Mr. Chair, where conservative members are asking the clerk to weigh in and make a decision. The clerk is not there to provide advice to the committee. The clerk is there to provide advice to the chair. The chair makes the decisions. And I don't think it's appropriate to be putting government officials in positions like this.
Point of order, Mr. Chair.
I don't believe were you weren't on a point of order, Mr. Gerritsen?
I was supplementing the point of order that had been previously raised.
He was back to his speech.
That's fine. If Miss Vecchio wants to come in,
go ahead. Go ahead, Miss Vecchio.
With all due respect, and Mr. Chair, you know I have the greatest respect for you, but there is the opportunity for us to question the ruling of the chair. So thank you, Mr. Gerritsen, for your input. But if the members of the committee on the majority did not agree, we can vote down the decision and go that forward as well. So that's an option. But please, but no more personal attacks. Thank you.
This is not a personal attack. This is not a personal attack. In actually, what I'm trying to do is defend the independence of the public servants. Mr. Falk said, "I would like the clerk to weigh in on this." It is not the clerk's job to weigh in on the procedure. That is the chair. And I think that anybody.
Well, unfortunately, Mr. Gerritsen, the chair asked the clerk for her opinion. So
not on that matter.
Exactly
he didn't.
That matter whether or not your sub amendment was legitimate.
If I need the unless the clerk thinks otherwise, I can talk to her offline. If you want to suspend, and I'll talk to the clerk. Do you want me to do that? Or otherwise, we'll move ahead. I can have a 5-minute chat with the clerk. I will.
Order, Mr. Chair.
Go ahead.
My understanding is that because it was ruled in order and Mr. Gerritsen began, that everything's completely fine. That things are in order here. Now, if the Conservatives wish to make up or at least reinterpret parliamentary procedures, let me be more diplomatic in my language, then that's up to them. But look, Bosch and Gagnon are very clear on these points, and again, I'd invite my colleagues to bring a copy with them to meetings, as I have in my office here with me.
So that we are on absolutely solid ground here, I will suspend for 5 minutes. It'll give people a little break anyway, and I will talk to the clerk offline. I'll give you a call on the cell, Evelyn. A meeting suspended for 5. motion is in order as it relates to the original motion is what we can determine, but it's at a place in where we have it, because when you look at the document as a whole, it will produce on the motion that's going to the speaker conflicting dates on the whole final product, if I could put it that way. So if Mr. Gerritsen could, whether it should be moved as a sub amendment to the amendment or placed elsewhere in the document, that it would flow better and we don't have conflicting dates in the motion as a whole that's going to the speaker. It would work better. It's in a sense in order, but it just doesn't flow.
So if I may, if I may on that, Mr. Chair, so we could also change the dates that are in the main motion to fix this, which I think the point would be entirely appropriate if this motion was to pass, because if this motion passes, then it automatically creates the need to change the dates in the main motion. So I think that my preference would be to continue with this, because what my motion in a sense does is say, let's get the public, let's get the officials here to weigh in on this and to provide their input. And then we continue on with Mr. Poilievre's motion. And then if at that time it's determined, okay, well, now the dates in his motion don't, you know, they're not achievable anymore because we passed some of them, they can always be changed at that time, or they can be changed when we come back to the main motion, right?
Yeah. Mr. Easter, it's Karen Vecchio, just asking on this with point of order, sorry. When I'm looking at this, the motion that Mr. Gerritsen has put through actually amends what would be Pierre Poilievre's motion, and not so much such a sub-amendment to Pat Kelly's motion, specifically that it is changing those dates. So that's one of the concerns that I have.
That's what I'm basically saying. I think the amendment, okay. I think really what you need to do is hold the motion, get it out to members so they can read it. We deal with the amendment, and then if you were to move that as an amendment to the motion as amended, it would flow better on the whole package, and we'd see where it goes then.
But the reason why that doesn't work is because what I'm addressing in the amendment is specifically related back to the documents that we're trying to bring back in through the main motion.
Point of order.
Yes, but if you, okay, I'll take the point of order, Ms. Vecchio.
Thank you. I don't know if you want me to do a point of order or just continue, but the fact is he is making an amendment to an amendment, and so it has to be deemed to the amendment, and what he's talking about is the main motion. If he wants to do that, he can make an amendment to the motion, but unfortunately it cannot be heard because there is a motion already on the table. Well, so I think this is a way of circumventing that, but I think the fact is it's out of order.
I think I'll take your point of order, Mr. Freg. Was it Mr. Fragiskatis?
It was, yeah.
And then I'll make a comment. Yep. Go ahead, Mr. Fragiskatis.
Excuse me, sorry, I thought you were going to make the comment, but I obviously misheard. Mr. Chair, it's vital that we follow parliamentary procedure and practice. Bosch and Gagnon on page 580 say footnote 580, that is the relevant one here. And I'll quote as follows. Decisions by the chair are not debatable. They can, however, be appealed to the committee. To appeal a decision by a chair, a member must inform the committee of his or her intent immediately being the key word, after the decision is announced. The chair then asks the committee the following question: shall the decision of the chair be sustained? The appeal that was, if I remember correctly here, it was Mr. Falk. Mr. Mr. Falk did raise his hand and make an appeal, but that came well after the fact. And that fact is that you recognize the motion to be in order, and Mr. Gerritsen was given the floor to speak. So I'm afraid all of this that we're now engaged in appears to be moot. That's not just my opinion. It's an opinion that aligns with the facts being based on what the record of practice in Bosch and Gagnon guides us with. So I think that we ought to continue respectfully, Mr. Chair. Of course, it is your choice. I think we ought to continue by allowing Mr. Gerritsen to expand upon and discuss the merits of his sub-amendment. And I know a number of other members wish to raise their perspective as well, and I would count myself in that group.
Point of order, Mr. Chair.
I didn't catch who that was. I think it was Mr. Falk. Was it? Is that your voice?
Thank you, Mr. Chair. Yeah. What Mr. Fragastatis has just stated is not accurate. I did, in fact, raise my point of order immediately after you made your comment, and it was you yourself, Mr. Chair, that had suggested getting the opinion of the clerk, and I just was affirming your suggestion. So Mr. Fragastatis was completely off base with his assertion that my comment was out of order.
Point of order, Mr. Chair. It was not immediate. We can go back to the record. It was not immediate. Mr. Falk is, I know he's an experienced member, but he will recollect, I hope, that it was not an immediate appeal. And Bosch and Gagnon is very, very clear that the appeal has to be immediate. You had recognized Mr. Gerritsen's sub-amendment to be in order, and for that reason, I think that we are not focused on the right thing here. I think we need to be talking about the sub-amendment.
My concern is that it doesn't make the motion, that it does, that it takes the flow out of the motion. I do believe the motion is in order, but misplaced. I will keep it. I will stand by my original decision and state recognizing that other changes are going to have to be made in the original motion to make it flow if this one carries. If this one doesn't carry, then no worries.
Point of order, if I could, Mr. Chair.
Yeah, and then I'll go to Mr. McGregor.
Thank you very much. No one said that, no one uttered the phrase challenge the chair. No one formally put that on the record. And as I've said already, and I think it's a critical point, so that's why I'm emphasizing it, Mr. Gerritsen had begun speaking after you recognized his sub-amendment to be in order. So again, respectfully to Mr. Falk especially, I appreciate that he disagrees, but his disagreement's not in line with
I hear you, and I do know the challenge to the chair had to come earlier. Mr. McGregor, I'll hear your point, and then we'll go back to the discussion on this and vote on it. Mr. McGregor, are you there? Did you want to make a point, Alistair?
Yes.
Okay.
Can you hear me?
Yeah, I can hear you now.
Okay. Yeah, so I have Mr. Poilievre's main motion in front of me. I have the amendment, I guess, by Mr. Kellaway. Mr. Chair, it's just a point of, it's a question. When is Mr. Gerritsen's sub-amendment going to be electronically distributed to committee so we can have everything in front of us?
Do we, has your folks got that sub-amendment to people yet? You don't have it, Madam Clerk, yet? Okay. Can we?
I'll double check on that right now.
Double checking that right now. We'll just hold a minute and double checking that. In the meantime, we can talk about the weather in the Charlotte Islands.
Well, that opens it up too, Mr. Chair.
Yeah, I know it's not good. Any word from them whether they got that sent, Mark?
Sorry if there was some confusion on that, but it is on its way to the clerk again. My staff were originally going to do it, but it is on its way to the clerk.
Okay, Madam Clerk, if you can get that and send out it out to people. I'm going to let Mr. Garrettson finish his remarks, and then hopefully by that time all the documents will be in front of people. If anybody further wants to speak, we'll allow that, and then we will go to a vote. Mr. Garrettson. You're muted, Mark.
Apologies. This is on my amendment, Mr. Chair?
Yep.
Okay. So, I mean, I put this forward as another attempt. This is my third attempt to try to provide some clarity around, what's expected and what's going to happen. And I think that the committee should get to hear from public servants who did the redactions, and the law clerk and the parliamentary council. What the opposition is doing, again, I don't want, I'm not, this is in my opinion, I don't want to get criticized of attacking anybody, personally, because that's certainly not what I'm doing. I'm addressing the way that I see this is that what they're doing is finding officials. What the opposition is doing is finding officials to have breached privileges of Parliament without even providing them the due process of explaining themselves. The due process, I believe, Mr. Chair, is extremely important. So if after the committee has heard from the witnesses and it is still not satisfied, then it can take whatever actions is deemed necessary. But we need to afford that due process, Mr. Chair. I think that in light of, allowing that due process to occur, that we should pass this motion to invite those officials. I mean, if the opposition is genuinely and truly interested in getting information in front of them and getting down to the bottom of this, why they wouldn't support bringing those officials to the committee to explain the process for themselves is a mystery to me. You want to talk about transparency and clarity and the need for accountability. What could be more accountable than having these individuals come to committee and address the issue and explain this? Now, you'll remember that earlier, Mr. Chair, I talked about what I perceived as the motivation. It wasn't about getting the information as much as it was trying to sensationalize on blacked out documents. You'll recall, Mr. Chair, that I spoke to that. Now, there's a very easy way to prove me wrong, which is to support this motion, to let the individuals come forward, to let them speak, and to let their voices be heard on this. And if you don't do that, then you're leaving the question of, well, why wouldn't you want to do that? And that's how I come to the conclusion that you don't want to do it because it might make this argument of some, massive conspiracy that's been trying to be built up over the last several months completely fall flat. And so if people vote against this and they're basically saying, no, we don't want these officials to come forward and explain the process, in my opinion, what you're basically doing is you're saying, no, we don't want the details. We don't want the facts. That doesn't matter. We want the sensational part of Mr. Polyev waving around blacked out papers that he probably just made a square and painted it black and hit print and use that as
point of order. I don't know that it's right of a member to suggest that somebody was bringing a fake document to a press release. And we do continue to argue the problem.
I would say that is out of order, Mr. Garrettson. Go on with your argument.
Yeah, that's a really good point. I don't want to think that either, so I'll take back that comment.
Apologize and resign.
Listen, I'm trying to be as candid about this as possible, and as honest about this as possible. If you want to get down to the truth and you want to really understand why those items were redacted, why wouldn't you want to bring forward the people that can explain how and why they did it? And if you
point of order, again, we're not asking why they were done. We were supposed to.
This is not a point of order. This is not a point of order. This is debate.
I think, Madam Jansen.
No, I know you want to do it.
I think that, Madam Jansen, is debate. It's not a point of order. We'll finish with Mr. Gerritsen. We'll go on to Ms. Zerowitz, and if you want in, then we will go to you, and hopefully we'll go to a vote after that.
I get the sense, Mr. Chair, that I'm hitting on a nerve. Maybe I'm on to something here, because every time that I bring up this point, conservatives tend to jump all over it and try to, say he's personally accusing us, he's doing this, he's doing that. I think I'm actually getting to some of the truth here, which disturbs conservatives over this, and that's why they're trying to throw me off every time that I'm in the middle of bringing this topic up. So, I mean, listen, you want to hear from people, you want to get the truth, you want accountability, then let's hear from the people that made and produced the documents. Let's just not go down the road that provides the sensationalist kind of information that people can have, because you're just showing a political motive to all of this, as opposed to one that truly gets to truth and accountability. And I mean, my comments go, not just to the Conservatives, but indeed to the NDP and to the Bloc as well. If this is really about that, then I'm sure that they'll find it necessary to hear from the people that did this. So I'll yield the floor now. Thank you,
Miss Zerowitz, and then Miss Jansen.
My mom, when I was about to be born, thought I was going to be a boy. So maybe this is why I get the misfits.
Maybe that's why I call you Mister.
It's true. Anyways, thank you, Mr. Chair. And I'm going to repeat a little bit about what Mr. Gerritsen had mentioned. I think if you step back and look at what Mr. Poilievre's motion is about, and really from what I've heard from Mr. Julian, we haven't heard a lot from Mr. Saint-Marie, but my understanding is that he has this worry as well, is that if there is a belief that the redactions within the 5,600 page WE documents that were released towards the end of August, the redactions were made because the Liberal government was deliberately trying to hide something, then this motion gets directly to the point. Because the other thing that I've been hearing, and I've been hearing from Ms. Jansen, I've heard from Mr. Julian today, is let's get going on stuff that matters to Canadians. So if we're trying to get to that, and if we need as a government to be able to prove that civil servants independently redacted this, and if we could actually bring them to committee, have them respond directly to the committee, directly provide the documents relevant to the committee, actually ask those questions ourselves in the public light, then I think we should be able to clear this up and move on to the business of why it is that we exist right now. Let's ignore the fact for a moment, Mr. Chair, that because we sort of forget, the documents were just one part of the whole, I think, looking into sort of the concerns around the selection of WE to run the CSSG. Recall that we actually had almost 2 full months of meetings on this committee, never mind the other committees, and never mind that the Ethics Commissioner is looking at it, as well as the Auditor General. We've already proven through, and you could go through all the people if they want to remind themselves, whether they're new members or old members or new members to this committee or old members to the committee, they want to remind themselves there's actually minutes that show this wasn't corruption. There was no misuse of funds. This was we was independently selected by our civil servants. We didn't do a sole source contract. We selected a contribution agreement for very deliberate reasons with clear parameters, and we absolutely did this for students. So I would say to you, this is an amazing opportunity. So what this motion says, and I hope people have had a chance to look at it at this point, what it basically says is it's suspending the original motion that Mr. Poilievre put aside and the amendment, so both of those, in order for us to be able to provide the 2 sets of documents that we've kind of been talking about today, as well as to bring forward the relevant civil servants who are in charge of actually doing the redactions. So that would allow the committee to actually hear directly from them. This would all be done in the public context. If for some reason the opposition is really unhappy with what they're hearing or they don't think it's enough, then we can come back and we can actually make a decision to come back to the original motion of Mr. Poilievre as well as the amendment. Although I would hope that we would be able to get past this, because as my colleague Mr. Gerritsen had indicated, then we will see that this is just a game. And this is just a way of our opposition members being able to say, well, you know what, we just want in some way to make the Liberals look bad. Right now, we are in an unprecedented pandemic. Canadians are asking us to be our best selves. Canadians are asking us to be the government that we need, to be the government that they need us to be at this moment. And that means we have to get past this partisan stuff. We have to get past these games, if only for the moment, if only for this year, because we have some really important work to do. So if this is what it's going to take, that we have to bring the officials who actually did the redactions, if we have to spend a meeting or two on actually discussing it, then let's move forward and do it so that we can get on as fast as possible to the important work that we have ahead and to rebuilding our economy and to supporting Canadians through this most unprecedented pandemic. Thank you, Mr. Chair.
Okay, I have, and I don't know if there's other after this, but I have Ms. Jansen and Mr. Fragiskatis, and then we will go to a vote, hopefully. Ms. Jansen.
I just wanted to say that from what I understand, Mr. Gerritsen's motion is to be able to explain why the nonpartisan public service redacted the documents, as opposed to the people that were supposed to, which was the law clerk. So this exact same thing happened at health. Instead of it going straight to the law clerk, who is just as nonpartisan and is just as efficient and amazing at his job as the nonpartisan public service, it would have been perfectly fine for it to have gone to him instead of being done the way it was done. So I don't understand why he's saying, why he now wants to make this about why it was done like that, when it should be about, who should be doing it. That's what the motion is about. Who should have done it? The point of privilege was the law clerk was supposed to do it. He didn't. This is not done just here for the WE documents. It was done at health as well. So I think, just the fact that Mr. Gerritsen suggested that Mr. Poilievre brought a fake document to a press release kind of shows you who's doing political theatrics here.
He did withdraw that
I did, and I think the public knows who does the political theatrics.
Okay, we're not going to get into that argument. Mr. Fragiskatis.
Thank you, Mr. Chair. I think Ms. Derowitz raised a number of pertinent points, and I agree certainly with what she said. I also think it's important to remind opposition colleagues what exactly the motion, the sub-amendment of Mr. Gerritsen calls for. Just in case there's confusion, I would have thought by now that we would have unanimous support for something that is quite reasonable. It says that after the committee reviews the two different versions of documents, the committee invite each of the relevant deputy ministers or the signatories of the transmittal letters, as well as the law clerk and parliamentary counsel of the House of Commons, to give testimony regarding the redactions applied to the documents that were requested and granted in the motion adopted on July 7th, 2020. So I'm failing to understand, Mr. Chair, what exactly the opposition has a problem with. The Liberal members of the committee, the government as well, there's no obstruction here. You can't say that we as Liberal members are being obstructionist. In fact, we're trying to find a compromise. In fact, we have a pretty good sub-amendment here, a very strong one that is reasonable, that is responsible. It would allow for committee members to give an opportunity to public servants to let us know and tell us why particular redactions were made, of course, along with the law clerk too. What is the opposition worried about? Are they worried perhaps that when public servants are questioned, that they might say that the personal information of individuals is not something that should be revealed in public? That much is obvious, at least it should be obvious, but opposition members continue to have a problem with that, apparently, in particular the Conservatives. Are they worried that the law clerk would agree with that perspective? Perhaps they are, Mr. Chair, but let's allow those meetings to take place. In the meantime, let's start planning what our chief responsibility is right now, which is to abide by Standing Order 83-1. It's absolutely paramount, Mr. Chair. There's so many things that can be said on that front. When we look at our responsibility as members of Parliament, we not only think about what our role is, and Ms. Jansen put it very well. I had her quote written in front of me, and it's since disappeared, so I won't look for it. But she made the case this morning that she was elected by her constituents to go to Parliament to serve and to fight on behalf of the people in her community. Well, every single member of Parliament will echo that. I think that, I humbly suggest this to my opposition colleagues, that they put some water into their wine, if I can use that analogy. Victor Hugo, Mr. Chair, said that being good is easy. What is difficult is being just. And I would add to that by saying, to be just, one must be fair. One must be open. One must be open to compromise. Here is an opportunity to recognize that Liberal members, and I speak for all of us here, but it's Mr. Gerritsen that put forward what is a really credible amendment. It would allow us to move forward. It would allow the opposition to have their concerns heard, but in a way that is absolutely fair and therefore just. The opposition colleagues are smiling that I bring up Victor Hugo. It's a famous quotation, and I think one that is quite relevant. We can't talk about fairness without talking about justice, and he obviously had a great deal to say on the matter of justice. What is wrong in a spirit of fairness and in a spirit of justice to bring public servants to the committee to put on record why they did what they did? I think it's fundamentally
point of order, Mr.
Chair. Point of order, Mr. Jennis.
Just for the benefit of the member, he might also appreciate a quote here from Winston Churchill, who once said, "It is good for an uneducated man to
debate,
read books
Mr. Chair.
of
This is debate. This is debate. This is not a point of order.
I think that's a matter of debate, Mr. Jennis, and not a point of order.
Thanks for clarifying.
You can speak. I don't believe there's anybody on the list after Mr. Fragiskatis. If you want to come in, then Mr. Fragiskatis.
Thank you, Mr. Chair. I did see Mr. Gerritsen with his hand up there, but I'll let you revisit that. What looks to be interest to speak on the part of Mr. Gerritsen, Mr. Chair. I appreciate the intervention, even though I was interrupted, but I know he did it in a spirit of goodwill. Mr. Jennis and I have sparred a number of times in the chamber through debate, and it's a pleasure to sit with him on the special committee for that examines at the moment Canada-China relations. He's an able member of Parliament, someone who is extremely intelligent and learned, and of course we are all so very impressed that he can quote Winston Churchill. That is good to know, and I'm glad
with Google.
With Google. Well, I won't say that, Mr. Chair. I don't know who said that. I heard something there.
Didn't let
Google.
me say the quote. It makes much more sense in that context.
We'll give you the opportunity later, Mr. Jennis.
I'm sure he'll take it, Mr. Chair. I'm sure he will take it. But I think that to get back to the issue at hand, the sub-amendment of Mr. Gerritsen, here is something that provides us with a framework that does not that will not occupy the committee at enormous length, and therefore prevent us from looking at, in a very serious way, the issue of a pre-budget consultation, and therefore is completely in line with the spirit of Standing Order 83-1, which, as I've mentioned a number of times today, we need to recognize and follow. We would have meetings on these documents. We would be allowed to question, and I would have questions, serious ones, not ones that that would try to ignore the main issue, not ones that would be partisan, ones that would be very straightforward to public servants, to the law clerk. And I would be very interested to hear what they have to say and put on record. Why is the opposition trying to prevent those folks from coming to the committee and speaking to committee members? Is it because, and I'm just speculating here, Mr. Chair, I'm not making any accusations, I would never do that.
That'd be a first. That'd be a first at this committee. But go ahead.
Well, I appreciate always your point of view, Mr. Chair, and I will just try in the spirit of being a good colleague here to be very sincere about what I was about to say, which is I am not of the view at all that our job is to be partisan on these matters. Unfortunately, the opposition seems to continue to be anxious to score political points because they're worried about scoring those points right now. What I'm worried about is making sure that we have a decision here today that allows for meaningful discussions, for substantive meetings to happen, where we can actually question those involved in the decision making around the redaction, of documents. Why that is such a problem, I'm not sure. Perhaps they're looking at polling. I'm not quite sure. They want to score the points now. They're anxious that they've received orders, maybe, Mr. Chair, from their whip that this is a must. That that the initial motion of Mr. Poilievre has to be accepted, and if that's not that motion, then it must be the amendment of Mr. Kelly, who's not here right now, but was here earlier. That this is what must be followed, and that the Conservatives cannot work with their colleagues in a spirit of good faith to put forward, or to agree to rather, a compromise that gets to what the Conservatives want, but also in a way that is, again, fair and just, to go back to that line of argument. I also make the point, Mr. Chair, that, and I've made it a few times here, but I think that we continue to, or certain members of the committee are not recognizing it. And that is that where we are in the country necessitates a particular approach on the part of members of Parliament. We, as MPs, have an enormous responsibility, but we are agents of the state in so many ways. We are tasked with working within government and advocating to government on the part of our constituents. There's many conceptions of the state, as you will know, Mr. Chair. I see Mr. McGregor here from the NDP. At least he was here. Oh, there he is. It's good again to have him here. And if Mr. Julian was here, I'd say the same thing. That the NDP has a particular conception of what the state should look like and how it ought to operate. It differs from how Liberals feel on the matter. It differs from how Conservatives feel. And how
Point of order,
feels.
Mr. Chair.
Mr. McGregor.
Yeah, just going back, I missed Mr. Fragascato's comments there. Did he say that we as members of Parliament are agents of the state?
He did.
Did you want to clarify that? Because I see myself as an agent of the people of Couch and Malahat Langford.
You can be many things. You can be
That's
many
not how he
things
sees himself, though.
You can be many things at the same time. We operate within a state framework, and therefore, in that sense, we are agents of the state. But I recognize, Mr. McGregor, that you are also a member of Parliament. You are, I don't know your personal situation, but you're a son, perhaps you're a husband, perhaps you're a father, I'm not sure, but you can be many things at once. The phrase "agents of the state" is not.
I think we are straying. We're straying a little from the relevance of this motion.
I was about to bring it back, Mr. Chair. I was, but Mr. McGregor wanted clarification on the point. And when I was going to bring it back, I was going to simply say that in light of the fact that we continue to deal with COVID-19, we must recognize that the state as a whole has a responsibility. Naturally, the NDP will understand the responsibility of the state in a particular way. One that seeks to put in a place of primacy the working class Canadians. Who can forget the very famous poem recited, it's an interesting fact. It wasn't Tommy Douglas who came up with the Mouseland poem and fable. It was someone else. But either way, the idea that the working class should be at the very core of what parliamentarians are looking at and who they're seeking to support. Of course, he used the analogy of the mice and the black cats. The black cats, of course, being the capitalist class, and the mice being the working class.
I do think
point of order, Mr. Chair.
We're straying from the motion.
I was going to work it back, Mr. Chair. I'm working into the public.
There's a point of order. Mr. Chair, on the floor for Mr. Jennis. Yeah, go ahead.
Yes, Mr. Chair, based on what the member was saying, I had assumed we were in camera and this wasn't things he wanted on the record. Can you clarify whether this is in camera or public?
This is public.
Oh, it's public. Okay. Well, I'm glad the record will show then. Thank you.
Okay. It is a public meeting. Mr. Jennis, Mr. Fragiskatis,
thank you very much.
On to relevance.
No, certainly, Mr. Chair, I'm making the point that when we think about pre-budget consultations, we have to think about responsibilities. Each member of parliament will understand the responsibilities in a certain way. The NDP have a particular approach to that issue of responsibility and what it means for parliamentarians that aligns with the ideological perspective of the NDP and the role of the state within that wider framework. I'm glad to go on record on these things. Happy to quote, even as a Liberal, Tommy Douglas. It's interesting if we review the parliamentary record and some of the things that Mr. Jennis has said over the years. I wonder if
I'm coming back to relevance again, and
my filibuster is much higher quality, Peter.
I'm reluctant to cut you off, but
I'm getting to the point at hand, Mr. Chair. I've stayed on topic, and yes, perhaps I've strayed at certain points. I know Mr. Jennis is off his game here a little bit and wants to continue to interject. It's not my intent to get under his skin. He's a valued colleague, and I hope we can remain collegial here. There are others, Mr. Chair, who will say that the role of parliamentarians, and this again reflects their position on what the state is all about, who will say that the primary job of parliamentarians is to make sure that people are secure, because that's the job of the state, to ensure the physical security of citizens. But that's not just a point that relates to the need of a strong military. Think about economic security and what Canadians are going through right now. You don't have to have a particularly focused understanding of German sociology through the works of Max Weber and others on what the state is all about to recognize that the state is much more than an entity tasked with ensuring the physical security of citizens. The economic security of citizens is absolutely paramount, and here we have an opportunity at this committee to look at that matter in great detail. I'm tempted, Mr. Chair, as someone of Greek heritage, to speak about Aristotle and Plato and the philosophies of both. What Socrates said about the state, I won't go into that.
That's good, because I was going to suggest maybe you, the clerk has now sent you the motion. It might be good for you to pull it up so that you could be on the motion with relevance. So the floor is yours to start to sum up.
Well, again, it is all relevant with due respect, Mr. Chair, when we are debating a sub-amendment that, if accepted, would allow this committee to meaningfully approach its various responsibilities. Number one, we would have finally a path forward that it would allow for pre-budget consultation to begin. And on top of that, we would deal with the issues that our opposition friends have raised here today. They wish to discuss this issue of redaction. Fair enough, but we cannot do that unless those who were involved and have been discussed, public servants, the law clerk, let's have them at committee. Let's have that meaningful discussion. Why we would hold that back is only for the opposition, namely the Conservatives, to answer, and they have not done it. Instead, they want to continue to focus on political points, partisanship, issues that everyday Canadians on Main Street don't care at all about. They care about ideas that will lead to genuine policy outcomes, as we've seen. And as I made clear in my earlier remarks today, this committee has the ability to do that, the ability to suggest policy proposals to the government, namely to the Minister of Finance and to the Prime Minister, that would continue to contribute to this country. CEBA, the payroll subsidy, matters of rent, all of these things can be looked at in a very serious way. I think, Mr. Chair, that we ought to move forward, agree to the sub-amendment of Mr. Gerritsen, and then begin planning what Ms. Jarowitz and Mr. Sainte-Marie have both called for. And I believe Mr. Julian too at some point. I don't want to leave him out of this. That is a pre-budget consultation. It's been a pleasure for the past couple of years serving on this committee. The best part of the year when we have the best part of the role is sitting through pre-budget consultations. It's a very serious enterprise, one that I take incredibly seriously. I know that I've raised various philosophers here today, various philosophical theories about what the state should be. Ultimately, the state should look after its citizens. Whether you put the working class at the center, as the NDP does, whether you put business at the center, as the Conservatives do, or whether you, as Liberals, put the needs of the working class, of the poor, and of business. We seek to be a party of moderation, in the middle, but one of moderation again. We can find ways to work together. All of this that we've heard here today from the opposition stands in the way of that. It's not in the spirit of collaboration what the Conservatives continue to do here. I would call on them to stop being obstructionist, to accept the sub-amendment of Mr. Gerritsen, and to get on with the business of this committee, namely the recognition of sub-amendment of Standing Order 83-1. Let's do what's right, abide by or agree with Mr. Gerritsen on what he's put forward, and then, as I said, start planning the real work.
Okay, thank you. I said I'd give Mr. Jennis an opportunity at least to finish his quote on Winston Churchill, or if he wants to make further remarks, then go ahead. Then I will go to Mr. Gerritsen and Mr. Badaway.
Mr. Chair, I'm extremely grateful. The quotation was from Winston Churchill, who said, "It is good for an uneducated man to read books of quotation." That is all I have to say.
Oh, that is the shortest I ever heard you speak. Go ahead, Mr. Gerritsen.
I don't know how I'm supposed to follow after that. I mean, that was a very enlightening quote that Mr. Jennis provided to us. But listen, let's get back to what I'm proposing. And then I put up my hand when Ms. Jensen was speaking, because I don't know if she, and fair enough, because this hadn't been distributed yet, despite the fact that I thought it had gone out. I don't know if she fully understood, and I'm just interpreting this based on what she was saying, what this is asking for. And so I just want to very quickly go through it again now that everybody has it in front of them. The first part says that the committee requests a complete package of documents, the complete package of documents provided to the Office of the Law Clerk and Parliamentary Counsel of the House of Commons by relevant deputy ministers or signatories of the transmittal letters, as well as the final package of documents that the Law Clerk and Parliamentary Counsel, of the House of Commons approved for release. So it's asking for those documents. And then it's saying that both the documents and packages be provided no later than October the 15th. And then further that after the committee reviews the documents, the two versions, the committee invite the relevant deputy ministers, the signatories of the transmittal letters, as well as the Law Clerk and Parliamentary Counsel, which is to the point that she raised, of the House of Commons, to give testimony regarding the redactions. And then of course it goes on to indicate the various dates in there, and then that Mr. Poilievre's motion be picked up after that fact. And the reason why I am having a very difficult time letting this go, and quite frankly, Mr. Chair, I'd love to hear from Mr. McGregor or Mr. Sainte-Marie as to where they are on this, because we have to, and I know that they would not want to put themselves in a position on basically voting on something that deems these officials have breached privileges of Parliament without even providing them the due process. So, I'm really curious, because we haven't heard from the NDP and the Bloc on this, where they are in terms of, do they support that? Because I think it's important for people to know that we're basically casting judgment based on some work that was done without asking for information as to how and why the work was done in the way that it was. And that's why, although I can appreciate my previous two motions, I can appreciate the political need to not support them. This one is actually a lot more, I think that members should pay a lot more attention to this, because what we're basically saying is we're saying, give them, and I see that Mr. McGregor has raised his hand to signal you, Mr. Chair. I know you're on a really small screen there, so hopefully you'll give him the opportunity to chime in at the appropriate moment. Maybe Mr. St. Marie wants to as well. But no, he doesn't. Okay. But I think it's very, very important that we get, we're basically saying that these officials who are independent and work for Parliament have breached privileges of members. And what's worse is you're not even giving them an opportunity to explain how and why they did their work before you deem that to be the case. Now, if you really have an interest in defending the institution and the individuals, which I know that the NDP and the Bloc do, you would want to at least explain, I think, and put on the record why it is that you don't think that they should be afforded the opportunity to defend themselves before casting this judgment on them. And then, of course, the next part of it is, and it doesn't leave it there. This amendment doesn't just say, okay, and that's it. That's the end of the story. The amendment then goes on to say, if the committee is still not satisfied, then it can take further actions it deems necessary, i.e., privilege being breached, and so there is still the opportunity to go back to Mr. Poilievre's motion and enforce that later on. And I think that if I realize that it's easy to assume that people out there don't understand the nuances of how this stuff works. And I know, based on Mr. Poilievre bringing out real documents that had been redacted and waving them around, when he did that, of course he's trying to give the implication that, hey, this has all been done by the PMO. The Prime Minister sat there and blacked out all these things, or he got his people to black out all these things before it was turned over to Parliament. I know that's come on, nobody in this meeting right now actually thinks otherwise. Everybody knows that was Mr. Poilievre's intention. Nobody actually believes that he took the time to explain to people, oh, and by the way, while I'm flashing these documents around, this was done by our legal counsel and the officers of Parliament that actually blacked these out, the necessary portions of this. Nobody actually, thinks that anybody took the time to do that. So we got to let these people have their say. This is like trying to have a judicial matter before a court on an individual without allowing that individual to put forth their defense. And I just can't understand how any member of Parliament wouldn't support more openness and accountability, unless, of course, going back to what I've been accused of so many times today, that the motive has actually nothing to do with openness and transparency and getting the information out there, but rather that the motive has to do with grandstanding and using an opportunity to, once again, as Mr. Fragascatos said, do nothing more than inflict attempt to inflict political damage on the Prime Minister in particular. We know that from day one, the Conservatives have spent very, very little time in opposition, since 2015, actually bringing forward policies and motions. And I hand it to the NDP because quite often, not all the time, but quite often when they bring forward motions, they bring forward opposition motions that actually are about policy. But we've seen the Conservatives, and every motion that they bring forward has always been a motion about how do I make the Prime Minister look bad? How can we paint the Prime Minister in a bad light? It's always been about personal attacks for the Prime Minister. So I apologize if I'm jumping to the conclusion that motives exist here, but it's all that I've witnessed from the Conservatives for 5 years. It's the only thing that I've had the opportunity to see. There's no interest in policy. There's no interest in bringing forward anything that is actually going to advance the agenda of Canadians. They never do that. They just bring forward oppo motions and various different opportunities during question period to just try to completely annihilate political careers, as opposed to actually advancing the things that Canadians care about right now. And it's germane to the discussion on this, Mr. Chair, because I'm trying to highlight why it is that they're not interested in supporting something like this, or at least why it is that it's perceived to me that they're not supporting something like this. And I wholeheartedly believe that the NDP and the Bloc are in a different place in terms of worrying about how it comes out that we affect public servants through this process, and the motives that were through a motion like this would be inflicting upon public servants, because they have to be I think that they should be extremely careful when going down this road. So, Mr. Chair, I know that Mr. Badaway had something that he wanted to add to this, but I just want to conclude my remarks by saying that I have a very, very, very difficult time letting this go, because we're talking about more openness, we're talking about more transparency, and we're talking about allowing people to be able to defend the actions and to defend the accusations, I should say, about a breach of privilege. And we should be affording them that opportunity to do that. So maybe Mr. McGregor or Mr. Saint-Marie sees this a little differently, and they have problems with this particular amendment. Maybe they can find an amendment to the amendment that would make it more palatable in terms of them being able to accept it. But I really think at the end of the day, we need to make sure that these individuals have the opportunity to make sure that they have a say in what they're basically being accused of by through this motion. So I'm really hoping, and as Mr. Fragascato said, in the spirit of collegiality, we can find a way to allow them the opportunity to do that. And if you're genuinely interested in getting to the bottom of this, I think that people will support that. Thank you, Mr. Chair.
Okay, thank you. Just to give everyone a heads up, I have on my list Mr. Badaway. I believe Mr. McGregor wanted in, and Mr. Lake. So Mr. Badaway first.
Well, thank you, Mr. Chairman. And I have to say, just jumping into this fray, and however watching it for a bit today, it's been quite a journey. But I also have to say that I'm not going to be here to give anybody any lessons or any preaching or any quotes. I'm just going to get right to the point. And I guess somewhat of a benefit, Mr. Chairman, that I'm coming from a perspective of being outside the box for the past day, in comparison to many of you who've been at this for quite some time. And what I've witnessed, quite frankly, Mr. Chairman, is something that's disturbed me since becoming an MP in 2015, compared to my former life as a mayor for 14 years here in a small community in Niagara, in Port Colborne. And I've always had an attitude or had a mindset and an appreciation. An attitude that was progressive on behalf of the people that I represented, a mindset that we put the business of good government ahead of the business of good politics. And quite frankly, that's what I can see here happening. And I say good government because we have priorities that are a heck of a lot more important today to deal with, like COVID and the pandemic. And many of the files that many of you work on a daily basis on behalf of each and every individual and business in your ridings. When I look at this, I see two words that resonate in my mind, one being accountability and one being transparency. And it's that simple, quite frankly. Accountability based on what we're discussing, and transparency on how to come out with how to come out with decisions based on the motion that's before us. And equally as important, if not more important, is to get to that, the amendment that's been presented to us that we're now discussing. Mr. Chairman, it is about team and it is about respect. And the reason why I bring up my former life as a mayor is because one of the things that I didn't demand, but I commanded, and that was just that, a respect about our team. And that's the respect for the people that are elected. But equally, if not more importantly, it's the respect of those people that work side by side with us on a daily basis that quite frankly make us look good. Because make no mistake about it, members, it's not you that does much of what you are read about or the reason why your name or face is in the paper. It's the people that you work with on a daily basis. It's your staff. It's the team, in this case, in the House, public servants, the law clerk, and the list goes on. So let's not dismiss that. Let's remember that. And quite frankly, they deserve your respect as much as they respect you, because they're passionate about being in the business of good government, not in the business of good politics. And with that said, there's many opportunities that come out of that mindset. Opportunities for you to represent best the people that are in your ridings. And quite frankly, even outside across Canada, as we get out of our ridings sometime. And in my former life, I also made it very clear to my council that we're not sitting around a horseshoe to bully the people that we work with. We're sitting around to listen, to learn, and to make proper decisions because of what we hear and what we learn. And this is no different. Here we are with an opportunity to make good decision based on the people that we represent, good government, which is the business we should be in, to take into consideration what our public servants, in this case, and our law clerk, have to say, have to explain with respect to their decisions before we inform the House that they have breached privilege of members of you. And I say bullying because without that opportunity, quite frankly, that's what we're doing. And we're taking on a decision that in fact is not fully informed. You know, I'm currently the chair of the Standing Committee on Transport, Infrastructure, and Communities. And frankly, I'm blessed to date, although we've only had a meeting, but many discussions on the committee members that we have in place. And from the sincerity that I hear from the committee members, and both at the meeting as well as off to the side, is that we all have a desire to get on with business and to get on with good government versus good politics. And with that said, it's political gain that you'll get based on results. That when it comes election time, those results come from that narrative on how hard you worked and what you brought back to your people. I've talked to many people throughout the past many weeks and many months on this very issue. And quite frankly, what people are concerned with is putting food on their table, paying their bills, being healthy. This, quite frankly, is to some extent rhetoric. It's noise. And as was mentioned earlier, it's just a ploy by the opposition party to gain a narrative after the good work that's been done by this government, and not just by the government, but by all of us working together for the past many months. And with that even said, it's not just about us. It's about the people that we work with on a daily basis. Different organizations, United Way, seniors organizations, our legions, our the people that help the homeless, and people that put food on people's table. And the list goes on, our municipal councils. That's what we should be discussing right now. That's the priority. That's the business of good government. And you know, I've always considered myself a riding MP, and not to get caught in the bubble in Ottawa with a lot of the rhetoric and a lot of the attempts for narratives to be captured, and therefore trying to get that word out there. No, it's just all about simply dealing with the resident Mrs. Jones in Thorold, and Mrs. McKinnon in Welland, and Mr. Poles in Port Colborne, and throughout the region. That's my priority. That's what I'm about. That's what I spend my time on. And now when I'm pulled into a meeting like this, which by the way, I fully appreciate, I feel very privileged actually, especially with many of you who I see almost on a daily basis that do good work. So why are we going down this road? And if in fact, if we're going to go down this road, why are we not doing it properly? Why are we not doing it in a way that the people that we represent expect us as MPs to be accountable and transparent? Why are we not allowing the process to be accountable and transparent, and therefore allowing this amendment to move forward? Again, I'll go back to my former life that I try to learn from when I'm in now my current life as a member of parliament, and trying to inject better government into the process versus better politics. Because as many of you may know, at the municipal level, it's about the person that you talk to in the Loblaws, or in the soccer field, or at the arena, or walking down a sidewalk, or being interrupted while you're cutting your grass and wanting to talk about transit, wanting to talk about the high water bills, and the list goes on. This is no different. People still do that with me. And one of the first questions they ask me is, why is it always, I won't use the words because it's not appropriate here, but why is it always a fight up in Ottawa? Why can't people just look after it like you used to do when you were a mayor in terms of our best interests, the things that we deal with on a daily basis? Not simply trying to play politics and gain a narrative, bashing the prime minister, bashing certain ministers, bashing MPs. Let's get down to it. Let's get down to work. So when I come in about an hour ago and seen the amendment that's been brought forward, and I see, quite frankly, the disrespect that's being shown here versus the respect for the people that we deal with on a daily basis, it's quite disturbing. Folks, we're all on the same team here. We all should be rowing in the same direction here. It's Canada. And I'll stop short of giving my opinion on some of the things that happen around the world, or even with our neighbors to the south. Because what's relevant here is, as Canadians, we should be rowing in the same direction. And part of that, and accepting the politics, I get that. It is Ottawa. I understand that. But having said that, allowing respect to be front and center, and therefore giving an opportunity for our public servants, our team, and our law clerk to come forward and be accountable, be transparent, and give us reason, then therefore move forward past that to the main motion. So to all of you, I say that. Show that respect. Ensure that you recognize the team. Ensure that you recognize that what's most important here is the business of government, not the business of politics. And therefore we can move forward with this discussion. And I do respect the discussion. But equally, if not more importantly, is to move forward with what our priorities are here on this day, October 15th, 2020, and moving forward as long as we're in this pandemic. And that priority being ensuring that people are healthy, they're safe, confident, and comfortable, that they have a government that's working within their best interests of what they're dealing with today. Thank you, Mr. Chairman.
Thank you, Mr. Badaway. Mr. McGregor, followed by Mr. Lake.
Yes, thank you, Mr. Chair, and I won't be long. I guess Mr. Garrettson asked for my viewpoint on this, and I guess when I go back and look at the original letter that was provided by the parliamentary law clerk, I'm struck by that one paragraph where the parliamentary law clerk notes that the House and its committees, the power they have to order the production of records is absolute and unfettered, as it constitutes a constitutional parliamentary privilege that supersedes statutory obligations, such as the exemptions found in the Access to Information Act. I mean, that's it in a nutshell. That's it, full stop. So, we're now dealing with a sub amendment to an amendment to a main motion, and I get what the Liberals are trying to do. I mean, they've talked repeatedly about wanting the Finance Committee to get on to more important matters, whereas members of the opposition are saying, fine, yes, let's get to a vote so we can get to those other matters. But for me, it's the fact that various departments took that step of deciding what the committee could see and what the committee could not see. And it just really goes back to that one sentence in the letter from the parliamentary law clerk. Our power to order the production of records, the production of papers, is an absolute authority. It's rooted in centuries of tradition. And that's what we're standing up for. Ultimately, we are the ones who want to make the decision as to what we want to view and so on. And I don't think ultimately any member of this committee, I've heard members of the governing party say that, or allude to the fact that we may want to go on a witch hunt, or that members of various ministries, deputy ministers, we're not interested in going after those people. I've worked very closely with deputy ministers at the Agriculture Committee. They're fine, upstanding people. And we in no way want to impugn their records or what they contribute to the way our government functions. I think at the heart of this matter is really about us upholding the rights and privileges of Parliament as an institution, a convention, a set of rules that is rooted in centuries of tradition, and that's really, I think, where the opposition is at. I was at the great proc filibuster of 2017. I remember taking part in that, and I'm just wondering why the Liberals are kind of choosing this hill to die on. Because if you're going to filibuster a committee, if you're going to delay us actually getting to the vote, actually you should have a reason. Now, Mr. Chair, in 2017, we were legitimately filibustering the Procedure and House Affairs Committee because we were trying to stop the executive from unilaterally changing the standing orders of the House of Commons. And that was a hill we were going to die on, because it was not only affecting our rights and privileges as members, but it was affecting the rights and privileges of all MPs, present and future. And so I think that was a more noble cause. That was something that could be easily explained to the Canadian public. But you have to ask yourselves, for people who are tuning in right now, not only to the Standing Committee on Finance, but also to the Standing Committee on Ethics, and they're wondering, why is it still October the 8th on the Standing Committee on Finance's website? Why are we now more than 176 hours in? Why do we keep on having sub-amendments to an amendment to the main motion? It's because it's continuous delay to allowing us as members of the committee to see information that we are rightly allowed to see, given Parliament's absolute power in this regard. So I'll end there by saying that I understand the Liberals' arguments, why they have to do this, and the process that they're going through. And to Mr. Badaway's comments, I believe that Parliament and its various committees were able to walk and chew gum. The business of government is going on. The House of Commons is dealing with justice bills. I know my Standing Committee on Agriculture is looking at agricultural matters. This Standing Committee on Finance is doing something that's related to its mandate, as is the Ethics Committee. So government is still functioning. The various ministries are still functioning. The House of Commons is still looking at other things. I believe that this committee is exercising a power that it should be exercising. And I hope that Liberals on this committee understand that the longer this goes on, the reasons that they have for delaying us to getting to an actual vote are going to start wearing thin with the Canadian public. You don't have on your side a plausible argument for delay like we, the opposition members, did in 2017. We had the public on side with us on that fight because the public, I think, inherently understood that this was about the rights of Parliament, the rights of its members, and the rights against executive overreach. In this particular one, I think the government, the longer this goes on, the more it looks like there's something to hide. So I would ask my Liberal MPs to help us get along so that the Standing Committee on Finance can have those pre-budgetary hearings. I know we're already in October, but there still is time left in this year. Allow this committee to get to a vote on the main motion so that we can uphold Parliament's right for the production of papers so that we as a committee can exercise our right to look at the fully unredacted documents, work with Parliamentary Law Council to decide ultimately what information should be withheld. There's numerous ways committees can protect private information, but ultimately this goes to the heart of what parliamentary privilege is all about. And so I just draw all members of this committee, I draw their attention to that very, very important sentence that is contained in the original letter from the Parliamentary Law Clerk. And with that, Mr. Chair, I'll conclude my remarks. Thank you.
Thank you, Alistair. Mr. McGregor. Turning to on my list, I have Mr. Lake and Mr. Gerritsen following that. Mr. Lake, if there's others, either click the hand on the reaction screen or raise your hand. Mr. Lake, welcome to the committee.
Oh, thank you. It's a pleasure to be a guest here, and I wasn't going to weigh in. I was listening, intently, and after listening to Mr. Gerritsen and Mr. Badaway, I had to, as they spoke in hushed tones, very serious tones about Parliament properly doing its work and about accountability and transparency. I know my constituents would be astonished if I, on their behalf, didn't weigh in, because it is unbelievably ironic to hear those words being used in the discussion that we're having here today. Of particular interest to me was Mr. Badaway's assertion that we should, quote, all be, quote, rowing in the same direction. How unbelievable that statement is, given that about 8 weeks ago, the Liberals not only stopped rowing, but they threw all of the oars out of the boat so none of us could row either. Just absolutely astonishing to hear that being said in the middle of a global pandemic, in order to avoid accountability and transparency, to use Mr. Badaway's words, in order to stop Parliament from properly functioning, properly again being Mr. Badaway's words, they shut down Parliament so that the COVID committee, for example, couldn't function and hear from expert witnesses from across the country on the best measures that we could take as a country to address a global pandemic. We're in a situation where we're probably, by the time this is over, going to spend as much money or run as much debt up in months, maybe a year, as we ran up in over 150 years of Confederation. And Canadians expect that Parliament will sit and that parliamentarians will hold the government to account. And in a minority parliament, if anything, the government should be working with parliamentarians from all sides in order to get the best result for Canadians. And so I had to weigh in. And when I put my hand up at first, it was actually, I think, before Mr. Badaway even said the things that he said. It was in response to Mr. Gerritsen, who made the comment that opposition members, particularly Conservatives, that we haven't moved legislation or bills or motions to better the lives of Canadians. I remember in the spring of 2017, the one time that I had the opportunity to move an opposition day motion. I remember working with members of the New Democratic Party, with members of the Bloc, with members of the Green Party, members from all sides of the House to come up with a motion that I thought was the biggest no-brainer. In fact, I reached out to Liberals, many of whom, well, between a dozen and 2 dozen Liberals who told me that they would support my motion on a Canadian Autism Partnership. Talk about something that should be as easy to support as just about anything. And put forward the motion, went through, first of all, an expert committee put forward a proposal to government for budget. It got rejected in the budget. And then we brought forward an opposition day motion to further the issue, a point upon which, New Democrats and Conservatives don't always agree, but on this point, we were in full agreement. And at the end of the day, when it came time to actually stand up and vote, every single Conservative member voted in favor. Every single New Democrat voted in favor. Every single Green Party member voted in favor. But who didn't vote in favor was not one single member of the Liberal Party voted in favor, because they were whipped to vote against it. And I'm looking at all of you. Mr. Fragiskatos, you voted against it. Mr. Easter, you voted against it. Mr. Gerritsen, you voted against it. As I'm looking, Mr. Badaway, you voted against it. Mr. Fraser, you voted against it. All 5 of you voted against it. And so to hear Mr. Gerritsen give the lecture that he gave earlier here, a lecture that was, really born out of a situation where he has to waste as much time as he can of the committee's time because he wants to avoid losing a vote that he's almost certainly going to lose eventually. To hear him make the points that he made, I just couldn't stay silent. And so, on behalf of my constituents, on behalf of stakeholders that I work with across the country, I had to weigh in. I will now, I assume, cede the floor so that we can listen to, hours upon hours of Liberals standing up one after the other to lecture us in the way that they've been lecturing us for hours upon hours already. And with that hope, maybe hope against hope that at some point we can come to a little bit of a common sense understanding and come to a vote.
Thank you, Mr. Lake. It's your absolute right to weigh in. My list, Mr. Gerritsen and Mr. Fragiskatos.
I find it very interesting, Mr. Chair, to be lectured from a Conservative member who was sitting in the House of Commons when Stephen Harper prorogued Parliament solely for the purpose of avoiding an election, to somehow be sitting there with a straight face telling Liberal members that proroguing after spending over $300 billion in order to get the gauge of Parliament to determine if we're going in the right course is somehow not a proper use of proroguing Parliament. And meanwhile, this member, Mr. Speaker, was in the House during that whole time, including when Stephen Harper did that, and he prorogued Parliament to save his own skin. No other reason. So I appreciate Mr. Lake's comments. I think he did a very good job at delivering that, in particular, advancing his position on it. But hypocrisy is a very interesting thing, and we're seeing it on full display right now in this committee from Conservative members. Going back to Mr. Allister's points, the reason why I have a difficult time with what he's saying, Mr. Chair, is because the reality of the situation is that it's not department officials that were doing the majority of the redacting. It's specifically the officials, and I will go back to my motion because we asked specifically for them to come. There are the deputy ministers, but also the law clerk and the parliamentary counsel for the House of Commons. These are not political staff, nor are deputy ministers political staff. These are individuals who have no way to defend themselves. So to suggest that as Mr. Allister was, that it's okay to proceed with this parliamentary privilege because of the fact that, they're in the departments. I know, it's unfortunate, but it's the same angle, Mr. Chair, that the Conservatives are using. That angle is, hey, we need to make sure that we just get as much out there as possible so that Pierre can go out again and start waving things around and grandstanding, get a 20-second clip that can, he can share on Twitter for all his followers, his faithful followers to watch it. And it actually produces nothing in terms of what a parliamentary privilege is intended to produce. So what we're doing here is we're saying, okay, well, those that were impacted by this should and are impacted by this motion that's being proposed right now. And again, the way that we ended up on this motion is very interesting in that Mr. Polyev decided that he would circumvent the order in which motions were already being delivered in committee, but I digress. And what we end up with is a motion that holds people in light of breached privileges of members of parliament. And that's where I see, where I think that Mr. McGregor and all members of this committee need to be focusing on, which is the fact that you're not allowing these people to defend themselves. And so Mr. McGregor brings up the point, Mr. Chair, he says, is this a hill you're willing to die on? Well, guess what? If this is a hill that involves saving the careers of individuals who are professionals that work within the government, who don't have a voice because the system intentionally doesn't provide them a voice because they're nonpartisan, then this is a hill that I'll go to. I will defend those people. I will go to the hill for those people. And if Mr. McGregor chooses that that's not the hill that he is interested in going on, then that's entirely his prerogative. But I think it's worth fighting for those people, worth fighting for them to give their voices so that their voices can be heard, and giving them the opportunity to come forward to committee to explain in detail why and how things were redacted in the way that they were. And I'm sure we're going to find out at the end of the day that there's nothing to this outside of standard redaction of information that was not relevant to the motion and what was being requested by committee. So Mr. Chair, I've made the point before, and I think that we really need to look for a way that we can provide an avenue to allow these people to be able to speak and to explain themselves so that we can get all the information out there. And the blatant disregard for giving them that opportunity, which is being showcased by members of all opposition parties for that matter, I think is extremely troubling. And I think that I'm willing to fight for those officials to make sure that their voices are heard. This is a hill that I'm willing to die on, Mr. McGregor. I'm willing to fight for those people to make sure that their voices can be heard. I respect the fact that you're claiming that you had the prerogative and you were justified in 2017 when you were in this position, but somehow magically we're not justified right now. And that's a matter of your opinion, of which I respectfully, completely, 100% disagree with. We need to make sure that our public officials always have the protections and are given the opportunities at all junctions, whenever possible, to explain themselves, especially before you bring them before this motion that basically suggests that they have breached your privilege, which is extremely unfortunate. So I'll leave it at that, Mr. Chair. I just wanted to respond to Mr. McGregor's comments on that, and of course, Mr. Lake's hypocrisy.
Okay, thank you, and we'll go on to Mr. Fragiskatis, but I don't see Ms. Jansen. Maybe I'm not seeing you. I wondered whether you may have had your hand up earlier. You may have been just putting it up. Anyway, we'll see when the time comes. Mr. Fragiskatis.
Thank you, Mr. Chair. I echo the sentiment that we just heard from Mr. Gerritsen on the point relating to Mr. McGregor. And it's not being disrespectful to say that it's very surprising when we have a sub-amendment before us that would very much allow for public servants to come forward and explain. The sub-amendment is perfectly in line with an idea and notion that suggests that the public service deserve to be treated fairly, and by virtue of the fact that they are nonpartisan, we have to take it upon ourselves to provide them an avenue through which they will be able to articulate particular decisions that they made, and opposition members
Point of order, Mr. Chair.
Can ask them questions.
Mr. McGregor.
Yeah, and I'm not trying to make this a point of debate. This is a point of clarification, and I hope you will find it a point of order. It's just rewinding to when the committee was examining the original motion back in July. Am I not correct in referring to the fact that did this committee not approve that redactions could be made as necessary by the Office of the Law Clerk? So, you know, I thought that redactions actually had already been agreed
Chair,
to
it's
by
a
this
point
committee.
of debate.
Well, no, I'm asking for clarification, Mr. Chair.
There's no such thing as a point of clarification. It's a point of order, and that's definitely not a point of order.
Perhaps Mr. Chair can walk us down memory lane, because, you know, I just want that to be on the record, a previous motion that was passed by the committee.
Well, it's Mr. Fragaskatos has the floor. It's not a point of order.
We'll go back to Mr. Fragaskatos. I think you can go back to the record, and I don't want to be in error on saying something that wasn't on the record at that time in terms of the directive. So the best thing is to go back and look at the blues and the motion in that regard. Mr. Fragaskatos.
Thank you, Mr. Chair. I won't belabor the point, but I did find it rather curious that Mr. McGregor, being a member of the NDP and a passionate one, clearly put himself on the record as not supporting a sub-amendment that is opening the door in a very transparent and fair way to public servants to voice decisions that they made instead of the alternative, which is Mr. Kelly's amendment and everything that Mr. Poilievre has done before that, which does not allow for public servants to explain themselves. Instead, silences them. And what we've done here on the Liberal side is put forward a sub-amendment, which I'll speak about in a moment at length, Mr. Chair, about why it continues to be important that we look at this and support it, the sub-amendment of Mr. Gerritsen. But I did find that rather curious. The NDP always on record as being a party that supports public servants and the whole idea of a vibrant, professional, nonpartisan public service. To Mr. Lake's point, I have not had the chance to get to know Mr. Lake very well, but I know him to be a very passionate advocate around a number of issues, but particularly autism. And I know that he has taken issue with particular decisions made by the government in the past, which he's quite free to do. I did notice, though, and I think it's important to put it back to Mr. Lake to say that it is interesting. I'll use a neutral word. It's interesting that Mr. Lake failed to mention the record of the Harper government. And I know that goes back a little bit, but he was a part of it. When he accuses Liberal committee members of standing in the way here and of playing political games, which we are not. But certainly, if you want to talk political games, Mr. Chair, what do we call efforts to obstruct the work of committees, to get in the way of committee work, as we saw under the Harper government? In fact, if I'm not mistaken, there was a book that conservative staffers wrote, which was to be read by committee members, in particular conservative committee chairs. The intent of that booklet was to find ways to prevent committees from doing their work, to prevent committees from meaningfully engaging in the issues of the day, to ensure that only conservative friendly witnesses would come forward and address committees, and many other examples. So it's a bit rich that Mr. Lake has told us here today of how unfair he thinks the Liberal side is being, when the Liberal side is putting forward ideas that allow for, again, this issue around redacted documents, the We Charity issue, and us as parliamentarians to engage on those matters, but to do so in a way that allows public servants to voice their perspective. We're not being obstructionist at all. I was also moved by Mr. Badaway's insight, and he comes at it from someone who has led in politics in other ways at the municipal level, a mayor for a number of years in the community of Port Colborne, which actually I have a tie to, Mr. Chair. My mother-in-law is originally from there, and the Badaway family is well known in that community and well respected. And I think we understand why when Mr. Badaway speaks with such passion about the everyday people that he knows in his community. And I would ask my honorable colleagues that we keep that spirit in mind, that ethic in mind. What would our constituents say right now when, and perhaps they are all watching, seized with this issue on the parliamentary channel on but something tells. But what would they say if they knew that we had a chance to be debating either this subject at great length? I believe we began at 11 a.m. today, and that's fine. The days are long in parliamentary life. If we were seized with this subject or parliamentary budget consultations as an alternative, which would they want us to focus on, Mr. Chair? Which subject would be more important? And on top of that, if our constituents were made aware that, and yes, some will be watching, so they will already be aware, but if the vast majority knew that the Liberal side has put forward a motion that, or a sub-amendment rather, that allows for the general substance of what the opposition is looking for to be heard, but in a much more fair way, what would they say? I think they would say that the committee should unanimously support Mr. Gerritsen on this subject. But I'll leave those initial observations there. I do want to get into my further thoughts on what Mr. Gerritsen has articulated. It's been a while since he put forward the sub-amendment, Mr. Chair. So to remind members, let me review the motion that Mr. Gerritsen has tabled. That the committee requests the complete package of documents provided to the Office of the Law Clerk and Parliamentary Counsel of the House of Commons by relevant deputy ministers or the signatories of the transmittal letters, as well as the final package of documents the Law Clerk and Parliamentary Counsel of the House of Commons approve for release, that both of the document packages be provided to the committee no later than October 19th, 2020, and that after the committee reviews the two different versions of documents, the committee invite each of the relevant deputy ministers or the signatories of the transmittal letters, as well as the Law Clerk and Parliamentary Counsel of the House of Commons, to give testimony regarding the redactions applied to the documents that were requested and granted in the motion adopted on July 7th, 2020. And that until such a time as this testimony is complete, debate on the main motion and amendment for Mr. Poilievre be suspended, and that the chair be authorized to schedule these witnesses and convene a meeting to resume debate on Mr. Poilievre's motion once these meetings have taken place. I know that I might be accused of trying to waste time here by reading out the sub-amendment or the motion of Mr. Gerritsen, excuse me, but it's important to catch up because it has been a long day, and some time has passed since Mr. Gerritsen put forward his idea. So what we are looking at is simply, number one, that we get a full and complete accounting, Mr. Chair, of the documents that are to be provided to the committee. The opposition has since voted down twice Liberal members' attempts to provide the committee with a common set of documents. Without a word, Mr. Chair, and here I find some surprise, without a word from the Bloc and the NDP. It's not clear that these members have expressed a view, and because many of the members from those two parties here as are substitutes, and I've seen I don't see Mr. Julian, but in either case, I know Mr. McGregor did put himself on the record before, but it's unfortunate he took the view that he did. So I think my previous comment applies. Next, what we are asking for are the transmittal letters. They have been cited here at length, but let me just repeat. These are the documents that tell the committee how the world-class public servants who prepared these documents per the motion of this committee applied redactions. Let me share some highlights. From the text of the letter from Mr. Paul Rochon, the Deputy Minister of Finance, who in his transmittal letter said, the committee's motion stipulates that cabinet confidences and national security information are to be excluded from the package. No information is being withheld on the grounds of national security, since the information does not so pertain. With respect to cabinet confidences, you will note that considerable information on the Canada Student Service Grant contained in cabinet confidences is being provided to the committee. This is in keeping with the public disclosures of information on this matter made by members of the Queen's Privy Council for Canada. A principled approach was taken with respect to this information to ensure a non-selective application of the protection afforded by cabinet confidentiality. And as a result, considerable information on the Canada Student Service Grant would otherwise be protected as cabinet confidence is being released. Information not related to the Canada Student Service Grant that is contained in cabinet confidences is withheld and identified as not relevant to the request. That's something that's entirely reasonable, Mr. Chair. With respect to personal information, the department is obliged to protect such information under the Privacy Act unless the individuals to whom it relates consent to its disclosure, or disclosure is otherwise authorized in certain specific circumstances, or the public interest in disclosure clearly outweighs any resulting invasion of privacy. Reasonable efforts, he continues in his letter. Reasonable efforts were made by the department to obtain consent. Where consent was not given, the department found that the public interest in sharing the information with the committee outweighed any invasion of the individual's privacy. As such, disclosure is being made pursuant to subparagraph 82 MI of the Privacy Act. As required by that act, the Privacy Commissioner was informed by our decision. In very limited cases, personal information was redacted from these records as consent was not obtained from the individuals concerned, nor was the department able to conclude that the public interest in disclosure clearly outweighed the invasion of the individual's privacy. The type of personal information that remains protected consists of the identity of unrelated third parties where their opinion or view relates to an unrelated matter to this inquiry, as well as personal email addresses and phone numbers. That is the end of the quote. From the text of the letter from Mr. Simon Kennedy, Deputy Minister of Innovation, Science and Economic Development, which my Conservative friends will know as the former Industry Canada, I read into the record the following. Innovation, Science and Economic Development Canada has retrieved all records from within the department that respond to the committee's motion. You will find the results of that search enclosed for the committee's consideration. It should be noted, however, that in the preparation of this package, care was taken to obtain consent to disclose certain personal information from exempt staff referenced in the material and in collaboration with other government departments, the staff from We Charity in accordance with the provisions of the Privacy Act. In addition, the committee's motion stipulates that cabinet confidences and national security information are to be excluded from the package. No information is being withheld on the grounds of national security, since the information does not so pertain. With respect to cabinet confidences, you will note that information on the Canada Student Service Grant that was a cabinet confidence is being provided to the committee. This is in keeping with the public disclosures of information on this matter made by the members of the Queen's Privy Council for Canada. A principled approach was adopted to this information to assure a non-selective application of the protection afforded by cabinet confidentiality. Information not related to the Canada Student Service Grant that constitutes a cabinet confidence is withheld and identified as not relevant to the request. Next, Mr. Chair, from the text of the Secretary of the Treasury Board, Mr. Peter Wallace, who holds the distinction of having served as a senior public servant in 3 levels of government in Canada. The committee's motion stipulates that cabinet confidences and national security information are to be excluded from the package. No information is being withheld on the grounds of national security, since the information does not so pertain. With respect to cabinet confidences, you will note that considerable information on the Canada Student Service Grant that were cabinet confidences is being provided to the committee. This is in keeping with the public disclosures of information on this matter made by members of the Queen's Privy Council for Canada. A principled approach was adopted to this information to ensure a non-selective application of the protection afforded by cabinet confidentiality. As a result, considerable information on the Canada Student Service Grant that would otherwise constitute cabinet confidences is being released. Information not related to the Canada Student Service Grant that constitutes cabinet confidences is withheld and identified as not relevant to the request. The same principled approach, it continues, the same principled approach was also applied to the second enclosed packages of TBS documents, which is provided in support of the commitment by the Clerk of the Privy Council to provide additional information on due diligence on the Canada Student Service Grant subsequent to his appearance on July 21st, 2020. Additionally, because I believe it is in the public interest to do so, this package includes information being made available as a result of a limited waiver of solicitor-client privilege as it relates to the information that is being provided by Employment and Social Development Canada. While many TBS employees continue to work virtually, guided by public health measures and focused on curbing the spread of COVID-19, these two packages provide, to the best of my knowledge, as of August 7th, 2020, the TBS documents in response to the above noted request for production of papers and due diligence line of inquiry. So that is I've read into the record that perspective. Now, let me continue on my own here, Mr. Chair. Again, the opposition, especially I'm thinking about the Bloc here, I've not heard anything from them, and the NDP have opposed the provision of these critical transmittal letters without a single word. It is because they are not tuned in, Mr. Chair. I see that Mr. Samari is there. I respect him a great deal, but again, we have something here in the form of Mr. Gerritson's motion that I think can be agreed to. There's plenty of compromise that's been made. I hope that the Bloc has an opinion. I've heard the NDP's, but unfortunately, it has not made much of an impact, and that's why I say without a single word, what has been offered doesn't really count. With all due respect to my honourable colleague, Mr. McGregor. Further, we are asking that the various versions of the documents be compared, and that public servants, the very public servants who wrote to this committee, Mr. Gagnon, and indeed all Canadians in their transmittal letters, be asked to come before the committee to talk about their approach and to answer questions from members about this motion. Again, I know I have questions for these individuals. Sadly, the Conservatives are refusing to hear advice from public servants. I made this comment before in my my remarks about an hour ago, Mr. Chair. It's stunning to me that the Conservatives aren't open to that. What is the fear? What is it? Might it be the fact that that public servants could put on the record very basic points relating to not wanting to disclose personal information, which I think is very reasonable. I mean, and that would therefore expose all of this on the Conservative side as one big political game, which it surely is. But I leave that judgment aside in the firm sense for now. Again, to my Bloc and NDP colleagues, this is something that Mr. Gerritson has put forward that opens a path, that allows us to get past the issues that we've been debating so vigorously today. We finally reached a resolution, or what I think is a reasonable one. Let's be serious about it. In every study this committee conducted in the last session of Parliament, officials provided us with testimony, and that testimony was meaningful, Mr. Chair. That is their duty on behalf of Canadians. I would also say that this has been the case for every study I've ever been a part of as a parliamentarian. There's no doubt about that. You know, I've had the honor and privilege of serving on the Finance Committee. I've had the honor and privilege of serving on the Committee for Foreign Affairs, on the Committee for Public Safety and National Security. And at every opportunity, whenever officials have come, we've only benefited as a committee. it's unfortunate that some, and I'm not speaking specifically of conservatives or only conservatives at the table here today, but in general, there seems to be this view of public servants on the part of the conservatives, this branding of them, this framing of them as somehow irresponsible, somehow living off the state, living off the largesse of the state. It's frankly, it's just not true. There's no truth to that. And in fact, if we look at who some of the central actors have been in terms of getting Canadians through this crisis, public servants have played an incredibly important role. Of course, Canadians deserve most credit in the first instance because of the responsibility that they've shouldered for themselves and for their families and their businesses. But public servants have been instrumental in suggesting policy design that has met the needs of the moment. I'm thinking specifically of the CERB here, but also the various other programs that were created very, very quickly and executed with incredible skill by the public service, which unfortunately members of the Conservative Party continue to demonize, and other opposition colleagues have not stood up for in the right way here today. Let's review, and let me go back to this point about what we've heard at committee before from public servants. On Monday, February 3rd, 2020, in a very lengthy meeting from 3:30 to 8 p.m., which, if that meeting was very lengthy, what's today's? But anyway, we'll leave that for now. A study on the pre-budget consultations of early 2020, what this committee should be working on. The following officials attended from the Department of Finance: Nicholas Leswick, the Assistant Deputy Minister for Economic and Fiscal Policy Branch; Andrew Marsland, Senior Assistant Deputy Minister, the Tax Policy Branch. Mr. Marsland, I'll highlight him in particular here. When I was at the very beginning of COVID-19, I had specific questions from constituents relating to certain programs that the government had put forward. I asked him very openly at committee technical details, and he articulated the rationale, which allowed me as a member of parliament to go back to my constituents and provide an explanation on why programs, were designed in the way that they were. He was very helpful in that. Evelyn Dancy, Associate Assistant Deputy Minister, Economic Development and Corporate Finance Branch. On Tuesday, March 10th, 3:30 to 5:30, a standard meeting time, as you know, Mr. Chair, for this committee, we had a study on corporate subsidies. What a lifetime ago that was. I mean, I have a faint memory of that, but it's still relevant to mention here in my remarks. Because on that day, we heard from ACOA, the Atlantic Canadian Opportunities Agency, in the form of Daryl Nolan, the Vice President of Policy and Programs, Bill Grandy, the Director General of Programs. We also heard from the Canadian Northern Economic Development Agency, the Department of Industry, in the form of Mitch Davies and Andrea Johnson. Excuse me, not to have any disrespect for Ms. Boost from the Northern Development Agency. She was also
Mr. Chair, a point of order. Do we? Sorry to interrupt my esteemed colleague, but do we still have quorum? Just because I see a number of our opposition members that are not present. So does that mean we still have quorum?
Mr. Genius counts as one and a half.
Yes, we do. And yeah, Mr. Janice counts as 1.5 at the moment. Yes, we do. By one member.
Yeah, don't worry. We're not going anywhere.
Yeah. Okay, Mr. Fragiskatis.
Thank you very much, Mr. Chair. We also heard on that day from the Office of the Auditor General, Mr. Andrew Hayes, who was the Deputy Auditor General and Interim Commissioner of the Environment and Sustainable Development. My colleagues could be wondering why I'm reading out the full titles of these individuals. It's because they worked hard to attain the positions that they're in and deserve to be recognized as such. Heather Miller
mentioned their degrees as well.
Well, Mr. Janice, they have, if not one degree at the university level, then they have 2 or 3 probably, and
what
master's degrees. Well, Mr. Janice, I'm speaking here. Really not good of you to interrupt. But if you want me to go on and speak about the average education level of our public servants, you'll find that they have master's degrees, they have PhDs. They can't hear your criticisms because their PhDs are plugged in their ears, Mr. Janice. That's how educated they are. You continue to find ways to belittle the public service. You continue to find ways
to. You have to go through the chair, Mr. Fragaskatis.
Excuse me on that, Mr. Chair. No, it's been a long day, so sometimes I too forget the requirements at committee. It's simply a rebuttal to Mr. Jennis, Mr. Chair, who, again, without even saying point of order, jumped in, and he was a great debate champion, as he's reminded all of us in Parliament repetitively. Yes, apparently, Mr. Jennis was someone who debated at length in high school and in university, and he's quite proud of himself. That's fine. He is asked here about the education levels of public servants. They're very well educated, I assure him. On Thursday, April 2nd, from 2 to 4 p.m., a study on the government's response to COVID-19. Really one of the most a set of meetings that I won't soon forget as a parliamentarian, let's put it that way. From the Canada Revenue Agency, we heard a number of individuals articulate their points of view. From the Department of Employment and Social Development, from the Department of Finance, a number of folks who I've already mentioned, so I won't repeat them, but really an impressive group of people who, in the midst of carrying out all sorts of work on policy and program design, found time to appear here before the committee. I know they're expected to do that, Mr. Chair, but these are folks who are working, 20-hour days and still finding ways to inform the committee about their work. I think they deserve the respect, not just by acknowledging them here and now, but also they deserve the respect of having them come to committee and explain this issue that the opposition is so concerned about, instead of putting words in their mouth, which is what effectively the opposition wants to do by actively preventing them from coming to committee. If we go with Mr. Gerritson's motion, we have a fair outcome that allows the opposition to get answers to their questions, but does so in a way that does not silence our public servants. I'll begin my conclusion there from here, rather than Mr. Chair. Conservatives are refusing to engage at all. I hope that we start to see a different approach also taken by the NDP and the Bloc. The members of the opposition are very fond of quoting the law clerk of the House of Commons, who has said and who carries out incredible service for all of us as parliamentarians. The law clerk that serves the country as well. The Conservatives want to vote that down. Remember that Mr. Garrison's motion calls for the law clerk to appear, again allowing all members, every single one of us, to engage. And I call on the NDP and the Bloc to support that. But unfortunately, I haven't heard very much on that point from either Mr. Saint-Marie or Mr. McGregor. Mr. Chair, we should not dither here. We should not waste our time. The end of Mr. Gerritson's very reasonable motion asks the committee to adjourn debate on the main motion and amendment for Mr. Poilievre be suspended. Excuse me, let me just read that again. The end of Mr. Gerritson's very reasonable motion asks that the committee adjourn debate on the main motion and amendment for Mr. Poilievre be suspended, and that the chair be authorized to schedule these witnesses and convene a meeting to resume debate on Mr. Poilievre's motion once these meetings have taken place. It seems to me that this is very reasonable, Mr. Chair. We ought to allow the clerk, the analysts, to do their important work and furnish us, with the documents that this committee has not yet received. Unfortunately, yet again, the opposition won't allow us to carry that important work to be conducted here, and that needs to be put on the record and recognized. We don't even know what they think or what their justification is for all of this, and I hope that a member from the NDP and the Bloc, I've given up on the Conservatives, will come forward and tell this committee, their constituents, and all Canadians watching at home what their view is, Mr. Chair. I'll end my comments there. Thank you.
Okay, thank you, Mr. Fragaskatis. We will turn to Mr. Saint-Marie, then Mr. Badaway, and Mr. Mr. Badaway, we'll go with that for now. I did have Mr. Fraser, but he disappeared. And okay, I see them waving. Ms. Zerowitz and Mr. Garrettson. Okay, first up, St. Marie. Mr. St. Marie, Gabriel, sorry.
Oui, merci, Monsieur le Président.
Thank you, Mr. Chair. I'm going to reply to Mr. Fragiscatos. He's saying that the bloc is not speaking up that much. Well, the committee has been working for 9 hours. And if I'm not mistaken, Mr. Chair, only you and me have been sitting at the committee right from its beginning. We haven't been replaced. What we've heard so far.
Point of order.
Yeah. Okay, 2 points of order here, Mr. St. Marie, Mr. Fragiscatos, and Mr. Garrettson.
I'm guessing that Mr. Garrettson's jumping in on the same point of order as I am, and my voice is kind of hoarse right now. So you know what? I'm going to allow Mr. Garrettson to speak.
Mr. Garrettson, point of order.
Mr. Fragiscatos and I have both been here since 11 o'clock, right from the beginning, Mr. Speaker, and I am disappointed to hear that what we've had to offer to this debate has not been so memorable as for Mr. St. Marie to remember the fact that we've been here from the beginning. But
on the same point of order,
we have indeed been here, Mr. Chair, from the beginning of this meeting at 11 a.m.
Okay, I think your point's been made, Mr. St. Marie. Floor.
Oui, merci, Monsieur.
Thank you, Mr. Chair. I'm sorry if I implied that colleagues were not there from the beginning. But anyway, the reason I haven't spoken up so far is because what we've heard so far is the following. 30-minute arguments and the turns would be over, but now we just have filibuster. Members of the Liberal Party do not want to respect the majority of the committee. Yet the majority of the committee reflects the will of the population. In Quebec, in order to organize debates, we rely on the Code Morin. We can ask the question and then go for a vote, but here it's not the case. But I think we could learn a lot from what is done in Quebec, and maybe we could speak a little bit more French in this committee. I know that my colleague Peter Julian spoke French a little bit earlier, but other than that, I can only hear English, and so I feel so disconnected because I don't hear French that much. And as for the sub-amendment, as for the previous ones, I think they don't really speak to the original motion. And everything that we've heard so far is just a way to kill time. So you won't hear from me in the next minutes or the next hours, Mr. Chair. Thank you.
Mr. Did I come in too soon, Mr. Badaway?
Thank you, Mr. Chairman.
Just so I make sure I have the right order here, because some people dropped up. Mr. Badaway, Ms. Zerowitz, and then Mr. Fraser. Okay.
I should be on that as well, Mr. Chair.
And Mr. Garrettson.
Thank you, Mr. Chairman. And I was going to wait a while to speak again based on what I heard, but I had to jump back in based on some of the comments from some of my colleagues, in particular Mr. Lake, in commenting on, as he did, some of the points that I had made, as well as other colleagues. And I guess it's to some extent time to really call it what it is, which I'm sure the opposition is thinking about, and very well should. This is once again an attempt to gain a narrative. Because of the fine work that the government and Canadians have been doing since COVID hit us back in March. And that's what it is. So let's just simply call it what it is. And quite frankly, most of our residents, at least my residents here in Niagara, see that. They see right through what's happening here. And with that, giving us a great deal of dialogue and giving us a great deal of feedback with respect to what we should be doing and the priorities we should be having, as I spoke about earlier. And to try and divert the discussion from the good work that's being done is simply wrong. And I also want to bring up that word that I brought up earlier that obviously isn't resonating, and that's the word respect. It was mentioned by Mr. Lake about fighting for the rates of. Well, let me be very clear, Mr. Lake. Who we are fighting for, and very well you should be fighting for, is respecting the people that we represent, respecting our team, respecting the ability and the opportunity for our team to come out and ensure that the decisions that we make are decisions that are evidence-based, that are based on reasons and based on what our team actually does on a day-to-day basis, quite frankly, beyond what you and I do on a day-to-day basis as it relates to the issues that we depend on them to then therefore be evidence-based, to then therefore make the proper decisions. Once again, respect. Respect for them to do their jobs, and respect for the people that we represent to ensure that those decisions are evidence-based and are in fact a decision that is sound. But I want to go back to the narrative again, and I guess to some extent, based on Mr. Lake's comments, give a bit of a history lesson. The narrative being, again, putting Canadians first, putting people before politics versus putting politics before people. And the narrative, quite frankly, on October 15, 2020, should in fact be the health and safety of all Canadians. And to have this discussion, once again, is simply rhetoric and noise, and quite frankly, getting in the way of us doing that. And when I say us, I mean all 338 members of Parliament, as well as the people who represent, working together to row in that same direction. And that same direction is, in fact, looking out for the best interests of Canadians. Let's be very clear on that, Mr. Lake and others on the opposite side of the table, that's our narrative, that's our priority. With that said, it was mentioned about COVID spending. And of course, the direction that this government has taken throughout the past many months. And often I hear the leader of the opposition, the new leader of the opposition, the former leader of the opposition, members of the opposition, speak about their critiquing the spending that's happening. And my comment has been and continues to be, where's your feedback? What's your thoughts? Instead of being a critic and being part of the problem, be part of the solution. And of course, with that, we welcome some of those thoughts, and then therefore what you would do in terms of taking care of the people, putting food on their table, ensuring that people are working, ensuring that our business community, our small business, our SMEs, our big business are being looked after, that rent can be paid, and the list goes on. And I don't have to give you that menu. You read about it every day, and I'm sure that you hear about it every day with respect to the people that need, and for the most part are being dealt with and taken care of because of the programs that we put forward. And yes, this is about transparency and accountability. But as I said earlier, it's also simply about respect. And I think we all should be cognizant of that and ensure that as much as we respect each other, we also respect the people that we work with on a daily basis that, quite frankly, look after our best interests as much as we look after the interests of our constituents. Now, having said all that, and looking at past Parliament and votes that we entered into on many occasions whereby the Conservatives would vote against. And I recall budgets and early morning votes that the Conservatives would stand in opposition to. Investments in homelessness and poverty, and seniors, and infrastructure spending, healthcare, spending in my riding, as well as the riding of Mr. Lake and Edmonton, Wetaskiwin, local sporting organizations, recreation, lowering taxes, support for businesses. Can't understand why those were voted against. Those are good things, very good things, like what we're doing right now in the middle of this pandemic. Fortunately, we had a majority government then, and a lot of those investments we move forward on. I have to, I have to give another history lesson, and I apologize, Mr. Chairman, because I'm just responding to the words that were now in the record by Mr. Lake and others about proroguing Parliament. And you know, we look at the 41st Parliament, the Harper government, in October of 2013, shut down Parliament for 33 days to avoid questions on Senate expenses and the Senate expense scandal and the resulting PMO cover-up. In the 40th Parliament, the Harper government shut down Parliament for 63 days to avoid the Afghan detainee issue. In 2008, the Harper Conservatives shut down Parliament to avoid a confidence vote that would have toppled the government. This shutdown lasted 53 days. In 2007, the Harper government shut down Parliament to declare a mission accomplished on 5 priorities from the election and took 32 days before bringing in a new speech from the throne. Mr. Chairman, I'm flabbergasted at the comments that are being made and how people can actually have the nerve to make those comments knowing this. And quite frankly, Mr. Lake was around then. He was a minister. Mr. Chairman, this sub-amendment, and if the opposition parties do not support the sub-amendment, all that's showing is that they don't care about the facts. They don't care about an evidence-based decision being made. Again, a lack of respect. All they care about is having something to flash around, props, get their supporters, supporting them, supporters that they'll blast out this information to for their next fundraising event. And that they should be ashamed that by doing that, they're robbing this committee of the opportunity to do its important work. Mr. Chairman, again, I go back to my former life. And when we had situations like this and issues like this, no, we didn't go into filibustering or we didn't get into the minutia of the politics because quite frankly, we put the people before the politics. We didn't put the politics before the people, trying to gain a narrative. Quite frankly, the narrative should always be dealing with the issues that people deal with every day, that they talk about at the dinner table at 5:30, at 6, sometimes at 9 o'clock at night. Myself tonight, midnight. And these people think about and live that every day. And to simply having discussion diverted from what they're thinking about to something that's going to gain political gain is wrong, frankly. And MPs from the other side can talk all they want. Call it what it is. Everyone knows it. We know it here. We're in the box. But quite frankly, folks, the people that are outside the box know it too. Call it what it is. And all this sub-amendment is asking for is simply to ensure that the decision that's being made is made on the best evidence presented to us by the folks that we count on every day to bring us that evidence. We can't be hypocritical here. Can't say on one side of your mouth that you want that evidence in other ways and in other issues, but yet you're not prepared to look at it here. What's that tell us? What's that tell Canadians? It's about accountability. It's about transparency. But most of all, it's about respect. Respecting our team and respecting the decisions that we're counted on to make in a manner that's evidence-based. You know, I often say to people, different people hold our seats throughout time. And although people have opinions about the people that sit in those seats, regardless of what level of government it may be at, it could be a mayor, it could be a city councillor, it could be a member of parliament, member of provincial parliament. Chairs sit there, those seats sit there forever. Different people occupy them. And people have opinions about those people that occupy them. However, we as occupiers of those seats, must, not should, must respect those seats we sit in. And part of that respect is ensuring that decisions that we make are made by a team that includes all parliamentarians as well as our support staff, ensuring that those decisions are evidence-based and therefore good decisions, putting people before politics, not politics before people. And we see that too often from those on the opposite side of the floor. We lived it between 15 and 19. And I think people seen that. Hence the reason why here we are back in Parliament, forming a government. And the expectation is for that to continue. So I ask all of you to take that into consideration. The respect that those people deserve. The respect on making a decision that's evidence-based. And therefore the respect to make the proper decision. Thank you, Mr. Chairman.
Thank you, Mr. Jennis. You want into Mr. Jennis? Is that what you're saying? Okay, you're just making sure I'm off mute. I have Ms. Sirowitz, and I'm not sure who's first, Mr. Gerritsen or Mr. Fraser, so you'll have to notify me on that. Ms. Sirowitz.
Thank you so much, Mr. Chair. I'm glad to be back part of the discussion. I was gone for 55 minutes, Mr. Samari, in case you were following that. I was listening very closely to your comments, Mr. Samari, and I was glad that you did speak. I don't agree. This isn't about killing time. I think that this direct motion that Mr. Gerritsen has proposed is directly trying to address what we felt was truly the concern of the opposition members. If there is a perception that there was redactions in order to somehow hide some secret information that the public should be seeing, then I think that motion was there to actually directly address that point. And let me just, mention 4 key points of this motion. The first one is that the main motion and amendment from Mr. Poilievre is suspended. It's just suspended. It's not killed. It's not thrown out. It is just suspended. The second part is that the chair is authorized to schedule meetings with witnesses. And who are those witnesses? We basically say we invite each of the relevant deputy ministers or the signatories of the transmittal letters, as well as the law clerk and parliamentary counsel of the House of Commons to come and talk to us about the 5,600 plus odd documents, to answer our questions, to talk to us about why things were redacted. And then the fourth part of this is to convene a meeting to resume debate on Mr. Poilievre's motion once these meetings have taken place. So it's to suspend, to directly try to address the issue that we believe is actually at the heart and soul of what we are hearing from opposition members in the public and even here. That's what we're trying to address. And if we're not hearing clearly, if we're missing something, then tell us what it is we're missing, because I want to listen. I want to hear from you. Because I agree with my colleagues. Mr. Badaway made a beautiful presentation, I think a very genuine one, about Canadians and where all of us, not just the Liberals, all of us, all of our thoughts are, and where we want to be in terms of thinking about them, setting a course for them, helping to restart the economy in as strong a way possible. So I'm listening, Mr. Samari, and I'm listening to all the opposition members right now. If we're missing something, you tell us what that is that we're missing, because in my opinion, I thought that this motion was not about killing time. This was about actually addressing very deliberately what we felt was the key issue that was being brought up by opposition members over the last few weeks. I'll also say, this whole day about talk it, and I think that anyone who might be listening, you kind of are thinking, oh my God, are these crazy people? Like anybody who might be listening to us for any period of time. Sometimes I think you have to talk things out to actually try to get to some sort of a solution. And it seems to be this is part of what it is that we do here, is to try to see if we can find some common ground, is to see whether or not some cooler heads will prevail, or better angels will prevail over time. So I don't see this whole day as a colossal waste, although I would have preferred not to be meeting for, I think we're going on 9, 10, 11 hours now. So I want to sort of just reiterate a couple of points, because this is what I believe we are trying to do with this motion, which is that we are being told, you federal Liberal government are trying to hide things because of so many pages of redactions. And then we, the Liberal government, are saying, but that's not the case, because we have outstanding, independent civil servants who have followed the letter of the law in terms of doing their very best to provide all the information that was asked for in the motion that was presented and passed by Mr. Julian on July the 7th, although he presented the motion actually on July the 2nd. So, and you heard key evidence to that point from my colleagues, Mr. Fragiscados, from Mr. Fraser, and myself. We actually read out key examples of civil servants who did their very best to give us as much information. And if they hit some information, well, it was personal cell phone numbers, completely irrelevant information to the CSSG, cabinet confidentiality. We gave example after example after example. And I also think that the other thing I really love about this motion is it really does provide a chance for us to hear from bureaucrats, from our civil servants who were in charge of this. And I think it would be a learning for all of us as well around the redactions, around what the rules are in terms of why they redact. And I think it would give comfort to the opposition members. And to be honest, if that is what we need to do, is hear from our civil servants in order for us to be able to continue with the work of our pre-budget consultations, then I'm willing to do that. I'm willing to spend a couple of meetings on that. And again, I want to keep on repeating this. We're just suspending the motion of Mr. Poilievre as well as the amendment. And our current motion actually says that, which is the fourth part, we have a meeting, we convene a meeting to resume debate on Mr. Poilievre's motion once the meetings have taken place. So there's no desire to actually just, throw this out. We're trying to address the issue at hand. I also want to mention a few other things, just because I think, I often think that if people are saying, well, and just so you know, I've received 0 telephone calls and emails, and I hate saying that publicly, by the way, because whenever you put that out there, all of a sudden someone starts a campaign to actually send you emails and telephone calls around these things. But we haven't received anybody calling us for the last few weeks about or believing that we were trying to hide things in some of the redactions of the WE documents that were submitted. People are very concerned about everyday things, and I'll talk a little bit more about that in a minute. But what I want to sort of point out to Canadians, or anybody who outside of our team right now who might be listening, is there were actually 2 motions that were put forward and approved on July 7th. One was actually all this information, but the other one was also to actually conduct a series of meetings that would actually look at, why did the government award the contract to WE, and how is it that the decision came to be made? Because I think there were some concerns that there was some corruption that was happening. And so we heard very clear testimony. We heard under oath from the Kilburgers. We heard from Prime Minister Trudeau, which is historically, a prime minister doesn't come to committee, but he made it a point of making sure that he came to be as transparent and to be personally accountable, to personally be asking questions. And we heard from Morneau, and we heard from all of them. And they all said to us, no, we're not friends. There was no corruption. There was no one that was selecting WE in order to make sure that we sort of, paid back for any type of friendship with our prime minister or any of our cabinet ministers. That is on record. There's no misuse of funds. We actually heard that all the money came back. It's all back. $0 were actually misused. There was no profit to WE. And actually, the contribution agreement that we actually put into place had a whole number of of checks and balances in place to make sure that the money was being spent properly. There was no profit to we, and it was all about how to get as many students engaged in volunteer initiatives and earning some money in order to be able to continue their school throughout the years. We also heard from Ian Shugat and Gina Wilson and Rachel Warnick. And so for those who don't know, Ian Shugat is our clerk of our Privy Council, and Rachel Warnick and Gina Wilson are two top civil servants. And we heard very clearly from them that it was them, it was the civil servants that actually selected we and felt that they, in the time frame that we had, in the amount of time that we had, that it was we that they felt were the best to be able to deliver this program. We also explained why there was a rush to do this before the summer, why we were rushed to do the contribution agreement. It's because we only had 4 months and we're trying to do our very best for all of our students. And I just want to remind everyone, and actually, I was only able to go to the cottage for 2 days this whole summer. And I was talking to some friends, and they thought that the CSSG was the only program that we actually provided for students. And it's not true. We provided $9 billion in supports. We provided support through the Canada Emergency Student Benefit. We expanded the number of job creation beyond the Canada Summer Jobs. We extended it to more than 116,000 additional jobs. We made huge adjustments around Canada student loans as well as the Canada student grants. We did a tremendous amount of things for students, $9 billion. So even if you take away the CSSG program, there was over $8.1 billion that were spent on students, and they used it, and it's been helpful to them. They're continuing their studies right now, and we need to continue to do more for them. I already talked about it wasn't a sole source contract, it was actually a contribution agreement. And I just want to remind everyone, we have contribution agreements for food security, $100 million, for nonprofits, $350 million, in order to help those who are in shelters or fight against domestic violence, $50 million. We have contribution agreements, and we've made that. It's a very typical way for a government to basically engage in this. So I wanted to list all of that because it's part and parcel. Like, why did we ask for all of these documents? It was all part of this initial consideration about whether there was anything inappropriate in terms of selecting we, who selected we, was there anything untoward? And I think that the evidence proved unequivocal, and in each of the points that I mentioned, that is not the case. Now, I will tell you, it doesn't mean that no mistakes were made, because no government is perfect. I was listening to Malcolm Gladwell a couple of years ago at some sort of, talk thing, speaker series in Toronto. And one of the key things he said is, in a world of change that we're in right now, we need governments to step up and do radical experimentation. We need governments to be able to experiment and not be afraid to fail, because if it's not governments, then who? And we're the only ones that are able to do that. And I'll also say to you, I do come from the business world, and a small part of my life was actually in the VenCap world. And I'll tell you, success for them is 1 in 10. So if they have one businesses in 10 that actually succeeds, then they actually think that that's actually beneficial. But in any case, I actually think that Minister Qualtrough actually said it best, where she said, yeah, we dropped the ball on CSSG. We could have done much better. It was a pandemic and things were crazy and we were going at breakneck speed, and we should not have dropped the ball on this. But she also said, I don't think in any way it should take away from the other really important, and I would say fantastic work that we've done for students and for Canadians writ large. And so she goes on to talk about it. So I just want to say, we're not perfect. We did our best. Of course, we're going to make mistakes. Of course, it's okay for our committee to have looked at it, and we spent about 2 months on it. We asked the really important questions, and we answered the really important questions. And I think it's important for us to acknowledge it. And I think it's also really important for us to acknowledge the Auditor General is also looking. We have to remember we've got 2 outstanding independent officers who have a long history of serving the public and serving Canadians, who are continuing to look at our spending, as well as whether there were any ethical breaches. So we have our Auditor General who came before us to say that she actually is looking at our spending, absolutely looking at all the programs and how we've gone about doing it. And there will be a series of reports before the end of this year. And then we have the ethics commissioner that's still investigating our prime minister and our former minister of health, Minister Morneau, to see whether or not there's actually been any ethical violations. And then I want to remind Canadians, these committees, and I know for sure this committee is not nonpartisan. It is not nonpartisan. I wish it were, if even for a moment, because I think we have some really important work to do. I will say to you, you know, I visit a lot of classrooms. I'm sure you guys all too. And one of my favorite classes was the grade 5-6 class of St. Nicholas de Bari. And one of the things they said is, you know, what's the surprising things for you as a politician? And I said to them, for me, the surprise is just the theatrics. I didn't realize how much theatrics there would be and how much gamesmanship there would be. And I said that to them. And then another kid said to me, and it's relevant to this, they said, Miss, are there ever days where you think, oh, I just can't take this anymore? And I loved him asking me this. And I said, well, there's definitely frustrating days. But I'll tell you, it's such an honor and privilege to have this job because I get a chance to be able to make people's lives better every single day. And I get a chance to be able to work with an amazing team of colleagues to try to create a better country. But I love those questions. They're like my favorite class ever because they ask the best questions ever. But I will tell you that the stuff that I've been hearing over the last, well, I wouldn't want to say the last few weeks, but I'd probably say last few months, is they're really worried about parents and family members in my riding. They're worried about their kids in school with the second wave underway right now. They're wondering why the federal dollars that's been going down to the provinces and to the city hasn't resulted in more test sites and more contact tracing. They're saying, why? They're worried about their jobs, their future. They're worried about their extended families. There's a lot of things that they're really worried about. And I know that a number of them have written to me and they have said, Julie, if there's anything that you could be studying on pre-budget consultations, you know, we know you're on finance committee, really look at the environment. Look at how it is that we could restart the economy in a way that's going to help us continue to transition to a low carbon economy. That's going to help us to decarbonize. That's going to help some of our energy sector be able to transition, and multiple other sectors to be able to transition. They worry about housing. You know, when I was growing up in downtown Toronto, my mother who earned minimum wage and my dad who was had a working class wage, they were able to afford a house in downtown Toronto. Not possible right now. So they're worried about housing. I have a lot of amazing people in the arts and culture sector in my riding. They have been struggling for a long time in terms of how are they going to be able to continue to survive in the 21st century, since so much has changed in terms of how we fund our artists and our cultural sector. And we know that arts and culture, in addition to tourism and hospitality, have been particularly hard hit through this pandemic. And it's going to be a while before anything returns to normal. And I'll also say to you that there's been a lot of different leaders, economic leaders, so David Dodge and Don Drummond. We've been hearing lots of them and reading a lot of them. And I think that they've had some really valuable things to say. And it's made me think I'd really like to get to pre-budget consultations because I want to hear ideas about how it is that we can ensure Canada has a competitive economy moving forward as we come out of this pandemic. How do we attract more foreign direct investment? How do we accelerate economic growth moving forward? How do we invest in productivity, enhancing physical and human capital? How do we invest in transition in industries in transition? There are so many things that we should be getting to right now, and the everyday things that my colleague Vance Badaway was talking about. And I think those are the things that I really hope that we'd be able to focus on. And I'll end off right now just with a few more comments, Mr. Chair. Canadians really need us as leaders to be our best selves, to really listen to our better angels, to be the government that they need us to be at this one moment in time, and to really rise above the partisan games and the business as usual. And I'm sorry that Mr. Poilievre feels that he needs to yawn during my low comments, but I think they're really important for us to hear. You know, I would say to you, I don't think what's happening on this committee now, where we're not trying to find a solution, which is what I'm feeling is right now happening. I would say to you, what would be really powerful is if we could maybe just find a way that we could move forward right through to pre-budget consultations. Just imagine that we can do that. What would we give up? Would we give up a bit of ego, a bit of power to hold up a committee, or the illusion that the opposition members are now holding government to account? Don't you think it would be far more powerful if we conduct the most ambitious pre-budget consultations, listen to the most historic number of ideas and stakeholders, and bring the best national and international leaders to give us their best ideas? How about if we actually have some true debate and battle over the best ideas, and maybe even attempt to try to present a unanimous report to the House of Commons, to our Deputy Prime Minister, to our Minister of Finance? Don't you think that would be more powerful? And that would be more historic, where we could actually say, and Canadians can actually say, in history, when we were going through an unprecedented pandemic, we actually had all of our parties lay down their partisan arms and say, we are going to work together, and we are going to work together in the best interest of Canadians, because this is the moment that Canadians need us to rise up to the occasion, to be our best selves, and that we rose up and we did exactly that. We all ran for office to serve Canadians and to create a better country. And if it's not us leading and charting a course for the future, then who? And if it's not now, at a moment of tremendous change, fear, and confusion, then when? Thanks so much, Mr. Chair.
Thank you very much, Ms. Sirowitz. Mr. Garrettson next, followed by Mr. Fraser, followed by Mr. Vaughan.
Thank you very much, Mr. Chair, and thank you to my colleague, Ms. Sirowitz, there for her intervention. The passion that she showed towards the end of that is truly reflective of the caliber of MP that she is and what she brings to the table here. And I wholeheartedly see that, you know, what she wants here is a solution and a way through this that is going to be a compromise in a way that everybody is going to be able to appreciate and and value. You know, going back to Mr. Saint-Marie's comments, he said that you know, this was just a waste of time, and I mean, obviously, I mean, filibusters are you know, inherently intended to do that, to create a point, to make a point. But I think that there is perhaps a bit of confusion as to why it is that we're going down that road. The illusion, I think that you know, Mr. Poilievre and other conservatives would like to paint is that it's because there's something to hide. And I think that that couldn't be further from the truth. You know, why I am very adamant about this one particular sub-amendment specifically is because I'm concerned about the manner in which public officials are being treated. I want them to have a voice. I want to be able to allow them to express themselves before we get to a point of determining whether or not they breached parliamentary privileges in the manner in which they provided information. And I'm not talking about political staffers. I'm talking about the officials that contributed to the redactions that we see in the documents. And I'm getting a sense, Mr. Chair, that I'm not going to get anywhere with this. It hasn't been apparently obvious to me that there's any interest from members other than Liberals at this time to support this amendment. So I'm led to the conclusion that it's going to be very difficult for these individuals, these public officials, to be able to defend themselves. And I think that it's extremely important that they have the opportunity to do that. So if we're not going to allow them the opportunity to defend themselves, Mr. Speaker, then I think it's incumbent upon me, and yeah, I'll go to the wall on this one, as Mr. McGregor phrased it. I think it's incumbent upon us, and I certainly take the challenge to make sure that they are properly represented and that their voices can be heard. I do not want officials to go down as being the reason why parliamentary privilege was broken, when in fact perhaps that wasn't the case. And we really won't know and be able to cast the best judgment possible unless we give them the opportunity to speak for themselves. So since members don't want to afford that opportunity, I'm going to try to defend them on the best to my own personal ability. So with that, I would refer everybody to the PCO redactions that were submitted. And I'd like to go through those to explicitly highlight where it is that redactions were made so that the general public can know and it can be put on the record. There are 151 pages in this document. I'll try to go through it as thoroughly as possible as to provide as much detail so that their voices can be heard through this process of trying to make sure that is understood about what they did to the documents. So if we start on page 49, where we see the first perfect example, we are looking here at a PCO document. Again, this is on page 49, and there are a number of programs that are listed. So what we have on here is a table. I wish I could share my screen and I could go through this with everybody, but what we have on here is a Excel style table, and there are a number of programs on here. Ones that completely do not relate to the Canada Student Service Grant Program that was the subject of this motion. So I'll read off the ones that were blacked out, the ones that were redacted, and this, is one of those perfect pages where Mr. Polyev held up the page and shook it while he stood there at the podium saying it's all been blacked out. Well, let's talk about what was actually blacked out. So we have the Youth Employment Skills Strategy, which wasn't relevant to this. We have the Youth Employment Skills Strategy, wasn't relevant. Student Work Placement Program, Student Learning Program, Canada Service Corps, other financial supports, Canada Student Loans Program, the Double Canada Students Grant, and the Canada Students Benefit. None of those were visible because they were not the subject of the motion from this committee. However, the ones that were visible, which were completely subject to this committee's motion, was the Canada Student Grant, where it specifically said that the post-secondary students under 30 enrolled in the spring, summer, or fall courses who significantly contribute to COVID-19 efforts through voluntary service. And then it went on to talk about the $900 million be set aside and the various different questions that needed to be addressed in relation to that. There was also, which was relevant and which is visible on the document, there's the We Social Entrepreneurship Initiative. So there's the $12 million there. And again, that is completely visible on that document. The next document that came from the PCO, this is on, that I think is germane and relevant to discuss. This is on page 78 to 79 of that document, and it's from Mr. Kilberger to Ms. Fox at PCO. Yet the only redaction present in this whole email, Mr. Chair, the only redaction in the whole email is the private citizen's email address. So that's the email address of Mr. Kilberger's assistant. This is private information and has no relevance to the process, and therefore there was nothing that was necessary to be.
Point of order, Mr. Chair?
Yes, Mr. Fraser?
Sorry, I'm just seeing that one of our colleagues has apparently been booted off the call, back. Mr. Fred. Oh, I think it's been remedied.
There. He is back.
He's back in person, back, Mr. Chair, in person here live
with that wonderful picture behind him. Go ahead, Mr. Yertsin.
Thank God for IKEA.
Thank you, Mr. Fraser, for I thought you were calling me on relevance or something like that, and I was ready to defend my position. This is extremely relevant to my sub-amendment, but in any event, thank you for pointing that out, that Mr. Bragascato was disconnected momentarily. So anyways, yeah, going back to this this email, the full entire email, there is the introductory paragraphs going into details about the proposals, the executive summary of both the programs that was sent from Craig Kilberger, or his assistant, his executive assistant. This is fully there. I don't know why this wasn't the page that Mr. Polyev was waving around. This one had all the information in it. He could have stood there and waved this one around and said, see how much information we're getting? But no, of course he didn't do that. Instead, he pulled one from like the previous example that I used, which was one that had information blacked out that had nothing to do with the actual program. And, I would encourage anybody, any media or anybody, to actually go back and grab the screenshot or a still shot of that video where Mr. Polyev is doing that, and actually see if they can see what's on that page. Because I can guarantee you that this almost looks exactly like that page that he had, and it was information that was completely irrelevant to this particular motion that was prepared by the committee. So moving on to another document, I turn your attention, Mr. Chair, to pages 105 to 110 of the PCO release. A number of programs listed under a number of programs listed are unrelated, again, to the CSSG. They have nothing to do with the motion at hand, and the committee explicitly did not ask for them. So these are the ones that you're going to see that because they had no mention, were not disclosed. So the problem here is, and I understand where the issue comes from, is that what happens is when we talk about redacted documents, and why I know the Conservatives like to use this angle because it plays really well in the media, is they like to say, well, these documents are redacted so heavily that we can't read them. Well, because usually when the public is used to receiving that kind of narrative, it's because you're talking about an intelligence briefing or something that is just specific to that particular issue, that is the entire document, and then stuff is being redacted from within it. But in this case, the call for these documents ended up producing mass amounts of paper, because so many programs were discussed that the way that they just redacted the programs that were not necessary was to completely black those out, but still give all the information. And I know that when this eventually does come out in one shape or form or another, Mr. Chair, Conservatives are going to learn this, and they're going to fall flat on this argument of this witch hunt for information that just doesn't exist. That's what's going to end up happening. And it's unfortunate that they're putting us through this at this point, but my objective here is to protect the individuals and their credibility, the folks back in the parliamentary offices that went through the work of providing this information and redacting this stuff, because they don't have the benefit of being able to defend themselves right now. And because the committee doesn't want to afford them that opportunity, because the Conservatives don't want to afford them that opportunity, nor do the NDP and the Bloc apparently, I find it incumbent upon us to do that. So I'll continue with this and go through some more documents.
Monsieur le Président. Point d'ordre.
Point of order, Mr. Chair.
Mr. St. Marie, go ahead.
Oui, merci, Monsieur le Président.
Thank you, Mr. Chair. I'm not sure I can follow the debate, but if I understood it well, Mr. Gerritsen is explaining to us the parts that were redacted, the content of those redacted parts. I would like to know how he obtained such information. How come a Liberal MP can have access to redacted information and not the other ones? Thank you, Mr. Chair.
Gerritsen, can you respond in kind?
Am I obliged to answer questions when I've been interrupted, or would the member like to wait until? That's not a point of order. If he wants to wait until he has the opportunity.
No.
Yeah, but all.
It's a point of order.
Qui est un député libéral et qui est pas.
Why does a Liberal MP have access to information that the other MPs do not have access to? It is unacceptable. This is why I want an explanation, Mr. Chair.
To explain that, I'm happy to explain that, Mr. Chair, and I'll do it. But I just want to say for the point of record, I just want to say for the record before I do that this is not a point of order. This is a member that clearly didn't open his email that is now challenging me as to why I did open my email and he didn't. Okay, that's what's going on here. This is not a point of order. But nonetheless, we all received these documents from the government House Leader. So I don't know what to tell you, Mr. Saint-Marie. Please open your emails and you'll receive this, because that's what I'm going through. I'm going through this information that everybody received, okay? So if you're okay with that, I'll continue.
Yep, go ahead.
I have a lot more to go through. I'm only on page 6 of 151. So I just really want to get down to this. So then as I was saying, the document that came from the PCO was titled "Increased Supports for Canadians and Youth for Students," and this goes into a lot of the details about the money, where the money came from, why it was important, why these programs were being developed, the Minister of Finance's ultimate decision, all this stuff. None of it is blacked out, Mr. Chair. It is all right there. None of it's blacked out. Again, this would have been a great page that Mr. Poilievre could have waved around that had nothing blacked out on it. Now, if you go to the next page, so you have a full page, and I'm on page, just so everybody is with me, because I know everyone's following along closely. I'm on page 106 right now. And so this page specifically has 3 programs in it. So this is obviously coming from, this is marked Secret Confidence of the Queen's Privy Council. This one is obviously setting out details about programs in it that was provided to the individual or provided, or that was used to compile the information. And 2 of the programs in here, the Youth Employment and Skills Development Program and the Canada Student Loans, were not relevant. So they were completely blacked out. They were not asked for in the motion, so they were completely blacked out. The one that you do see in there, and the reason why it was important to provide this page, is because there is a paragraph at the bottom that specifically goes into Canada Emergency Student Benefit, and this lists off everything, with respect to the briefings and the eligibility for students, and the extended all post-student secondary students, including those in college, part-time, full-time. So the point is that if we asked those officials to come here, which this motion is trying to do, Mr. Speaker, they would have the opportunity to answer these questions. And they'd say, well, we blacked out these large areas because they had stuff to do with other issues. They even left the titles in there, so at least you knew what they were blacking out. That's the irony here, is they didn't even black out the title. They left the title in there so that you knew exactly what they were blacking out. And you end up with, just this little paragraph at the bottom, which was relevant to the motion. So, you go to the next page of that same document, and then it continues on with 2 additional points as it relates to that particular program. And then it starts to go into other programs, again, where stuff is blacked out, but then you have another area which is germane to the motion, and it goes on to talk about the CSSG program again, and everything that was offered in that. So you see a lot of these, you'll see this happening over and over again, and it might make for great theater in terms of being able to wave around papers and say, hey, see everything that was blacked out. And I know that when time comes to Mr. Poilievre being able to see what was actually blacked out there, he's going to have nothing. It's going to fall flat, and because there is nothing there. And so my motive here, as I've stated before, is making sure that those who did do this are not found in to have breached privileges of Parliament because they did exactly what they were supposed to do. And it's unfortunate that we can't let them come here to tell us this. So, you know, continuing on that page, I'm now on 108. At the bottom in section 69, you see that it references the Canada Student Service Grant again. And it says in your announcement, you indicated the grants in support of post-secondary studies would be available to students helping to fight against COVID-19 this summer. You also announced that the grant value would be between $1,000 and $5,000, depending on the number of hours. The remaining details include eligibility criteria, scalability, specific amounts based on hours, and delivery mechanisms have yet to be determined. And then of course there on the next page, because I know everyone's following along, there's that section that talks about the We Social Entrepreneurship Initiative, and it goes into the details about that $500 grant for a 10-week mentorship program, and then it finally comes to the PCO recommendation, and then the PCO's recommendation is all there except for the one portion that is blacked out again, and it's clearly marked that it's not relevant. So you're getting the reason why it's been blacked out. Now, so I mean, we keep coming back to this point of what could possibly be here. The next one, okay, so now I'm on page 111. Page 111 of the of that submission, and it says it's page 111 of the submission, but from PCO release, it's pages 189 to 90, and we're looking at an email between Rachel Wernick and Ms. Shannon from the PCO. As the motion expressly stated, unrelated cabinet confidences were removed, so they're unrelated. As well, Ms. Wernick's cell phone number was removed. I don't know why Mr. Polyev would want Ms. Wernick's cell phone number, but I think it's entirely her privilege to have that cell phone number kept and only be distributed to those who need it, nor do I think that providing that phone number would be even necessary or even have any relevance to the issue at hand that this committee was looking for. And I think that we can all agree that we wouldn't want that phone number to be out in the public. But the entire email, all the details about it from Rachel to Tara and back and forth, it's all there, except for you know, those details, as I said, that are missing phone numbers, and you know, it brings back to this point that why do we even need to have this information out there when it's completely irrelevant and people deserve to have that privacy. Turning to page 191 now of the PCO release, we have another email here between Ms. Wernick and Ms. Shannon. Again, only the cell phone number has been removed. So this one's from May 7th of 2020 at 3:14 in the afternoon. And they discuss the intent of the policy. They go back and forth in multiple emails. All the email addresses are available. They're .gc.ca email addresses. Everything is available in there except where it says mobile : and Ms. Wernick's phone number. That's the only thing that's been blacked out from there. Again, no clue why Mr. Polyev would be offended by the fact that the phone number has been blacked out. Going to page 192 to 193 of that PCO release, we have another redaction due to a cell phone number. And again, I think we can all agree that the removal of such information is completely reasonable. I find it interesting that while the public is battling a second wave of COVID-19, my colleagues are chasing down private cell phone numbers of people. I don't know what the motive is, but I'm sure that they have a motive, but you, again, you know, the point is you see this entire email starting Thursday, May 7th at 3:22 p.m. and it's wonderful. It starts off from Ms. Wernick says, "Wonderful, thanks for the information," and it's a back and forth conversation with them. I'm not going to lie, it's not the most entertaining stuff to read, definitely not juicy, and has that smoking gun that apparently Mr. Polyev was looking for. So therefore, I guess he decided that, you know, chasing down a mobile phone number or searching for other information that's completely unrelated to these programs must have you know, I don't know, maybe even buried in there is, discovery of who the second gunman on the grassy knoll is. I have absolutely no idea. The point is that there's just so much information that's being provided here. And the only stuff that isn't being provided is the information that is specifically irrelevant or confidential in terms of it being somebody's phone number. Pages 219 to 221 of the PCO document release. And frankly, this is truly extraordinary, a document that would rarely ever be released, a document that would never have been released under the Harper government, I'm sure, unless Mr. Lake wants to correct me on the Harper government's incredible openness and transparency. But this goes into a synopsis of the entire cabinet meeting. Obviously, this would be protected by confidence, but these details are in there. It's there for them to see. It's stuff that, as it relates to this particular issue, has not been held back. There's another page, the next page, that if it had not been for the one bullet and sub-bullet at the bottom of page 220, had it not been for that one little section there, as it relates to the Canada Student Service Grant, this page would never have even been included because the whole entire page would have been irrelevant. So the only way to provide the 5 or 6 lines on there that are relevant is to black out the other sections. Of course, Mr. Poilievre takes this and flashes it around and makes it seem like it's a smoking gun because we're covering up massive conspiracies, or at least he's trying to drum up those conspiracies. But the reality is that page would never have even been provided had those that bullet about the Canada Service Grant at the bottom not been there. That's the only reason why they had to get rid of the rest of it. The next page, because the bullet continues on from there and leads into the next page, is completely non-redacted. So I hope that people, and if there are still people out there, we're now 11 hours into this, I hope that if there is public out there and they actually are listening to this and watching this, I hope that they can appreciate, and perhaps I'm not doing a great job of explaining it, but appreciate what we're talking about in the redacted documents. We have, and this is a perfect example, we have a page here that starts at page 220, and the whole about I'd say 4/5 of the page has been redacted. And the only reason why is because the information that was on there was not germane to the motion. Then in the next bullet starts the part on the Canada Student Service Grant. And then the following page, the entire page is not redacted because it relates to the Canada Service Grant, the PCO's comment, where things were going and coming from. And so it's entirely appropriate to share. The problem is, and again, this goes to those people that might be paying attention to this, is that rather than explain that to you, it's no different than if you were to copy and paste this and just copy and paste the relevant parts, rather than think that the public is educated enough to be able to, let me rephrase that. It appears as though when somebody takes the one page that has the major part of the redaction on it and waves that around, you're assuming that the public is just going to buy in right away and say, hey, this isn't a real, this isn't the government being transparent. They blacked out everything. And I understand why the theatrics of it play off so well, but it's the reality of how these documents are released. So the document, as it continues, when you go into page 220, 221, really starts to talk about the details and PCO comment, and it turns to the Deputy Prime Minister to provide the key takeaways from it. And literally, it's all there for everybody to read. Another email on page 222, on page 222, which references page 254 to 256 of the PCO release. Once again, we find a redacted part, and you guessed it, folks, it's the personal and private cell phone numbers of a staff member. Again, something that would never be released in an ATIP, but something that Mr. Poilievre is obsessed with obtaining. But if you go into the details of the email, you can read the entire email here. It's from Tara Shannon, again, going to Ms. Nix, Shannon Nix, and it just goes back and forth about the partnership and struggling to deliver on the existing programs and to not have the capacity to take on more placements, so on and so forth. The second part goes into the CSC programming is not funded and so on, and it just goes into the details of it. But my point is that nothing in here was redacted that was germane to what is going on and what the committee was seeking to get through this motion. The only thing in this that's been redacted is the telephone number, both in French and in English, because her signature at the bottom is in English first and then in French, and the phone number in both versions of the signature has been redacted. And that's it, Mr. Chair. Everything else in there is totally available. You know, we can go on and we go to the next email, an exchange between Ms. Wernick and Mr. Philip Jennings from the PCO, and in it they are discussing an attachment that Ms. Wernick has forwarded to the PCO. I know that the opposition has a lot of interest in Ms. Wernick. However, the only item here, can anybody guess it? Does anybody know? The phone number, cell phone number. The only part of this that's redacted. See, and this is what I find so fascinating, is Mr. Polyev didn't jump up to the podium there and start flashing around these papers saying, why isn't Ms. Wernick's phone number being showed to us? Why is it being redacted? Of course not, because he doesn't get the theater out of that. But that's the reality of all the documents that have been submitted. So again, she talks about the attachment being the proposal. Everything is in there, who it was sent to, when it was sent, what the PDF is called, her signature again, and then her phone number has been blacked out. So, and then again, we get to confidence, another document here. This would be the next one. We have Mr. We have another synopsis of a meeting, another cabinet scenario. And here again, it's another one of Mr. Polyev's fully blacked out documents, that he wanted to wave around. But the reality of the situation is that the parts of that are blacked out are the parts that have absolutely nothing to do with the motion that this committee had asked for. But the reason why it was important to provide all of that, including the cover sheet, including the synopsis, and having all of it, was because to the next page, the first page that becomes relevant, I should say, all of a sudden you have the part on the Canada Student Service Grant. So, this is happening time and time again in these documents where these large sections of it are being blacked out. But the reality is that the only parts that are being blacked out are the parts that are completely irrelevant to the motion. And when you do get to the parts that are relevant, then you get everything on the Canada Student Service Grant. I mean, I don't know if perhaps Mr. Polyev was hoping to get something else out of cabinet confidence that he was digging around for, and that's why he's upset that these parts of this are blacked out. But the reality is that he got exactly what he asked. The committees got exactly what they asked, and my amendment that we're speaking to right now, Mr. Chair, and the reason why I think it's so important for us to have a discussion about this and to pass this amendment is so that the people who did these redactions can come here and they can say things. They can say, excuse me while I take a sip of water here, Mr. Chair. They can say one of two things, Mr. Chair. They can come here and they can say, no, Gerritson's actually totally incorrect. All the stuff that we blacked out there was related stuff. We just didn't want you to see it. Or they can come here and do what is probably the most plausible thing that we would see, is we would see them come here and probably validate everything that myself and my colleagues have been saying today on this issue, which is that the items that were redacted were items that were completely irrelevant. and didn't have anything to do with supporting this particular motion. And so, you know, I'm sure that you know, we would end up seeing that if that's the case. I have no doubt about it. So I'm led to believe, and you know, people were saying, why am I you know, suggesting motive opposition? Well, why wouldn't you want them to come here and confirm if what I'm saying is true or not? I can't understand that. So I find it incumbent upon us to make sure that that voice is heard. You go to the next page, which is page 351 of that document, continues to go right on. The PCO comment on this particular program is in 2 bullets there, and then it blacks out the rest. And it blacks out the rest because it's completely unrelated. And you know, a really good sign of knowing that this is actually what's happening, Mr. Chair, is the fact that in these documents, which are clearly like PDF documents or some form of Word or something like that, in these documents, Mr. Chair, you're not seeing lines here and there. It's not like you're seeing paragraphs and within the paragraphs words being blacked out or sentences being blacked out. You don't see any of that in these documents. What you do see in these documents are entire sections that clearly are coming before or after sections that relate to this program and sections that relate to the request that was made by the committee to get this information. And that is a massive signal that what you're getting here is the reality of what was produced and what was, the reality of what was related back to this particular motion, the CSSG program in particular. And so, you know, and I think people should actually, you know, take note of that. Take note of the fact that in a page or two worth of relevant information, there's not a single word or phrase or sentence or paragraph that's been redacted. It's the entire portion that's related to this program. And so I just cannot wrap my head around the fact that the opposition would allow government officials who are nonpartisan, parliamentary officers who are nonpartisan, to go down with having their careers stained by the notion that they impugned upon or that they contributed to members of parliament's privilege being rejected. Or being infringed upon is perhaps a better term. You know, I just can't understand when it is so obvious that that's the case, why members of the opposition, I get why the Conservatives are doing it. I get it. They've been doing it since day one, since I arrived on the Hill. I mean, they've been like this right from the beginning. I get it. They have, I don't know, maybe they just don't have any good ideas or what it is. All they ever want to do, talk about the Prime Minister and everything that he's doing that they perceive to be some kind of scandal. They don't want to offer actual substance, but I'm shocked to see this coming from my colleagues that are from the Bloc and the NDP. You know, I've always understood, or I've always appreciated the fact that they want to stand up for the public servants that we have. And this is a glaring you know, example of how they're not doing that. So I'm at a loss for words when it comes to it, Mr. Chair, because you know, our public servants are the institution, they're the bedrock of how Parliament functions. I mean, think about it. Us politicians, we come and go. The people sitting around this table, some of us will be here after the election, some of us won't be, some of us will be gone after the election after that. But those public servants, the clerks and the people that create the bedrock for the institution to function, you know, these are the people that we're talking about here. These are the people that are being affected by this. These are the being affected by this, Mr. Mr. Chair. Are we? What's going on, Mr. Chair? Do we have are we on a conference call here too?
Yeah, just a moment. I heard somebody else coming on the line. I guess.
It was the floor audio people, Mr. Chair, and I don't know what it was, but that's who it was.
We'll go back to Mr. Garrison. I never noticed, Mr. Garrison, that you were at a loss for words, so we'll let you go again.
Thank you, because I'm only on page 28 of 151, Mr. Chair. I got a lot more to offer on this, because if nobody else is going to defend these public servants than it is, and I can do my part to do that. I'm going to do that because I think it's incredibly important. So we're back to this scenario where as I was saying before, the conference call interrupted us there. I'm just shocked. I'm shocked that the NDP and the Bloc would allow nonpartisan government officials that suggesting that they go down with this ship. I mean, I understand the political attacks, and I even understand the sport that the Conservatives get engaged in, even when it comes to personal. But it's one thing to attack it's one thing to attack parliamentarians. We're fair game. We have the stage. We have the soapbox we can stand from and defend ourselves. These, rule number one when you get in politics, Mr. Chair. Rule number one when you're an elected official. And I learned this the hard way. I will say I learned this the hard way, and I'll never forget this because I think it's really important because it goes to this issue about how we treat public servants. And that's really what my amendment is about. And I'll never forget this. I learned this the hard way. The rule number one, Mr. Chair, is you never attack or impugn motive on staff because they can't defend themselves. And I learned that the hard way. I think it was my first or second meeting when I was a city councilor, and there was a big issue, and it had just come off the election, and we, were debating this issue, and I really went after one of the city commissioners at the time, and afterwards, a gentleman who, had been involved in the community a long time. I won't name him, but he came up to me and he said, the way that you treated that staff person, you really, should never put them in that situation. And he really reamed me out over it. And in retrospect, I learned a lot from that. I learned a lot from that opportunity because I realized that we need to be better when it comes to taking care of our staff. And so at the next meeting, the first thing I did, Mr. Chair, is I raised a point of order at the beginning of the meeting. And I apologized to that staff member for what I did because it wasn't right. And in the same spirit, in the same lesson that I learned from that individual, he was a former principal of Queen's University, if I can be totally honest. I still won't name him. But the lesson that I learned that day, I continue to carry around with me to this point. And I'm not, back to Mr. Gregor's point, I'm not willing to just let this go because this is about the integrity of officials, of parliamentary officers. And I don't think it's appropriate that they're being treated this way, not being able to come and defend themselves. In the amount of time that I've spoken, just in this session, they could have defended themselves and answered some pretty quick questions about this. But of course, Conservatives don't want that. They don't want them to come and explain themselves because it'll completely discredit Mr. Poilievre's motive of trying to suggest that advanced conspiracy theories like the ones, by the way, he shares from the post-millennial. God, I mean, I can't believe Mr. Poilievre's retweeting the post-millennial. Leave it at that. It's almost as bad as when the Conservatives get up and quote the Fraser Institute as a reliable source of information. Anyways, I digress, but I go back to what I was reading here. And on page 364 of that document, again, and this is from page 364 to 380, we have the actual funding agreement between we and the Government of Canada, which was released by the PCO. And again, the professional public service redacted personal contact information. That's it. That's it. So Mr. Polyev, in all the ammunition that he's looking for, has the document titled Canada's COVID-19 Economic Response Plan, Support for Students and Recent Graduates, Funding Agreement between Her Majesty the Queen in Right of Canada, and as represented by the Minister of Employment and Social Development, herein referred to as Canada, and We Charity Foundation, herein referred to as the recipient, herein collectively referred to as the parties. This is, if there is going to be a smoking gun, Mr. Polyev, I hate to rain on your parade.
Through the chair, Mr. Garrison.
Mr. Chair, if there was ever to be a smoking gun, this is where Mr. Polyev would have found that in this document. This is the actual funding agreement. And guess what? What's redacted from this? Absolutely nothing. The private cell phone numbers and contact information of people, not even their names. It goes into the whereas clauses, the resolve clauses. It has the interpretation and definitions. It goes on to the dates and the duration. It has everything in there, Mr. Chair. Everything is in there that has the details of this plan. This is where you were going to find it. Like, this is where you were going to find it if you were going to find it anywhere. This would have been, everything that you were looking for. But unfortunately, I think that while everybody was focusing on everything else that was going on with the pandemic, and Mr. Chair, what I interpret Mr. Polyev was probably just going through this document, digging up, looking for, the smoking gun in here, and he just couldn't find it. So what did he do? He went back to these previous documents that I referenced earlier. And these are the documents where portions had been redacted out because they're completely irrelevant to the motion that this committee had passed. This contractual agreement goes on for 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11 pages before it gets to the signatory page. 11 pages, 37 parts with subparts and subparts that they could be critiquing into. Mr. Polyev and Mr. Speaker, Mr. Polyev could have been there with his staff, and I'm sure they did, just drilling into every little detail of this agreement, looking for that little part that says, so on and so forth is going to get all this money, and it's going to be great, isn't it? No, because it's just not there. He was never going to find that. And he knew it wasn't there. He looked through this. He read the agreement. They probably sat there in dismay thinking, oh, geez, what are we going to do now? We don't have, this smoking gun that we thought we had. Oh, I got an idea. Let's go back to the redacted parts that are earlier on where they redacted a whole page, and we'll say, see what they're missing out? They've taken all of everything that we had and they redacted the whole thing, everything that we were supposed to get. Meanwhile, it was parts of an Excel spreadsheet that had absolutely nothing to do with this actual motion, with the actual documents that had been requested. And if I got to be completely honest with you, Mr. Chair, until I was asked to get on this committee and to participate, I didn't even really fully understand it. And so when I start to go through these documents and I started to understand this better, and I honestly came to the conclusion myself, being a member of parliament, so somebody who's in the know, so to speak, I came to the same conclusion. I said, how is it possible that Mr. Polyev is so obsessed with this information when it's pretty clear that the parts that were redacted were completely irrelevant? And I'll bring you back to what I said earlier, Mr. Chair. If this was somehow a document where people wanted to redact portions of it for the purpose of hiding stuff, within emails and within letters, within contracts, you would have seen portions of it redacted. You would have seen sentences of it redacted. You would have seen paragraphs. You would have seen words. You don't see
any of that. It's all open and available with the exception of telephone numbers and in some cases email addresses, although a lot of email addresses were shared. Like, so you ask yourselves, Mr. Speaker, through you, or Mr. Chair, through you, the opposition asks themselves, well, why are they going on and on and on about this? Why are they intent on filibustering this? Why are they intent on making sure? Why are they intent on pushing this as hard as they can? Because the premise of what has happened here is wrong. What they're doing is they're trying to fabricate scandal where it doesn't exist. And I see a problem with that. But the more abusive problem, Mr. Chair, the more egregious issue that I have is how they're trying to implicate officers of parliament in this, how they're trying to implicate department officials in this. Like, it's one thing when the opposition goes after the personal characteristics of a member of parliament, most often or the personal relationships or whatever it is of parliament, most often the prime minister. It's one thing to do that. It's completely different ball game when you start going after the people who are there to support the institution, the people who theoretically, or in the way that our system is set up, don't care whether it's a liberal government or a conservative government. They don't care. They're there to execute what their directives are, if it's in a department, whether it comes from cabinet, their minister, or if it comes from parliament, as it was with this case. But now we're trying to implicate them in all this, and I have a huge issue with this. So when we hear people talk about, when we hear people talk about, why are the liberals holding this up? Why are the liberals spending, pushing on 12 hours? Well, I'm doing it because I don't want to see members. I don't want to see people who can't protect themselves in these scenarios go down because they're just considered collateral damage to Mr. Poilievre. I don't think it's appropriate, and I don't think it's fair. It's one thing when he and the Conservatives continually go after the Prime Minister, and they had no problem with We Charity being collateral damage as long as it served their objective. They had no problem with that. But when it comes to the independent officers of Parliament, I have a serious issue with it. So yeah, I will hold this up as much as I can. I will put the brakes on this as much as I can because I think it's and I will go to the wall for these people because they deserve it. And if the Conservatives, and much to my dismay and unfortunate reality, the NDP and the Bloc don't see that, and they're unwilling to see that they're taking these people and they're allowing these people to become collateral damage in Mr. Poilievre's quest, then that's just extremely unfortunate. But I won't let it happen. So we'll go through all this, and I'll highlight, and I will try to defend them as much as it's possible. I mean, they deserve that. They deserve that from us, as I've said in the past. I go now to page 376, Mr. Chair, and this continues on from that other document. This is Schedule A of the product, the Schedule A of the project description. So now I've gone through, I think it was 13 pages, 37 parts of that contract, plus the signatory page where everybody would print and sign their name. And then you get into Schedule A. And so Schedule A is the project description. And by the way, I should point out, and I encourage all members to do their homework and to go back and look at that entire contract that was provided by the Government House Leader's Office. Nothing was redacted in that contract, absolutely nothing. And then you get to Schedule A, and the first thing that was redacted, telephone number, then an email address, then another telephone number, and another email address. You got the names of the people who were the recipients of the project being We Charity. Their names are right there. So all you don't get is their telephone number and their email address. And again, I can't understand why people would want or see the need to have that. It talks about how We Charity will administer cash awards and facilitate the creation of volunteer opportunities. All of this open to Mr. Polyev and his, a research team back in his cave or his office, wherever it is, to go through this and find detail and to look at it and to make sure that where the smoking gun is. It's all here. It's all in this, Mr. Chair. You get to the activities of what they're supposed to be doing between June and September of 2020, and you get all the details, the bullet points of absolutely everything that's going on. Everything is in there. Then you get July to August, you get September to November, December to March of 2021. The reality is that, as I read this and I reflect on it, I think of the massive lost opportunities for students as a result of this. I think of the collateral damage that's been done in terms of allowing we to be the charity to take the heat of politically charged motives by Mr. Polyev. I think it's extremely, it's a detriment. There are kids, there are students who are worse off now because of this. And as you will see, when you finally get exactly what it is that you're after I go through all of this and put it all on the record, you'll see that none of this was anything that was offensive and that should not have been redacted for any mean. And it's all there right in the actual document for you to see. Go on to the next page, the eligibility to participate in the We Created volunteer opportunities. So here's the eligibility for the volunteer service opportunities, for the CSSG award. Everything's in there. Open, available, transparent, for members to scrutinize. There's so much information in here. Mr. Polyev and the Conservatives and the NDP, for that matter, could have taken this opportunity when they got this document to scrutinize the manner in which policy was being created to advance interests and to advance opportunities for young adults. I mean, there's so much policy in here that could have been the subject of the scrutiny, but it wasn't. And that's, what we keep coming back to. The subject of the scrutiny was, how do we make it look like they were trying to hide something so that we can better off our own political agenda from this? And that's unfortunately what happened. We go further on for, the disbursements of the Canada Student Service Grant Award. They go into the details of the lump sum and based on the and how people were going to get paid. All that is in there. The expected results. So these are the outputs that was expected from this. 40,000 eligible volunteer service opportunities gone because Mr. Polyev looked at we as an opportunity to create a political carnage that he saw upon other people. That's what he ended up getting out of this. Those opportunities gone. And unfortunately, we see other members of other opposition parties jumping on board and following suit with that. But you had the opportunity to criticize the policy of this when you got all of this, to criticize what those outputs were going to be. The NDP had the opportunity to come here and say, well, hold on, why is it only 40,000 eligible volunteer service opportunities? Shouldn't, for this kind of money, we be seeing 60,000 eligible volunteer? Why don't we do X instead of Y? Why don't we, craft this policy so that it works like this instead of that way? But no, they chose to do none of that. They chose not to engage in meaningful, productive dialogue that would be something that people could actually, that people, Canadians, that could actually benefit from. They chose nothing to that end. Even though all the information was here, I'm still going through this, and I'm still on the schedules, and I'm now looking at I'm at the signature line, where people were going to sign the acceptance of that schedule that's attached to the contract. The next page here, I'm on 394 now. So we have, this is the Finance of Canada's proposal from page 394 to 401 of the PCO release. It discusses the implementation of the Canada Student Service Grant in full and unredacted detail. I'm going to repeat that: full and implementation. It discusses the implementation of the CSSG in full and unredacted detail. This is the financial proposal. The only removal of information. Can you guess it? Can anybody guess it? I'll put this out there. Anybody at home guess what was left out from this?
Point of order.
Sorry, Peter, I was muted. Point of order, Mr. Julian.
Thank you very much, Mr. Chair. I'd like to thank Alistair McGregor, who's been doing a stellar job for the NDP. And Mr. Chair, if you could catch me up on things, what have I missed over the last few hours?
Listen, it's not up for. You'll have to look at the blues for that, Mr. Julian. It'll be probably be more accurate than my assessment would be, but. Mr. Fraser has been going extensively through some of the documents and explaining what was redacted and what was not. So back to you, Mr. Fraser.
It was Mr. Garrettson. It was actually Mr. Garrettson.
Mr. Garrettson,
I just want to say,
Mr. Garrettson, sorry.
I have two things to say to that, Mr. Chair. First of all, thank you, Mr. Julian. I usually leave it to my party to relieve me, but I appreciated the fact that you did that on my behalf. Number two, I just want to say it is a massive compliment to be confused for Mr. Fraser. And I appreciate that, Mr. Chair. That was very, very nice of you. And I actually, for Mr. Julian, for your benefit, I could start at the beginning again. Would you prefer that? No? Okay. So I'll just pick up where I left off then. So I was on page 380, and I was discussing the details in there and how it had the recipients and everybody was going to sign off on that. Then I went to the next part, and I thought that this was very, very important because this was the financial proposal specifically, the implementation of the Canada Student Service Program. And I was putting it out there. I thought somebody was going to call me on a point of order for trying to turn this into a reality TV show and getting call-in people to answer my question. I had put it out there that in the financial proposal, the implementation of the Canada Student Service Grant goes into all the details. So we got the overview, we got the proposal description, we got the costing, we got what to expect with the first 20,000 placement opportunities. We got the second cohort. We got the initial processing and administrative capacity of the program. We then go into the initial funding envelope of the grant, a total of $500 million. We go into the contingency fund of additional grants. We go into the program support costs of the program, the costing assumptions. We go into the implementation. Then we go, and it goes again within those time periods from June to July, and then from over the summer and fall, and then again the results. Then we hit the stakeholder communications and considerations. We go into lots of detail about the stakeholders that have been consulted and contributed to this. Then we get we get to the end, and guess what's blacked out, Mr. Chair? This is what I was getting at, Mr. Chair. I don't even want to make you guess because I don't want to put you on the spot. But it was a telephone number. That's right, Mr. Chair. In this entire document, and I went through every section of it, the entire document of the financial proposal, implementation of Canada Student Service Grant or Canada Student Service Program, the implementation of it and the financial impacts of it. The only part that was redacted was the phone number. And the two phone numbers of the executive director and the director. And of course, this isn't what Mr. Poilievre chose to criticize. He could have, I'm sure that he could have found something in here to, attack the government on in terms of the policy that it was attempting to create and how horrible and wrong it was. He could have done that, but I mean, that's a lot of work. That requires actually having to come up with ideas and think of different ways to do things and how to be better at things than what you're seeing people trying to do things. This is a lot of work. It's a lot easier to just grab pieces of paper where portions of them have been blacked out and you know full well why they've been blacked out. Go grab your podium and your iPhone for your Twitter clip and start waving around the pages saying, look at all the blackout that's going on here. Never minding the fact that the entire document that relates to the financial proposal and the implementation of the program is 100%, with the exception of a mere 18 digits that represent 2 phone numbers. The entire document is open and accessible and unredacted. 18 digits in that entire document have been redacted, representing 2 phone numbers. And somehow, Mr. Poilievre, Mr. Chair, joined by Mr. Julian, the Bloc, and the rest of the Conservatives are offended by that. And I just don't understand it. It's great theater, but it's completely misrepresentative of what's actually going on. And so let's get to an even more interesting document, Mr. Chair. I'm on page 402 now. And this is a very interesting document. And I think my colleagues will also find this interesting. So this is an email, and we're looking at page 404 on here of the PCO release, which there's a meeting invite to discuss the WE contract. The redaction, a conference call ID login. I mean, like, it's probably not even active anymore. I mean, those conference IDs are generated every time you come up with a new, or usually every time there's a new meeting, but somehow the government officials decided that it was important to remove the conference ID, and it became an extremely offensive point to Mr. Poilievre and to everybody else on the committee who opposes allowing the people who did that redaction to come and explain themselves. Why don't you want to hear from the person who removed the conference ID to actually explain, well, this is why I removed that ID? I just can't understand why anybody would not be interested in getting the answer to that question, unless, of course, the motive is that you're not even interested in it at all from the beginning because it doesn't serve your purpose of political carnage, is the word that Mr. Pregascatos and I have been using. It doesn't serve that purpose. So that's clearly the only reason why somebody would not want that to be public information, or sorry, would not want the public to be able to understand that information right from the people who actually did it. So I am painstakingly going to go through and make sure that their voices are heard as to why it is they chose to do that. So page 405, we get into the PCO release of pages 417 to 419. This is a cabinet confidence document stamped limited distribution. It's what we call a memorandum to the Prime Minister seeking a decision regarding this program, the Canada Student Service Grant, and other matters. As is noted in the motion from the committee, matters related to this particular program were requested, and here they have been released. So you have this document labeled secret, limited distribution, confidence of the Queen's Privy Council. I mean, I don't know about you guys, but this is the closest. I mean, I have, you know, I'm sure that Mr. Easter, who's been on cabinet, has seen a document like this before. I certainly have. Mr. Poilievre has as well. So maybe, you know, it's not a lot to him. But when I see this, I'm like, okay, this is a pretty important document, memorandum to the Prime Minister. I got to be honest, I've never seen one of these before. So what is being redacted here? Let's have a look. Oh, the only items, and there are just a few points that have been redacted. 1 point, actually, 1.5, I'd say. The only part, and everything else is available for people to read there, were items that were not related, items that were unrelated to the cabinet confidences. All of that stuff was provided. The only stuff that was redacted was the stuff that what was related to cabinet confidence. See, and this goes back to my point earlier, Mr. Chair. Mr. Poilievre didn't grab this sheet and say, hey, cabinet confidence of the Queen's Privy Council. Why has this been so widely distributed in the summary? Why are we getting all the information that they're providing here? That never happened. He didn't do that because it didn't serve his purpose. So he's blacked out. So the only items that are blacked out on here are those that are unrelated to the motion that was brought forward by this committee. Then you go to the next page, page 2, page 3. All of page 2 is available to read. You got everything in there from the Minister of Finance's decision. You go to the PCO comment, PCO comments on the issue. All of it's available. There's not a single word that's blacked out in this secret limited distribution confidence of the Queen's Privy Council, page 2. It's all right there. This is the document that the Prime Minister would have received. Page 3. Page 3. We go into this again. Again, you know, bullet after bullet after bullet of the details right there. And then there is one item that is blacked out towards the bottom. And again, the only, and you know, 95% of this, if not more, 97% of this, I'd say, just very quickly glancing at this, is totally available and to be seen. And as we've heard, the little bits that have been redacted were not germane to the motion and were not being asked in the motion. We then go to an interesting email here from the PCO. This is pages 426 to 427, an email from Ms. Roseanne McKay at PCO to one of her colleagues, Elaine Baudouin. The topic, a cabinet meeting, note for the Prime Minister, not unusual whatsoever. And does anybody out there want to guess what was being redacted? I know I'm starting to sound like a broken record, but I think we're starting to notice a pattern here, Mr. Chair. What was redacted? A public servant's cell phone number. Again, something that clearly Mr. Poilievre has taken great offense to, not being able to know that individual's cell phone number. But quite frankly, I don't think he needs to know. I don't think that anybody else around this table generally believes, with the exception of maybe Mr. Poilievre, that he needs to know. But the information, everything else in this email is right here. And this is from Roseanne McKay. She goes into detail. She says, please find the attached meeting management for tomorrow's implementation call with the PMO. They get into the details. You get to see, you know, you're really getting to see behind the curtains here, the curtain here. You're pulling it all back and you're seeing exactly what happened. You're seeing the emails flying back and forth. You're seeing the documents. I've gone through the contract. You're seeing the documents in terms of you know, what was provided from the financial impact of this. You're seeing all the emails. You've literally pulled back the curtain, and it just surprises me. I understand the motive of the Conservatives, but Mr. Julian has had the opportunity to look at this stuff too. He got it from the House Leader's office as well. He had the opportunity to see this, and yet he still thinks that government or parliament officials, it's okay for them to be collateral damage in this, to have them be strung up as the people that were responsible for breaching parliamentary privilege. It's just, the whole notion of this is absolutely foreign to me, that members of parliament would be willing to let people go down for this. And you know, I even can understand, I don't agree with it, but I can understand when it is somebody, you know, like a deputy minister, and you can say, well, you know, that deputy, you know, was really kind of somewhere on the line between the politics and the nonpartisan stuff, and you know, and you can take a position on that. I get it, because people do that all the time. People can make those judgment calls. I don't think it's the right thing to do, but I know that from time to time people do that, and I can understand not doing it, but I can understand why people jump to doing it. But what I just can't understand is that when we start accusing people, officers of parliament, legal counsel, for basically motivated out of what, I don't know, some, I guess, perceived political agenda, would jump on and start doing something like this. Because we're seeing a pattern here. And I hope if my discussion on this evening, Mr. Chair, serves any purpose, it's that we're seeing a pattern. The very first thing that you should get out of this pattern is that the vast majority of times, things that were redacted were telephone numbers. And next to that, it was information that just wasn't asked for. And the problem is, you know, perhaps there's a way around this in the future. Perhaps there isn't. I don't know. The problem is that when these documents were originally prepared, obviously nobody knew that they were going to be asked to be supplied to committee. So therefore, everything was put into one document and things were compiled together. And as a result, when this stuff is asked for and they start going through the documents and they pull out sections, well, just like a chapter doesn't always have to start on the beginning of the next page, nor does an issue. And that's what we're seeing here. We're seeing multiple issues being discussed. And when one issue is concluded, and then the next issue was the Canada Student Service Grant, then they have to redact the part before that. They have to eliminate the part before that because it wasn't asked for. And the unfortunate thing about doing it that way is it then gave ammunition to Mr. Polyev to start waving this piece of paper around saying, see, they redacted all of this because they didn't want us to see it. But in reality, it's just because the people didn't want to put a page break when they went to the next topic. That's really what this is about. This is about the fact that in a lot of these documents, there just wasn't a page break. Because if there had been a page break, then the entire, on each issue, then each issue would have been on its own page and there would have been no redaction at all. That's what this comes down to. And Mr. Julian knows this. I believe Mr. Saint-Marie knows this. I believe the majority of my colleagues from the Conservative Party know this. But for some reason, it doesn't matter to them. For some reason, Mr. Chair, the integrity of the people who did that redaction because there wasn't a page break are now somehow getting strung up on this charge that they impugned and impeded on the parliamentary privilege of members. And I take great exception to that because there wasn't a page break. That's what it comes down to, the lack of a page break, basically. If there had been page breaks, there wouldn't have had to be redactions that we saw, and Mr. Polyev would not have had his prop to wave around to everybody. That's what it comes down to. Pages 428 to 432 from the PCO. And again, we have a document with a conference ID redacted, probably not even functioning anymore, a conference ID that's been redacted, and items that are clearly not related to the CSSG, to the Canada Student Service Grant. These items were redacted by, again, the good folks at public service. But you know what I find really, and you saw this routinely throughout this document, Mr. Chair, what I found really interesting is that in most cases, if not all, they still show the title. So they show the title, and in this case, I'm on page 428. They say the status of implementation, Canada Emergency Wage Subsidy. That's all there. They have the Canada Emergency Response Benefit, CERB. They have one part in there that's not relevant, so it's been redacted. But you're still seeing all the details of the other stuff. They're still giving you the titles so that you know exactly what it is, that where and why they were redacting stuff and how stuff was not relevant. And this document goes on and on, page 429, page 430. There is a lot of information in here about the Canada Summer Jobs Program, an implementation update on that. And the comments are available for that. The Canada Emergency Commercial Rent Assistance, that's in there as well. We get to the Canada Emergency account that was set up for businesses. The Old Age Security Guaranteed Income Supplement top-up. The Regional Relief and Recovery Fund. The document goes on to page 432. Then, guess what? We got another email here. Pages 433 to 434. And this is another release from the PCO. Mr. Chair, you want to guess what's been redacted again? 9 digits. A 9-digit phone number from an individual that sent an email. That's it. Again, Mr. Poilievre has a fascination with public servants' phone numbers, and that's clearly becoming apparent to us. But nonetheless, that's all that's been redacted. And you can see that. Another email here on July the 28th regarding the week contract. Please find the email below. Social development. This is from Heather Moriarty, social development policy. It goes on. The details, the email correspondence back and forth to page 434. We get to page 435. And the redaction below in this one is, again, only appears to be an email address. It's an email address that's in of an individual that is in the CC line, the carbon copy line there, Mr. Chair. That's the only thing that's been redacted. And it goes into the details about from Mark Kilberger, his email. Hi, how's it going? Thank you for your time and your call. As we shared in our call, we are feeling confident for the launch. We currently have 10,000 WE placements, which are ready to go. If needed, we can have 15,000 WE placements, which could be ready for launch. Goes into all the details. Everything is in here. The only item that has been redacted, again, is that 9-digit phone number. Page 458. Again, we're looking at another email among public servants who are involved in the Canada Student Service Grant file. The content, again, is all visible. The redaction, the cell phone number of a public servant. That's it.
Point of order, Mr. Chair.
Point of order, Mr. Poilievre, go ahead.
The member is suggesting that all that's being redacted here is phone numbers and email addresses.
This is not a point of order, Mr. Chair. Mr. Chair, I still got a lot to say. This is not a point of order.
It's not a point of order. I'll hear Mr. Poilievre for a minute here to see if it is a point of order. Go ahead, Mr. Poilievre.
Well, I was just going to say that under the terms of the previous motion, which was adopted in accordance with the standing orders, the documents were to be turned over to the law clerk of the House of Commons. If the redactions are simply phone numbers and email addresses, then the law clerk can confirm that to be true or untrue, and make sure that nothing is released other than that which is permitted according to the original motion. So if it's just phone numbers and email addresses, then the government will just hand it over unredacted.
I think it's a matter of debate. I will go back to. It's not a point of order. It's a matter of debate. I will go back to Mr. Gerritsen, who is staying pretty relevant to the motion that's on the floor. Go ahead.
Although I would agree that that was not a point of order, I want to thank Mr. Poilievre for bringing up that very important point, because that is what this amendment is about, Mr. Poilievre. It's about letting them confirm that. It's about inviting them to this committee to allow them the opportunity to confirm that. So yeah, you're right. You weren't on a point of order, but you raised an incredibly good point, which is that congratulations. I think we're starting to get somewhere now, Mr. Poilievre, and I think that it's great. So that's what this motion, this amendment is about. It's saying let's invite them here so that they can confirm that. I'm going through detail. I know, Mr. Poilievre, that you've been following
to the law clerk.
Despite the fact that Mr. Poilievre has been changing backgrounds, I know that he's been following along with this because he will know, he will know, Mr. Chair, that I am going meticulously through these details, because where he does not see it as being his responsibility to protect the great public servants that we have, I am going to defend their case on their behalf, because he will not allow them to come here and do that. I still got a lot to go. I'm on page 68 of 151, Mr. Chair. I still have more work, more to enter in here that I think is entirely appropriate. So I'm going to continue doing that now.
You still have the floor. Go ahead.
Thank you. So just getting back to this, and I'm sorry, Mr. Poilievre, if I got under your skin there a little bit, but you will have an opportunity to respond in good time. But we got more emails here. Okay, so I'm now on the email that's on page 458. Again, okay, looking at public servants involved in Canada Student Service Grant file. The content is all visible. Mr. Poilievre, do you want to guess what's missing?
The law clerk.
Nope, it's a phone number. The 9-digit phone number that you're obsessed with getting, Mr. The only thing again here,
I just want to call the public servant and ask for the documents to be handed over in accordance with the motion. That's why I need the number.
Well, that's
because the politicians won't do it. I know the public servants will. They have the integrity that the politicians don't. So maybe what we need is a phone number. That's fair,
but it's up to that public servant to provide him the phone number, and that's the problem here. The public servant does not want you to have their phone number, Mr. Poilievre. I'm sorry if I'm the one that has to let you down on this, but it's the reality of the situation. So until you can get that phone number on your own,
I'm sure he's a terrific guy.
I'll just continue on reading on this.
Guy. And he'd probably
I know you're having a wonderful debate, guys, but it would be better to go through the chair, and you have the floor, Mr. Gerritsen.
Okay. So, the only thing again on this email from June the 11th to again this Tara Shannon, as requested, here are the responses to the technical questions on the contribution agreement. The third party has indicated they required a signed agreement by tomorrow to launch for Monday. More details about it. The only thing that's missing, the 9-digit phone number that Mr. Poilievre is so obsessed with getting. The Canada next, I'll go to page 481, and this is where we get to the Canada Student Service Grant. So this is questions and responses. Background on contribution agreements. So there is all the details. Contribution agreements are used by the government to further
Policy objectives. Under a contribution agreement, the recipient is responsible to design project activities to meet objectives and outcomes. There are some questions in there. Question 1, then there's responses. Question 2, what is the relevance on May the 5th date for page 2? So they get into all the details. Again, great stuff. You know, having an opportunity to pull back the curtain, see what's going on behind the scenes, and to make sure that you know, everything is out there and in the open, and it is. This particular document here, so let me just backtrack on my pages here. So we got page 1, which is 481, then it goes to 482, 483, 484, 485. Absolutely nothing was redacted, absolutely nothing. Now this particular document would not have served Mr. Poilievre's purpose of grandstanding in front of a podium, because there's nothing redacted on here, because nobody had to put nobody, because they did use a page break at the end of this one. Actually, this one ends with a paragraph and then there's a page break. Now, had at the bottom of page 485 there been another topic introduced here and other information completely unrelated, even though we see that you know, this is the end of this particular set of questions on the CSSG, had that been there, then there would have been an opportunity or they would have had to redact that. And then, you know, there would have been a big blacked out part on there because it wouldn't have been germane to the motion that this committee had passed. But luckily, somebody put a page break there and started on a new page, so they didn't have to redact anything that was unrelated. Going to page 486, we have an email from Craig Kilberger to Ms. Fox at the PCO. It's on pages 491 to 495 of the PCO release. The entire content and attached information from Mr. Kilberger is included. There is no redaction on content other than the names of private citizens and personal contact information, which is all relevant. Again, we are seeing the reoccurring theme, Mr. Chair, time and time again, of redactions that are done by an email address and a telephone number. And that's the only things that are being, and in some rare cases, name a first or last name of somebody, but I've only seen that once in all the documents that I have read so far. And again, this goes into the details. Like, this is from Mr. Kilberger. He goes into the details of you know, what's going on with the particular agreement. And as I said, the redacted parts are only about that personal information. When you get to the next page, they start to talk about you know, some of the programs that they're doing, some of the things that they're advocating for. You know, obviously nothing that intrigues Mr. Poilievre, but it's still very important information about what's being done for young folks in our country. It goes on to talk about their global development commitment, WE board of directors, HR recruitment, transparency and human resources, diversity and inclusion training. You know, again, Mr. Chair, all great things. 100% of this is intact and has not had a single letter redacted. And everything is here for scrutiny, for the conservatives to fall over and dig deep into the details. But of course, they didn't find anything because there was nothing to find. But yet they want to somehow suggest that it is up to the you know, somehow we can find people that work for Parliament, officers of Parliament, to be individuals who have contributed to the breach of a parliamentary privilege, which again is so unfortunate. So I turn your attention now, Mr. Chair, to some of the documents. I'm sorry, Mr. Chair, I just realized I've been talking for a really long time. There might be somebody else who wants to get in here. Why don't I have a page break, and maybe I will pause right now, Mr. Chair,
because I was about to get into documents from the Finance Committee. I'm about halfway through, so why don't I take a break right now, and then if necessary, I'll come back to start talking about those afterwards. But I don't want to leave you with any cliffhangers or anything, but I have a feeling that we're going to see more redacted phone numbers, okay? And when we get to that point, I want you to remember that I warned you of this in advance and that this was a reoccurring theme. Thank you, Mr. Chair.
Okay.
Point of order.
Point
of order. I
who-
just was
who's,
wondering, Tamara.
Yes, Ms. Jensen.
Sorry.
Ms. Jensen.
Yeah, I was just wondering. We had talked about repetition, and I'm wondering, is it possible that we stop being repetitious?
Oh, on that point of order. Nothing I've said. I have not repeated anything. These are individual emails every single time that are not related, and I've been referencing the page numbers so everybody can follow along and they know exactly the emails that I'm discussing.
I thought I would try because it is really repetitious, but
Mr.
by
Chair,
all means,
He is going through the pages. So if anyone wants to follow along, pull up the documents and they'll have the pages. I have on my list Mr. Fraser next, and Mr. Vaughn. And did I see Mr. Fragascatis? Did I see your hand go up?
I'm glad to go in that order.
I think I have Mr. Fraser first, so we'll go there. And Mr. Badaways is up as well. Okay. Mr. Fraser, Mr. Fraser, you're first.
Thank you, Mr. Chair. And look, I do have remarks ready to go. I think we have been carrying on for quite some time, so perhaps I'll give the committee an opportunity to wrap things up before I get into my remarks. So, Mr. Chair, I move that we do now adjourn.
Okay, you moved that we adjourn. We'll see if we've got the will of the committee to adjourn. And go.
Sure.
Yeah, go ahead.
Yeah, I believe that motion to adjourn is a debatable motion, and at least I'd like to have a word.
Mr. Chair, let's call the question.
No, you can't just shut the thing down.
If
I may, Mr.
Point of
Chair,
order. It is not debatable, Mr. Chair.
Mr. Chair.
Just
Mr. Chair,
hold on.
Point of order. Point of order.
Just wait till I make my point before you make your point of order. To adjourn, we have to have the will of the committee, so we have to have the majority.
Point of order.
So that's that. What's your point of order?
Yes, Mr. Chair. According to standing orders, the matter needs to be treated before the meeting is adjourned. It's clear that through this marathon speech session that has gone on now 12 hours, that the Liberals on this committee have something to hide. There's obviously bombshells in these.
This is not a point of order, Mr. Chair. This is not a point of order. This is not a point of order. This is not a point of order. This is not a point of order.
All of them. All of them.
Shouting not a point of order.
Point of
it's like a chorus.
Order.
Mr. Polyev, this is not a point.
It's not a point of order, so I am going to
we get some
take a
terrified
Mr. Chair, if you can't get him in order, you're going to have to suspend this meeting if you can't get him in order.
Mr. Polyev.
Now he wants to suspend the meeting.
I don't, but if you're going to be out of order like this.
Protest too much.
I do not want to suspend. I still got 76 pages to go through.
Okay.
I don't want to suspend.
Gentlemen, it's not a point of order. We will poll the committee to see if there is the will to adjourn.
Point of order, Mr. Chair.
And is this a point of order this time?
It is indeed.
Let's hear it and we'll see.
Based on the standing orders, it is clear you cannot use an adjournment to cover up a political scandal.
That's not a point of order. You had me that time. I was rooting for you that time, Pierre.
I'm not sure who is the clerk, Madam Clerk.
Can Sergeant at Arms go over there and settle him down?
Would you?
A point of order.
Would you poll the committee to see if we've got the will of the majority to adjourn?
You would like me to ask for recorded division?
Well, this is clearly a cover-up. They're going to shut down the meeting instead of allowing the meeting to go ahead.
That's not a point of order, and the clerk is in the process of polling the committee to see if there's an adjournment
as members
agreement.
of the committee that can vote are the following: Mr. Fraser, Ms. Jerowich, Mr. Fragiskatos, Mr. Vaughn.
Mr. Vaughn.
No, sorry, Mr. Gerritsen is still on. Mr. Badaway, Mr. Poliev, Mr. Nader, Ms. Jansen, Ms. McLeod, Mr. Sainte-Marie, and Mr. Julian. Is this list correct?
Yep.
Okay.
Mr. Julian is there. Okay, that's, you got the names right. Go ahead.
Mr. Fraser.
And sorry, the motion is, as I said, to adjourn. In favor.
Ms. Jerowitz.
In favor.
Mr. Fragiskatos.
In favor.
Mr. Gerritsen.
Okay, yes.
Mr. Badaway.
Yes.
Mr. Poliev.
No.
Mr. Nader.
No.
Ms. Jansen.
No.
Ms. McLeod.
No.
Monsieur Sainte-Marie.
Oui.
Mr. Julian.
No.
Mr. Chair, we have 6 yeas and 5 nays.
Okay, meeting adjourned, and if we go to the call of the chair, we will reestablish the meeting tomorrow at 11. Meeting adjourned.